Number 42, the request of the council for the appointment list after vacation. After vacation.
My lord, serial number
today or after vacation?
Serial number 4.
Wait.
Yeah.
Lawyers and the VC, please wait. I thought merits will argue on Madi. If there is a case, we'll admit Either you argue today or after vacation. The request of the council for the appointment list after vacation. It is listed for admission only. What is that you want? You want to comply the office objections? Well, just come up for admission. Be happy, isn't it? The request of the council for appointment just after vacation. After vacation. After vacation. Meanwhile, the council for the appointment is permitted to comply the office objections.
For reporting of settlement, other side is not willing to come at all. That's why told me that he is refusing to come.
Other side in there.
Okay, sir.
Only no.
Okay.
Please reach out the worker. Let us find out. Yes. I vote or move, madam. Say number. That may not even reach, madam. I don't think we can take it up. Anyway, please wait. Yes, Mr. Umesh.
My lord, serial number 4. We have to report the settlement. Kindly fix on Monday, my lord. ಅಲ್ಲಿ ಮುಗಿದಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ FDP ಸೆಟಲ್ ಆಗಿದೆ ಅಂತ ಅಂಡರ್ ದೇರ್ ಸಿಗ್ನೇಚರ್ ಅಂಡ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಕಾಪಿ ವಿಲ್ ರಿಪೋರ್ಟ್
We will record your statement and close this appeal.
ಇಲ್ಲ ಅಂಡರ್ ದೇರ್ ಸಿಗ್ನೇಚರ್ ಆಗಿದೆ ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್
ನಂಬರ್ ಲಿಯನ್ ಹೇಳಿ FDP ನಂಬರ್ ಲಿಯನ್
ಸೆಟಲ್ಮೆಂಟ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಬಟ್ ಸೆಟಲ್ ಆಗಿದೆ ಅಂತಂದ್ರೆ
FDP number kodi in view of the settlement in FDP, this appeal stands disposed of on the Mudita. Whatever settlement.
Under their signature, Agide, we could not proceed further, my lord. Monday report.
Dispose it on this.
Monday.
No, it's all. Mr. Kulkarni, any request for adjournment?
My lord, the serial number 61, my lord. My lord, I am ready, my lord. Last time when the matter was posted, the other side advocate wanted to know whether there is possibility of a settlement. I have contacted my client, my lord, and I have been
settlement ready is there. Yes, settlement ready. I think please argue, madam. 2006 no adjournment. Sorry. Please argue.
Yes, ma'am. Yes, ma'am.
2006 it will not be adjourned.
Yes,
please go on with the.
Yes, ma'am.
Next, Karim. Mr. Ravi B. Patil.
Lordship, appearing for the petitioner, Lordship. Lordship, this honorable court on 30th September 2021 disposed the WP, Lordship. Issued a direction to the first respondent, Lordship, to grant permission to the petitioner number 2 college for the academic year 2019 and 20, Lordship. The Lordship, in view of change of laws, Lordship.
What is change of law?
The Lordship, second respondent has authority to grant the permission to the petitioner number 2 college, Lordship. Section 3, subsection 1, Lordship.
Madam, please tell me, as on the date when the writ petition was disposed of, who was responsible to give the permission?
Your Lordship, second respondent, Lordship. This Honorable Court issued a direction to the first respondent, Lordship. Though, Lordship, I have intimated the order of the first respondent, Lordship. The first respondent issued a correspondence on 13/12/2021, Lordship, intimating regard the authority of the second respondent, Lordship.
Where is that?
So, Lordship, I have
Where is
enclosed
that?
the correspondence, Lordship, along with my application dated 13/12/2021, Lordship.
Hmm. But whereas the respondent number 2 say that they will not consider this direction.
In this correspondence, Lordship, the first respondent stated that he has no authority to grant the permission to the
Now, where
petitioner.
does the respond?
Police, Lordship. In view of change of law, Lordship, section
Where does
3 of subsection 1, Lordship, constituted a Central Council of Medicine, Indian Medicine, Lordship.
That is when, from what date? CCIM.
So, yes, Lordship.
That is from what date?
Lordship, the first respondent in his correspondence has
From what date the respondent number 2 shall consider your case? When did the law undergo a change?
Lordship,
The counsel for the petition has filed IA 1 of 22 for clarification. However, the counsel for the petition is unable to clarify when the respondent number 2 is authorized. From what date the respondent number 2 is authorized to consider the case of the petitioner? Means just after vacation.
so, Lordship, it may be taken on tomorrow, Lordship. I will clarify it, Lordship.
And take your time, leisurely clarify.
Lordship,
You
Lordship,
cannot take it
this
at
is
your-
the Lordship.
You should come
Exams are
prepared,
going. The Lordship, exams are going on, Lordship.
madam.
The Lordship, it may be taken on tomorrow, Lordship. Will clarify the date, Lordship.
Sorry, madam.
Lordship, it may be
Yes,
taken
Mr.
up tomorrow.
Subhash. Huh? Settlement ಆಗಿದೆ. The office note with respect to ranking of the results of this is on. This who appears, Mr. Subhash Shastri. What is the IA 1 of 20? What application was allowed?
Filed by the applicant under order 41 seeking permission to give additional evidence of the RS. This application was allowed on 4/2019 by an
During the respondent votes, we filed this application mainly on the ground that the question of
IA 2 of 2007 is filed at order 41/27. Is that a fact? Huh? So somebody else has appeared, isn't it? Mr. Rajshekhar. Leon Rajshekhar, yes, and Sri Rajshekhar. Office is directed to show the name of Mr. D.R. Ravishankar as the counsel for appellant to P, 2A, 2B, and 2C. The cause list. What about A1? Appellant number 1. He is dead. It is stated that the appellant number 1 has expired. Yes. Consequently, the counsel representing the appellant number 1 can no longer represent appellant number 1. Office is therefore directed to delete the name of the counsel for the appellant number 1 and show the name of Mr. D.R. Ravishankar as the counsel for appellant to see the cause list. This what about this IA 1 of 20? This next week. In the office of what is this office objection? Prayer not sought for consideration of delay in filing the recalling application. Question delay. What is the delay? How many days? Well, IA 2 of 14 the appeal was dismissed on 2020. 2 of what 21? The 2 of 21 is filed to recall the order dated 6/2/2020. Delay caution for not complying. The objections, office objections. Last day will be. This is the caution for not appearing on 6/2/2020 is accepted. Consequently, the office objections on IA 2 of 21 is overruled. In view of the above, the order dated 6/2/2020 is recalled and the appeal is restored to file. This is the appeal for office of Partition. Office is directed to show the name of the learned counsel for the appellant as M.N. Madhusudana instead of M.H. Madhusudana. Yes. List for admission. The counsel for the appellant undertakes to file an application to bring the legal representatives of the deceased appellant to the course of the day. In view of the submission, 1 week time is granted to enable the appellant to enable the learned counsel for the appellant to file necessary application. Yes.
Well, I'm for the FDP 12 of 2001.
Learned counsel for the appellant and respondent submits that the parties have entered into a settlement which is reported in FDP 12 of 21.
12 of 2001.
2001 before the
on the file of Principal Civil Judge Junior Division. Shuvamogga.
Municipal Union Division, Shumaka. Stop in that way of the matter, comma, this appeal is disposed of in view of the settlement arrived at in FDP number so and so. Yes.
Number 5, Corona Bellary, P.I. Hare Krishna.
Memo is filed by the learned counsel for the appellant. Memo is filed with the learned counsel for the appellant. Withdraw the appeal as the dispute is settled between the parties. Stop. In view of the memo, the appeal is dismissed as withdrawn. Office is directed to refund the court fee according to law. Yes. R4. Now correct. What means? The legal counsel for the appellant submits that the name of the husband, the name of the husband of respondent number 4 is Subramanya. But Suryanarayan charge is there. You also mentioned it as Suryanarayan.
First appellate court is wrong.
Who is Suryanarayan Achari. That his name is wrongly mentioned as Subramanya Achari before the first appellate court in RA 1 of 2016. View of the aforesaid submission, the name of the husband of the respondent number 4 as shown in the first state is accepted. Is the appeal for admission if all other office objections are complete.
One more number 6 is the Nagarajari. It's a son of it's mentioned as a daughter of in the trial court.
R4 month
R4
the office objection raised is only regarding discrepancy in the husband's name of respondent number 4. R6 to be
one more Respond number 6 is Nagarajari.
I don't see any office objections in respect of respondent number 6.
Number 6. First appellate court it's mentioned as daughter of.
Mr. Court is mentioned as
Daughter of actually son of
the office objection raised regarding respondent number 6 is overruled. It's the appeal for admission if all other office objections are complete.
Nagarajari.
2 weeks. The learned counsel for the appellant has in view of the memo, just as with whatever this fine, learned counsel for the to pay the cost of this finder to the High Court committee in the course of the day. Such submission is placed on it. What about sorry? View of the appellants are permitted session before the first appellate court for recalling the 2 weeks. 2 weeks.
9,
My lords,
1 week time to comply the office.
my lords, am I audible?
Yes, you are audible, but what is that you want?
My lords, I appear in item number 8, my lords. Mr. Jain is leading me in the matter. I am seeking for a humble passover, my lords.
No, Mr. The office objections are not complied. We have granted 2
No,
weeks time.
no, my lords, some important submissions have to be made, my lords, pertaining to the agency in the matter.
All
My
right,
lords, may
unless
please
you
be,
complete the office objections, we cannot take it up. Please comply
No.
the office.
my lords, the office objections are something which can be overlooked by this honorable court, my lords. The submissions are made to be important, my lords. They are very important in nature.
All right.
My lords, may please grant me a passover.
Sir, unless you complete, we cannot take it up. You take 1 day's time to complete, take it tomorrow.
My
You
lords,
complete, well, no, unless without complaints of office objections, we will not take it up. It's not
My lords,
court.
my lords, the advocate has to make some
Office
important
objections
submissions
first.
regarding the same, my lords, regarding the objections itself, my lords.
Sorry, please don't interfere with the court proceedings. Comply the office objections, move the matter tomorrow, we'll take it up tomorrow. Next.
Oblige, my lords.
Friend number 1, friend number 2 and 3, my lord, and original suit, my lord, they are Telecast, Kumbar, number the part, page number 16. Kumbar Nagarajan. Arya, my lord, page number 23, there's Kumar the part Nagarajan.
Office objection raised regarding the discrepancy respondent number 2 and sorry. Respondent number 2 and 3. The overall is there. If all other office objections are applied. 2 weeks. Weeks. Just after service of notice to respondent. Huh? 14. Just after service of notice in the respondent. Interim order granted earlier is extended to the next week. 2 weeks. Huh?
Subjects in it. What we already paid, whatever we are paid to the same court, I will pay. Same objection as well.
Read the explanation to the office.
I want to give you an explanation in the office. Memorandum of appeal benefits have been paid. What
There are some other office objections.
immediately after that.
It says any proof regarding the court fees paid in the first appeal. The FTP order sheet to be filed along with IA. Court fee paid before the first appeal court to be stated valuation paragraph.
Yes.
Counsel for the appearance substance is complete the office objections. Office to check and verify if office object is the appeal for admission. Let him do it, sir. You complete demarcation one in the lagata. Please check see if office objections are complete, list to tomorrow. Correct? It's 2 weeks.
That is the updates. Only
So if you complied it, let the office verify.
your clarification for hearing it. Even number 2 and 3 was right, but it's not given it. Already, first update code of position. And see, page number 20. There number total stated appeal number 1 is expired on the
So what are the office
that
objections?
is only observation. Remaining observations we have. Remaining observations only
Non-complaints of office objections for the second time. defendants have died. How can you bring the legal representatives on the car?
Already, both the defendant was right. First of all, I put one defendant was related. Second,
You all right? Defendant number? Imran Khan.
Defendant number 1.
What about defendant number 2?
Defendant number 2 in already. Defendant number 3 was late. Who is recording? Who is now is there? E1 and D3 was there.
D1 and D3.
Yeah, yes. D1 and D3 was there.
What about D4?
D4 is already in court.
D4
D4 is applied number 2. I3.
So what is the office objection? No.
That is only a remaining officer.
That is the only, Mr. What is the office objection? That is the office objection. You should tell in which language you can understand. I can
clarify as to who is related to the first object. Deletion of property details not or a loss. Any officer.
please mention that this Ehsanullah Khan is expired. Mention that. Belief is expired.
Call it.
You give the details, a footnote on the body. Mr. So-and-so is expired, therefore they are not arrayed as parties. You can't meet that office objection, is it? Footnote, Barcode, please put a footnote below the cost title and say that so-and-so is expired. Please comply the office of
degree.
Only time granted to comply the office objections. Office is directed to list the appeal after all office objections are complied.
Lord, I appear for the appellant in this case, my lord. I pray for a week's time, my lord, to file objection to the application, my lord, seeking direction, my lord.
Yes.
I pray for a week's accommodation, my lord, to file
I am for
objection
the
to the
respondent,
application.
my lord. I have filed an application seeking direction to the trial court to draw the final decree in respect of Schedule A and C property, my lord. Because there is no dispute with regard to those properties. It is an admitted fact that those are the joint family properties. Only dispute is with regard to Schedule B property, my lord.
No, my lord.
But how can there be a division? How can there be a division? He has to take into account the value of the property.
Yes. But since it is a decade-old,
In fact, IA cannot be considered, my lord. The entire finding of the trial court is under challenge in this appeal, my lord. The appeal is already admitted. Immediately after the vacation, my lord, the matter may be posted for final hearing. We will argue the matter, my lord. Paper books are also filed, my lord.
it is a decade-old.
Here 2 of 21 is filed for a direction to draw final decree in respect of the Schedule A property.
A and C, ma'am.
A and C properties. As the appellant is interested only in the B schedule property.
B. According to me, it is self-acquired property.
The appeal is admitted to consider substantial questions of law. The decree cannot be implemented in respect of the Schedule A and C property unless these questions are answered. Hence, IA 2 of 2021 is rejected. This is the appeal for final hearing as per seniority. IA 1 of 19 is allowed. This is the appeal for final hearing as per seniority. Same order. Issue notice on IA 1 of 13. Issue notice on IA 1 of 13, 2 of 22. Yes. It will come up, Mr. There are older matters, can't help it.
Appearing for R2 and 3, my lord. Presence may be noted.
Counsel for, what is this, IA 1 of 22? For early hearing. IA 1 of 22 is allowed, this is the appeal for final hearing as per seniority. Counsel for the appellant undertakes to amend the cast title during the course of the day. If the cast title is amended, office is directed to verify. Please stop. Yes. The IA 1 of 15 is filed for condemnation of delay of 211 days in filing the appeal. This application is not opposed by the respondent. The cost shown for the delay of 211 days is accepted. Hence, IA 1 of 2015 is allowed. This is the appeal for admission. Let it come for admission. You can say that. Yes. Issue notice on IA 1 of 15. Issue notice on IA 21. 1 of 21. Same order. Same order. 1 of IA 2 of 21 is filed for recalling the order dated 26/8/2021. The cost shown for recalling the order dated 26/8/2021 is accepted. This order dated 26/8/2021 is recalled.
So I am for the appellant, my lord, in this case, my lord.
What was the order earlier?
My lord, the dismissed for non-prosecution, my lord, on that day, my lord.
Yes, how much cost will you pay?
My lord, please, my lord.
Recall subject to payment of cost of rupees 1,000 payable to the High Court Legal Services.
Yes,
1,000 rupees cost.
please, my lord.
What is this recalling the order dated 17/11?
Serial number for R4, my lord.
But this expedition is dismissed as abated. So why do you file an application for recalling? Issue notice on IA. Issue notice on IA 2 of 2021. So where have the served? R3A and B. IA 2 of 2021 is filed for condonation of delay of 1,965 days filing the application to bring the legal representatives of deceased respondent number 3. Though the notice of this application was served on the respondents, the representatives of R3A.
R4, my lord. Appearing on behalf of counsel for R4, my lord.
Yes.
Counsel
Yes,
pays for
madam.
time,
Please
my
go
lord.
on. Please go on. What is
Counsel is unwell, my lord. She is hospitalized. Pray for time to file objections, my lord.
Please wait. Yet they are not opposed the said application. The caution for the delay in filing the application to bring the legal representatives is accepted. Hence, IA 2 of 2021 is allowed. Consequently, the abatement of the appeal, abatement of the expedition as against the legal representatives of deceased respondent number 3 is set aside. Consequently, the legal representatives of R3 are ordered to be brought on record. Counsel for the appellant is directed to amend the cost rate. This is the appeal for Hearing, final hearing after the cost title is amended. Yes. Put it well, put it not. Yes, next. Mr. R. Chandrana. Mr. Balakrishna Shastri. Mr. R. Chandrana, Mr. Balakrishna Shastri. There is no representation for the appellant and respondent. Is R. Chandrana. Then you please argue the matter. Ready? Argument my 2003 appeal. Ready? Sir, 2003 appeal in a Swalpandri name, sir. How many more years you want the litigant to suffer? This tomorrow is the last chance. Final hearing nale. There is no representation for the counsel for the respondent. Number 2. List of the learned counsel for the appellant submits that there are no possibilities of a settlement. Please list the appeal for final hearing tomorrow. Mr. Narayan sir.
For the appellant, my lord.
For respondent, my lord.
This matter, after hearing for some time, your lordship observed that 2/3, 1/3 share that proposal. My clients are agreeable to have the 2/3 and for them 1/3. Now, Mr. Mohan was, I think he's on the line.
I'm online.
Yes, yes, he was talking to the clients and there was some discussion. He said, "I am agreeable that way. Otherwise, under 53, I am entitled to continue." That's the position of the case. After hearing, your lordship suggested some possibility of suggestion. We talked about it. Then 1/3 I have already having. Regarding the 2/3, half of that is 1/3 to me, 1/3 to them. So I will have 2/3, they will have 1/3. That was a proposal. I made my made my clients agree.
No. Half of 1/3, sir. Half of 1/3 plus your 1/3 will become half of the property.
Illa, hagalla. Your lordship, the purchase is 1/3, 1/3 each. So that there is no dispute at all. The dispute is regarding 2/3. Adanna ಅರ್ಧ ಮಾಡಿ ಅಂತ ನಾವು ಹೇಳಿದ್ದು. ಅಂದ್ರೆ 1/3 ನಂದು ಇದೆ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೇ ನನ್ನ 1/3. Remaining 2/3 ಗೆ dispute. Remaining 2/3 ಅನ್ನ half of ಮಾಡಿ ಅಂತ ಅಂದ್ರೆ 1/3, 1/3. So I will get 2/3, he will get 1/3. That is the position. I made them agree. Otherwise, it is not possible because I paid entire sale amount to them regarding their share. But there was no registered document. That is why you are having possession without title. That's why this is the position.
Correct. This is settlement. You please report a settlement. Otherwise, you please argue.
I have spoken to my parties, my lord. What they say is, I am entitled. Actually, there is 10 acres, my lord. 5 acres plus 5 acres. So of which 1/3 has already been purchased by the petitioner here in my lord. I mean the appellant, my lord. So actually, I was entitled for 2/3. That is roughly around 6.5 acres, my lord. My client is ready to concede 1.5 lakh, and they say that we are ready to take 5 acres and give 1.5 acres to them, so that it will become 5 acres for both of them, my lord. That is what they have said.
Is that acceptable to you, Mr. Y.K. Narayan Sharma?
No, it is not acceptable, my lord. The simple reason is this. Simple reason is this, my lord. A portion of it is already acquired, and they are not sure as to what is the extent acquired and what is the possession available. So dividing on the basis of
that is acquired, whatever portion that is acquired, it will be deducted.
Yes, ma'am.
And whatever remains,
then 5 acres will not be available.
No, 5 acres will not be available, but whatever
then how can
remains,
you say 5 acres? That's why I told my learner friend. That's why I told my learner friend that it's only 1/3, 2/3. If it is agreeable, that could be done because the extent is not known to each of us. They also do not know. That is why I said 2/3, 1/3 will be proper, and FDP proceedings allow ಬೇಕಾದಾಗ 2/3, 1/3 ಮಾಡ್ಕೊಳ್ಳಿ. And even in the compensation also 1/3, 2/3. That is the best way. I also thought of it practically, and if it is possible. Otherwise, I have to argue the matter. Sorry, ಆಯ್ತು ಅಂತ ಹೇಳಿದೆ.
There's no settlement, there's no common ground. Please argue.
My lord, one submission, my lord.
I am ready to argue it, my lord.
One submission, my lord.
I'll pass it forward. Yes, Mr. Mohan.
My lord, one submission. Actually, my parties, they went and saw the factual position. Half acre has been taken over by sewage board, my lord, and the compensation has been deposited in the bank, allowing the bank to disperse whoever, whatever the outcome of this case, my lord. Another half acre has been encroached by one of the neighbor. It is less than half acre, my lord. They said around 10 feet.
even for argument's sake, if we say that 1 acre is not in their position, 9 acres remains, my lord. So if it cannot be demarked on acre basis, at least it can be on percentage basis, whatever the actual position is there in the with the appellant, my lord. In that, it could be 50-50, or even I'm ready to take 45%, my lord.
Are you trying to ask me to mediate? You people
No, my
should
lord,
settle. No, you people should settle and report a settlement. The way you are putting it to me,
no, what is happening,
it's
my lord,
virtually
is
asking whether I can mediate.
no, my lord, what is happening is the legal representatives, there are 10s in number, my lord. It is just like putting all the frogs in one basket. So unless the court, if it then intervenes, it would be easy to convince, my lord.
The court cannot either this way or the court cannot have put something that you people are not willing to accept. Either you argue the appeal and you get an order on merits. I cannot impose some compromise on you.
I am ready to
the court
concede 1.5
impose
acres, my lord. I was entitled for roughly 6.5.
Argue then. I'll pass it over. Pass over. Please argue.
Yes,
we'll take it up after the admission.
Oblige, oblige.
You know, 31.
Now, what I am suggesting, with your lordship's kind permission, if my learned friend can, because he, as he says, half acres is, we are not sure whether half or more. Some portion acquired, some portion encroached. What my learned friend says. My client also says that they are not sure about the extent. So instead of the extent, I said percentage 1/3, 2/3. That then what is lost also 1/3, 2/3. What is available also 1/3, 2/3. Compensation
Don't
also.
put
That
it to me.
No, that's why. That is why. No, I am
requesting. The other side.
I am requesting.
Let them decide.
No, I am requesting my learned friend through this saying that let him convince those people, because we are not sure, both of us not sure about the extent available. That is why 1/3, 2/3 is the best way.
Sir, we will have 45 and 65, sir. I will have 45, sir, and you have 55, sir. I will have only 45%. You have 55, sir.
ಇಲ್ಲ ಅದು ನಾನು ಒಪ್ಪಕ್ಕಾಗೋದಿಲ್ಲ. I have to put it to my client. 1/3, 2/3 ಮೊನ್ನೆ ಮಾತಾಡಿದ್ದು ನಾನು ಅದನ್ನು ಒಪ್ಪಿಸಿದೆ. Because some of them are not agreeable. ಎರಡು ಕಡೆನೂ 10 ಜನ ಇದ್ದಾರೆ. I made them agree 1/3, 2/3 ಅಂತ. ಇಲ್ಲದ್ರೆ because I purchased the entire thing. Now I am giving 1/3 back without even compensation. 1/3 back.
Please argue. Please argue. Yes, next. Yeah. Yes, I will. The file compromise petition joint member. Madam, when there's a settlement, you should settle it as quickly as possible.
From the appellant, they are going to purchase our land as well. That still has to be discussed. So once that is done, finally.
The last chance list on 13th. Yes.
Connected appeals with originally, good hearing OS number 102 of 1984 was filed by the appellant hearing seeking declaration in respect of 2 acres 2 gundas of land with survey number 106/2 and for a relief of question in respect of 25 gundas on the eastern side of the social property from the respondent number 1. During the pendency of the suit, the respondent number 1 filed OS number 520 of 1989 seeking declaration and permanent injunction, claiming that he is owner in respect of land bearing survey number 106/2 measuring to an extent of 1 acre 10 meters. In fact, he claims in the written statement in my suit as well as in his suit that he is the owner he has purchased land bearing survey number 106/3P. He claims that he has purchased the land bearing survey number 106/3P measuring 1 acre 10 guntas. My land is survey number 106/2 measuring to an extent of 2 acres 2 guntas.
What is it? Concurrent finding.
What's concurrent finding? In spite of the fact that there is discrepancy in the survey number, both the courts have found the rights of the respondent number 1 and declared that the respondent number 1 is the owner of survey number 106.2, which is owned by the appellant hearing.
Did the respondent number 1 purchase this property?
But he purchased year 1984. My side did my father acquired this institutional property on 6/5/1948.
Your father has purchased this for 1948.
Yes,
What is the survey number shown there?
survey number is 106.2, measuring to an extent of 2 acres 5 gunters.
It is mentioned as 106.2.
106.2. Specifically it is mentioned. And is the said deed where the respondent number 1 claims specifically mentioned as 106/3P, measuring to an extent of 1 acre 10 gunters, which is dated 3/3/1981.
There was a declaration given in respect of 106.2.
106. However, both the learned trial judge come to the conclusion that the survey number was wrongly mentioned in the said deed of the respondent number 1. And on the basis of the boundaries, the trial court has come to the conclusion that he is the owner of 106.2. In fact, these boundaries also do not match. He had set up a.
But what about the extent? Do you say it is 2 acres?
2 acres. He had purchased an extent of 2 acres 5 gunters. He claims that he has purchased an extent of 1 acre 10 gunters.
The office director to security LCR.
My lord, my lord, I appear for the respondents.
Year 1 of 2022 is filed. The applicants come on record as the legal representatives. What is this A5 to A9?
In the appeal, some of the appellants were allowed. Therefore, office raised objection. The hearing, I have filed impleading application to implead another image Somya Rani Gaurama. For example, only some of the appellants. But therefore, office raised objection. Thereafter, I have filed this application to implement to come on record as appellants.
Who are they?
They are the different sons and daughters of Raja. They are the family members. Ingrajamma, wife of Rajagoda, Jayamma, Rajagoda, Santama, Rajagoda.
People are not challenging the order passed to the trial court.
Some of the family members challenged.
Who are some of the family members?
Ariya 76 of Ingrajamma. That is different number 2. It is wrongly taken as Ingrajamma. Before the court, then Jayamma, that of Rajagoda. Then Shantamma. These people only alone find others, they are the family members.
Shantamma is dead.
Yes, Shantamma is dead. Their LRs are brought on record.
But these LRs did not challenge the order passed to the trial court. They have challenged the judgment of the trial court. How can you file it here? How can you file it here? Respondent I implead ಮಾಡಿ ಅಷ್ಟೇ. Implead them as respondents. Year 1 of 22 is filed by the applicants to come on record as appellant number 5 to 9. Next para. It is seen that these applicants were arrayed as the legal representatives of deceased defendant number 4 before the trial court. OS number 147 of 2003. So these applicants did not challenge the judgment and decree of the trial court before the first appellation. Without doing so, they have filed an application. This regular second appeal to come on record as appellants. So if the applicants have failed to challenge the judgment and decree of the trial court, they cannot assail the said judgment and decree in this regular second appeal by short circuiting the appeal remedy under section 96 of the Code of Civil Procedure. In that way of the matter, IA 1 of 2022 is rejected. It is open for the appellants to file appropriate application to bring said applicants as respondents in this appeal. This argument is admission argument. Ready will not hold on, you know, I can only pass it to you. Don't ever make. Don't ever see you have moved this moved a memo and got the matter listed. Huh?
Is moved by respondent counsel.
Really? Password togoli. Password martin.
Tomorrow morning.
Not tomorrow, sir. Either Passover or today.
In this case, plaintiffs.
Yes.
They are claiming, the plaintiffs are claiming to be the point matter of Rajago. Is the specific contention of the appellants that they are not the wife and children of the Rajago. And no single material has been brought out before the trial court to prove the marriage. All burden was put on the defendants.
Suit for what?
Suit for partition and separate question.
Please go through the file. Suit is filed for what? Maintenance.
Maintenance and also partition. To create charge over the property, namely over the share of the to declare the second as part one fourth share in the first preliminary decree for partition separate question. 1/4 share of second
What happened to this?
Suit is decreed. Against which we filed appeal. Appeal came to be dismissed.
What is the nature of decree? Password.
Decree granting decree, so. Right, the declared plaintiffs are entitled to have equal share by means and bounds in the future property. Bearing number survey number 62 and survey number 19 acres. Survey number 3 by 3 measuring 1 acre 7 acres. And the legal heirs of Rangagowda are entitled for respect.
So therefore, shall do Somyas. Plaintiff number 2 is also Somya.
How do Somya and how Somya?
You half of correct idea.
Now, we have our contention is that Rajagowda is not at all married. They are not the orphan children. In order to prove that Melada, they have not placed any material regard to the celebration of the marriage.
Who are the witnesses?
Witnesses, some of the villagers. They stated that they were, we have seen that they were living together.
Can you work on that witness?
Just because according to us, we never lived with them. It is created, the entire burden put on the defendants. Whole burden was shifted to the defendants. But it is well settled principle, when the marriage is stated, it is the bounden duty of the plaintiff to establish the marriage or full marriage in accordance with the under the Hindu Marriage Act.
Please come to paragraph page number 36. You're ready or not ready? You're ready. Then keep quiet. You're ready, you please ask. Last paragraph.
We have to about this time. No doubt the present case, the marriage invitation is not produced. But also not clear what type of marriage decision may be in the first time or the first time. But those, but putting up the lengthy evidence given by leader the two other senior citizens, and as both the content debate and disposal, marriage took place about 30 years back. They went by the festival and living together after they were done. The second plaintiff is married. No doubt. The Defense Council transacted including the PW 2 to 6 in the length and given there is some stress and things in the transaction, it is nowhere affected the rate of the time and it is nowhere affected the case to come to the conclusion that the plaintiff is not being verified wife of plaintiff number 2 is and the daughter of the first and the suit properties are settled property of the running in India. The above which is located by the
What is this case sentence in the cross examination? Plus or minus, sir.
2:30.
Come before 4:30 and argue. Pass over. Yes, Mr. Chandramohan.
I represent the appellant in this case, my lord.
Yes,
my lord,
please.
this is defendant's appeal, my lord.
Suit is for?
Suit is for declaration and permanent injunction filed by the plaintiff respondent, my lord. My lord, the facts of the case is that initially the land in question, my lord, belonged to the appellant herein. On 26/11/1991, the respondent plaintiff purchased the same from the plaintiff appellant herein, my lord. She was in the place, my lord, in the Gejjalagere, where the land is situated and the appellant is also residing, my lord. For some time she was there. Thereafter, my lord, since she being from Kerala, my lord, and not well aged, my lord, she left for her native Kerala, my lord. After some time, my lord, since she was unable to cultivate the land and all, my lord, she sold this land, resold it, my lord, in favor of the appellant, my lord, on 18/9/2000, my lord. 18/9/2000. My lord, in 2011, 2001, my lord, this land and the other lands in and around Gejjalagere got acquired by KIDB, my lord. And in 2011, my lord, this lady, my lord, through one GP holder claiming to be her son, filed the suit, my lord, claiming that she never sold this land to the appellant. And then, my lord, the suit, my lord, after contest came to be dismissed. The lower appellate court, my lord, there was delay, my lord, in filing the appeal. Court below, my lord, in a lower appellate court, my lord, in a very short manner, my lord. Point number 1, page 20, my lord, condones the delay, my lord.
So how have you repurchased it?
Beg your pardon, my lord?
How did you repurchase this property? From whom?
From the very same person to whom I had sold, the plaintiff.
Yes.
She, my lord, files a suit, my lord, through her, a person claiming to be her son, a GP holder. But strangely, my lord, she comes and gives her evidence, my lord, in the original suit. But the suit, my lord, after contest and in a detailed considered judgment, my lord, the suit came to be dismissed. And there was delay in filing the appeal, my lord. Delay was condoned, my lord, without proper reasoning. And thereafter, my lord, appeal has been allowed. The court below, my lower appellate court, my lord,
to secure the records of the correction.
notice may kindly be issued to the parties, my lord. She is already a aged person. We do not know. We do not know, my lord.
I want to see those signatures.
My lord, your lordship will kindly say about that aspect, my lord. My lord, court cannot be an handwriting expert, my lord. Court can compare.
But if it is visible to the naked eye,
my lord, but still, my lord, because 10 years difference, your lordship will kindly say the first sale deed executed by the.
Is there a photograph of the lady?
Photograph of the lady, my lord.
In the sale deed. In the sale deed dated 18/9/2000.
I don't know, my lord. At that time, whether.
You must be having the copy of the sale deed, isn't it?
Yes, yes, my lord. That is there.
Please.
But in that, my lord.
This issue notice call for records.
Photographs were not there, my lord.
No, in 2000 it was there, sir.
Photos. Certificate copy has been produced.
Photographs were introduced in the year 2000. 1997 in the issue, 95, 96 in the photographs.
Records may be called for, but what I request is, since that lady was already old, my lord, it is better to issue notice, my lord. We do not know.
Notice call for records. Yes, Mr. Chandramohan, issue notice call for records.
Oblige, my lord. Oblige, my lord.
Second dependency. Plaintiff, Seshappa and the third defendant, they were the children of one Narayan Mulya. Narayan Mulya got the properties by virtue of grant made under the provisions of Karnataka land records. But plaintiff claims that after his death, they have succeeded to the properties and they are entitled. First defendant is the widow of Seshappa Mulya, who is the son. She propounded a will of Narayan bequeathing the properties in favor of Seshappa. The second defendant, who is the appellant hearing, she is the daughter of Seshappa Mulya. She propounds a will of Seshappa Mulya. My lord, the trial court upholding the will of Seshappa Mulya dismisses the suit of the will. As against which an appeal is filed. Appellate court reverses the judgment and grants, passes a preliminary decree declaring this. Lord, now the question is whether Seshappa Mulya had executed a will in favor of the second. The courts below have rejected the.
Seshappa Mulya had executed a will in favor of the second defendant.
Second.
But what about the will in favor of Seshappa Mulya?
That is upheld by the trial court. The appellate court reverses.
What is his right to execute a will?
Narayan Mulya had executed a will in favor of Seshappa Mulya. That is the will propounded by the court.
What is his power to right to execute a will?
Narayan Mulya, my lord, he was the grant. He had executed a will in favor of his son. That will is propounded by the first defendant. That is upheld by the trial court. And dismisses the suit of the plaintiff. Now the second defendant propounds the will of Seshapamurthy, who has been bequeathed under the will that is executed by Narayan.
I'm asking you, what is the right of Narayana Mulya to bequeath the entire property?
Narayan Mulya is the person in whose favor grant is made under the land.
Grant is made to the family.
No, it is not. Narayan Mulya, but he is a male member.
Correct, but when he was granted, were this plaintiff and the other defendants were they born?
They were born. Narayan Mulya reported. They were born. Well, necessarily it need not be.
There is a form number 7 that you had filed. Form number 7 was it produced before the trial court? Then the tenancy is inherited. It inherits the tenancy on behalf of all the family members.
Lord Narayan Mulya, in his lifetime, he has executed it. He is the person who has
No doubt. The question is,
Narayan Mulya was the father.
If Narayana Mulya had inherited the tenancy from his father.
That is not nobody's case.
That
is nobody's case. Part number 7 is not produced. Part number 10.
You not have any.
Adhan produce ಮಾಡಿ.
Form number 7 ತಾನೆ produce ಮಾಡಬೇಕು.
ಅವರು ಮಾಡಿ.
Then how do you say that it was not for the member?
Lord, they are governed by horizontal law. Male member is not a member of the kutumba of their children. Therefore, my lord, it cannot be a family property. That concept is not there. And it is nobody's case that my lord Narayan Mulya had obtained it on behalf of the family.
But then how else is the partition granted then?
Partition is granted by ignoring both these.
What basis?
My lord, first is, my lord, that the original of the will that is executed by Narayan Mulya is not produced. Second, as far as my will is concerned, my lord, one is, my lord, it is executed even prior to the will that was executed by Narayan. Seshapamurthy had executed the will even before the death of Narayan Mulya.
Is that not a wonderful suspicious circumstance?
That may be a suspicious circumstance, but under law, my lord, it is no.
Fact that he has executed the will even before he got the property from his father through a will. Is that not a wonderful suspicious circumstance that can cut both the wills? It can cut both the wills. Before his father could give the property to him by a will, he gives it to his daughter by another will.
He says, my lord, I am in possession of the property. Therefore, I have given it to my daughter. That is all he says in his will.
Sir, you accept that this is a property which is the independent grant in favor of Narayana Mulya.
Narayan Mulya, it is.
If you say it's independent grant in favor of Narayana Mulya, only he can bequeath it. If he does not bequeath it, then everybody gets. Now, if you have bequeathed the property even before your father bequeathed it to you, and thereafter you get the bequeath, what does that mean? So, it's a clear case.
But he doesn't say, my lord, I am the owner of the property. I am in possession of the property. I will be.
Sir, ಅವನಿಗೆ ಬರಕ್ ಮುಂಚೆನೆ ಇನ್ನೊಬ್ರು ಕೊಟ್ಟಿದ್ದಾನಲ್ಲ, ಮಗಳು ಕೊಟ್ಟಿದ್ದಾನಲ್ಲ. ಮಗಳು ಕೊಟ್ಟ ಮೇಲೆ ನಂತರ he gets it from his father. So what is that not a wonderful suspicious circumstance to show that the Sheshappa Mulya?
Not be suspicious.
What is it?
Maybe
it can't be coincidence. They can't be coincidence. It can't be coincidence. Now, how did you know that his father is going to give the property?
He has not mentioned anything about that.
Sir, by giving anything it to ತನ್ನ ಮಗಳಿಗೆ ಕೊಡ್ತಾ ಇದ್ದಾನೆ ಅರ್ಥ ಏನು? ನಮ್ಮಪ್ಪ ನನಗೆ ಕೊಡ್ತಾರೆ ಅಂತ ತಾನೆ. ನಮ್ಮಪ್ಪ ನನಗೆ ಕೊಡ್ತಾರೆ, ಅದಕ್ಕೆ ನಾನು ನನ್ನ ಮಗಳು ಕೊಟ್ಟಿದ್ದೀನಿ. ಇನ್ನ ನಿಮ್ಮಪ್ಪ ಬದುಕಿದ್ದಾರೆ, ನಿಮ್ಮಪ್ಪ ಕೊಟ್ಟಿಲ್ಲ. ಇಲ್ದಿರೋದ್ರೆ how can you give something that you don't have? And thereafter you possess it by a will from your father. Is that not a suspicious circumstance? And how old was Narayan Mulya when he executed the will?
In the year 1988.
How old was he?
Age is.
ಇರುತ್ತೆ ನೋಡಿ, will ಅಲ್ಲಿ ಇರಲ್ವಾ? Exhibit ಎಷ್ಟು?
Exhibit D5.
80 ವರ್ಷದ ಮುದುಕ.
Executed in 86. 80 years.
80 years. Yes. ಅಷ್ಟೇ ಅಲ್ವಾ? ಬರ್ಕೊಳ್ಳಿ. is filed by the
Not for feeding the grandpa stock.
will ಹೆಂಗಾಗುತ್ತೆ? ಅದೇ will ಹೆಂಗಾಗುತ್ತೆ?
Once he gets the property after the death of Narayan Murli.
Right. How can he? This is suspicious circumstance.
Suspicious circumstance.
This is suspicious circumstance. This appeal is filed by the defendant number 2 and defendant number 2 and defendant number 4, challenging the judgment, challenging the divergent finding recorded to the first appellate court. RA 91, RA 103 of 2010. There is another appeal ilva. There is only one appeal of 203 of 2010 and 91 of 2010, by which the first appellate court reversed the judgment and declared the trial court OS number 120 of 1998. Next one. The suit in OS number 120 of 1998 was filed for partition and separate possession of the 1/3 share of the plaintiff in the suit property, which is agricultural land bearing survey number 40/1, 40/2A2, 40/3, 40/6 of Maladi village, Beltangdi Taluk, and survey number 157/2B of Maladi village, Beltangdi Taluk. Next paragraph. The plaintiff claimed that the land in survey numbers land bearing survey number 40/1, 40/2A2, 40/3, 40/6 were granted to Narayana Mulya by the land tribunal 25/9/1979, while the land bearing survey number 157/2B was assigned in the name of Kittu Hengsu, wife of Narayana Mulya. Stop. The plaintiff, defendant number 3 and M.K. Sesappa Mulya were the children of Narayana Mulya and Kittu Hengsu. Stop. The defendant number 1 is the widow of Sesappa Mulya. Stop. Hence, it is stated that the above properties were the joint properties of the plaintiff and defendant 1 and 3. Hence, she is entitled to 1/3 share in the suitable properties as Narayana Mulya died on 25/7/1988, while Kittu Hengsu died on 28/7/1984. Stop. The plaintiff alleged that the defendant number 2, claiming to be the daughter of Sesappa Mulya, had propounded a will claiming right, title, and interest over the above properties. Stop. The plaintiff alleged that Sesappa Mulya had not married anyone else other than the defendant number 1, but the defendant number 2 and his mother, Karnataka had got their claims located in the revenue records. Hence, they were arraigned as parties in the suit. Next paragraph. The defendant number 1 contested the suit and admitted the fact that the land bearing survey numbers 40/1, 40/280, 40/3, and 40/6 of Malvadi village were granted to Narayana Mulya by the land tribunal. She also admitted that plaintiff, defendant number 3 and Sesappa Mulya were the children of Narayana Mulya and Kittu Hensu. However, she denied that the suit properties were the joint properties of the plaintiff and defendant's moment. She contended that Narayana Mulya had executed a will dated 1/1/1986 in respect of the Asian property in favor of his son M.K. Sesappa Mulya. And after the death of M.K. Sesappa Mulya, she being the only legal heir of Sesappa Mulya, had succeeded to the said properties. Full stop. Insofar as the land bearing survey number 157/2B, she contended that it belonged to the plaintiff herself and the defendant number 3. Hence, she contended that only the land bearing survey number 157/2B was able to be partitioned between the plaintiff, herself and the defendant number 3 in 3 equal shares. Next paragraph. The defendant number 2 contested the suit and claimed that the plaintiff had no right over the suit's real properties. She contended that the defendant number 1 and 3 also had no right over the suit's real properties. She contended that the land bearing survey number 40/1, 40/282, 40/3, and 40/6 were cultivated by Narayana Mulya and his son Sesappa Mulya, and that Narayana Mulya had filed form number 7, claiming occupancy rights in respect of the aforesaid survey numbers. She claimed that the land tribunal granted occupancy rights in favor of Narayana Mulya in respect of the aforesaid survey numbers. Later, Narayana Mulya bequeathed the said properties in favor of Sesappa Mulya on 1/4/1986. So she alleged that after the death of Narayana Mulya, Sesappa Mulya became the owner of the aforesaid 4 survey numbers and contended that the defendant number 1 had deserted Sesappa Mulya. Therefore, out of natural love and affection, Sesappa Mulya had bequeathed the 4 survey numbers and another property in favor of the defendant number 2 in terms of a will dated 18/8/1984. Full stop. She claimed that after the death of Sesappa Mulya, she became the owner of the aforesaid 4 properties, 4 survey numbers. She also claimed that the land bearing survey number 157/2B was assigned in favor of Kittu Hensu, and after her death, it devolved upon her husband and children, and thus the plaintiff, defendants 1, 3, and 4 are entitled to 1/4 the share in the said property.
Share that is declared with the character, not with the. But as per the decree that is granted by the appellate court at 25, holds my lord that the defendant number 2 is an illegitimate child of Sesappa Mulya, and she has got a share in the Internal page is 86, in page 47.
26, yeah.
Internal page 26. EW2 in our cross-examination has categorically admitted that the dependent number 1 is the wife of CH-22.
Where are reading?
In page 26. Internal page 26.
Internal page.
In page 35. Came to know about even in the will dated shows propounded to dependent number.
I didn't get it. In page number 26 alwa.
Allah. So internal page 26 in page 35.
Correct. Where are reading?
First line from first line on.
One is the wife of
Seshapamula, and she came to know about this later. Even in the will dated shows propounded by dependent number 2, there is a recital that dependent number 1 is the wife of Seshapamula. Therefore, second marriage during the subsistence of first marriage is void under the marriage act. Therefore, dependent number 4 cannot be considered as the wife of Seshapamula. Therefore, dependent number 2 cannot be considered as the legitimate child of Seshapamula. However, as rightly observed by the lower court as 16 of the marriage act, even an illegitimate child has got a right over the properties of her mother. Therefore, dependent number 2 being the illegitimate child of Seshapamula would be entitled for a share in the issue. But therefore, a share has to be declared in favor of.
Will declare a share.
1/3 share.
Other share only.
Other share. But she is the only daughter. She is the only daughter.
So therefore, she will get only 1/3. So whatever her father gets, she will get it. This different number 1 is not alive. Is alive.
She and herself.
So 1/3 only share ಆಗುತ್ತೆ. So 1/6 ಬರ್ತದೆ. Full stop. Based on these rival contentions, the trial court failed the following issues. The plaintiff was examined as PW1 and she marked the documents of exhibit P1 to P11. Full stop. The defendant number 1 was examined as DW1 and defendant number 2 was examined as DW2, and they marked exhibits D1 to D34. They also examined 2 witnesses as DW3 and DW4. Based on the oral and documentary evidence, the trial court held as follows. Trial court held that the suit properties, the trial court held that the land bearing survey number 40/1, 40/280, 40/3 and 40/6 were granted to Narayana Pujari, Narayana Mulya by the land tribunal, and therefore it was a self-acquisition. Stop. It also held that the said Narayana Mulya had executed a will in favor of his son, Seshappa Mulya, in terms of exhibit B5, and that Narayana Mulya, exhibit B1, and that Narayana Mulya had in turn bequeathed his property. The aforesaid Narayana Mulya had in turn bequeathed the aforesaid in terms of exhibit B5. Stop. And what the suit B properties other ಬಗ್ಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? Trial court. But why was a share not declared in so far as occupancy is concerned?
Our should have been declared.
Correct, but occupancy ಗೂ ಬಂದಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾರಿಗೂ ಹೋಗ್ಬೇಕು? ಮಗಳಿಗೆ ಬರ್ಬೇಕಲ್ವ? What does the trial court say about the other property? Occupancy property. ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳ?
ನಮಸ್ತೆ ಹೇಳಿ. ಹಾ ಹಾ ಅದೇ ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೆ, ಈಗ ಆಫೀಸಿಗೆ ಬಂದಿದ್ದೀನಿ. ಯಾವ್ದೋ
Please read this paragraph number 33 over. Sorry, paragraph number 32 of the trial court judgment. Paragraph number 32.
As per defendant number 2, he said MP Sheshakamulya executed a will in her favor on 1884. Defendant number 2 has examined one of the said D4 as DW4. Even though DW4 is proposed, he knows Sheshakamulya from 1968. He does not know Devaraj Pandey and Vittal Ray. Further, DW4 has proposed that Sheshakamulya executed a will in favor of defendant number 2. At the time of execution, he said Sheshakamulya has given exhibit D5 to the document writer. As per DW4, year 1984 said Sheshakamulya has executed the will in favor of defendant number 2. So it creates a doubt that how the executant can give exhibit D5 when he was executed in the year.
Why did they shoot? Why was the suit dismissed then?
That will was upheld. Will executed by Narayan Mulle was upheld.
Will executed by Narayan
Mulle in favor of Sheshakamulya was upheld. Then it held my lord that it comes to defendant number 1. 25. Also,
exhibit D1. Full stop. Consequently, it held that the plaintiff had no manner of right, title, or interest. The 4 survey numbers referred above. So far as the land bearing survey number 157/2B is concerned, the trial court held that ಅದ್ರ ಬಗ್ಗೆ ಏನಿಲ್ವಾ, ಡಿಸ್ಕಷನ್ ಇಲ್ವಾ?
schedule property was assigned or 20 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ಏನೋ ಹೇಳ್ತಾರೆ. ಎಲ್ಲ ಒಪ್ಕೊಳ್ತಾರ, ವೈ ಶೇರ್ ಇಸ್ ನಾಟ್ ಡಿಕ್ಲೇರ್ಡ್. ಸೆಕ್ಷನ್ 6 ಬಿಡಿ, ಸೆಕ್ಷನ್ 15 ಪ್ರಕಾರ ಬರ್ಬೇಕಲ್ಲ. as per 15 she is entitled for a share.
They are married.
No?
They are no right as per.
Nindamma judgment is gone. Nindamma judgment ಹೋಯ್ತು. Nindamana Nimbavana, which is a Nimbava. Nimbava. The judgment is already set aside. So far as the land bearing survey number 157/2B is concerned, the trial court held that the revenue records of the said property was transferred to the name of the defendant number 1, 2, and 4. and that the plaintiff had not challenged the said litigation proceedings before the revenue courts. So therefore, it held that the plaintiff failed to prove that the said properties were the joint properties of were her joint properties, were the joint properties of the plaintiff and defendant number 1 and 3. Yes, it thus dismissed the suit. Being agreed with the aforesaid judgment and decree, the plaintiff filed first appeal with, in RA 91 of 2010. ನೀವೇನಕ್ಕೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ 103, while the defendant number 2 and 4 filed RA 103 of 2010 against the finding that Sheshappa Mulya had not executed the will in favor of the defendant number 2. Stop. The first appellate court heard both the appeals and framed the following points for consideration. Copy. Stop. The first appellate court reversed the judgment and decree of the trial court on the following consideration. On the following findings. Number 1, that the will executed by Narayana Mulya in favor of his son Sheshappa Mulya was fraught before UGHT fraught with suspicious circumstances, namely that Sheshappa Mulya had already executed a will in favor of the defendant number 2 even before getting the same from Narayana Mulya. Full stop. Number 2, that the
Narayana Mulya's will is concerned, original is not.
That the original will of Narayana Mulya was not marked before the trial court. Number 3, an attempt made by the plaintiff number 3, no evidence was adduced to prove the signatures of the attesting witnesses or the executant of the document. Full stop. That though the defendant number 1 had filed an application to summon the original thumb impression register, the same was dismissed by the trial court and challenged before this court in a writ petition. Full stop. This court disposed of the writ petition, directing the trial court to decide the validity of the document based on the basis of the certified copy. Full stop. It held that except producing exhibit E1, the defendant number 2 did not adduce any evidence to prove exhibit E1 in accordance with law. It therefore held that the defendant did not comply with the requirements of section 68 of the Evidence Act. And that the defendant number 1 failed to prove the due execution of exhibit E1. Since in view of this finding, the first appellate court held that the plaintiff, plaintiff is entitled to an undivided share in the suit's property along with the defendant number 1, defendant number 2, and defendant number 4. Full stop. The first appellate court held that the defendant number 2 was the illegitimate child of Sheshappa Mulya. In view of the a recital contained in exhibit D5, which was the will stated to have been executed by Sheshappa Mulya in favor of the defendant number 2, wherein it was stated that the defendant number 1 was his first wife. Full stop. The first appellate court held that the defendant number 2, being such an illegitimate child, is also entitled to a share in the property of CH-22 and thus allowed the appeals, and thus allowed the appeal filed by the plaintiff in RA 91 of 2010. And dismissed the appeal filed by the defendant number 2 and 4 in RA 103 of 2010, and consequently decreed the suit
After running and receipt.
to one-third share in all the suit property. Being reviewed by the aforesaid judgment and decree, the defendants 2 and 4 have filed these second appeals. The learned counsel for the appellants contended that the suit properties contended that survey numbers 40/1, 40/282, 40/3, and 40/6 were the properties that were held by Narayana Mulya as his as his own properties, and that he had executed a will in favor of CH-22, who in turn executed a will in favor of the defendant number 2, and therefore there is a clear flow of title in favor of the defendant number 2. He further submitted that the will of Narayana Mulya was executed in the year 1986, and that the same was and defendant number 4. Full stop. For contra, the learned counsel for the plaintiff submitted that the will executed by Narayana Mulya was not proved in accordance with law. Therefore, Narayana Mulya should be considered as having died intestate. Stop. If that be so, then the property is to devolve on his 3 children, namely the plaintiff, defendant number 1, and the defendant number 3. Defendant number 1, namely the husband of the defendant number 1 and the defendant number 3. Full stop. Insofar as the land bearing survey number 157/2B is concerned, he submitted that the plaintiff and defendants were all in conformity, that each of them are entitled to a share in the said property, and therefore the first appellate court was right in decreeing the suit filed by the plaintiff. Next paragraph. I consider the submission made by the learned counsel for the parties. I also produced the records of the trial court as well as the judgment and decree passed by the trial court and the first appellate court. Next paragraph. The undisputed facts are that the land bearing survey number 40/1, 40/282, 40/3, and 40/6 were granted to Narayana Mulya by the land tribunal pursuant to form number 7 filed by him seeking grant of occupancy rights. Full stop. Insofar as the land bearing survey number 157/2B is concerned, the same was assigned to Srimati Kittu Hengsu, who also died intestate. Full stop. As far as the will executed by Narayana Mulya, the defendant number 1 and defendant number 1 failed to establish the same in accordance with law. Full stop. Therefore, the finding of the first appellate court that Narayana Mulya did not execute, first appellate court that the bill executed by Narayana Mulya in favor of Sheshappa Mulya was not proved in accordance with law, cannot be interfered with. If that be so, then the first appellate court was justified in decreeing the suit filed by the plaintiff and declaring that she is entitled to 1/3 share in the aforesaid properties. Insofar as the land bearing survey number 157/2B is concerned, plaintiff being the daughter of Ensu was entitled to claim 1/3 share along with the husband of the defendant number 1 and the defendant number 3. And the first appellate court was justified in decreeing the suit. Full stop. Decreeing the suit. Full stop. Since the first appellate court did not specify the share of the defendant number 2 and defendant number 4, it is necessary to modify the judgment and decree of the first appellate court to a limited extent, namely to declare that the defendant number 2 is entitled to 1/6 share in the suit shell properties, while the defendant number 1 and defendant number 4 are together entitled to 1/6 share therein. Consequently, these appeals are dismissed. However, dismissed and under the judgment and decree of the first appellate court granting 1/3 share to the plaintiff in the suit shell properties are upheld. Full stop. The defendant number 2 is declared to be entitled to 1/6 share in the suit shell properties, while the defendant number 3 is entitled to 1/3 share, while the defendant number 1 and defendant number 4 are together entitled to 1/6 share in the suit shell properties. Yes. Both appeals are disposed. 1/6. 1 and 4 will get 1/6 together. There are 2 wives.
She is not illegitimate.
Legitimate and illegitimate wife. There are 2 wives to sell self-acquired property and Tikkam Rupura. Then they are entitled to 1/6 share, both of them. What is the evidence of Madhya Yavaga? The finding is Sheshappa Mulya himself says in the will that she is married. How can you now dispute it? Yes. Issue notice on IA 1 of 19. Notice. Yes. ಇಲ್ಲ ಅಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು ಹೇಳಿ 1/3 ಮಾಡಿದೆ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ. Voter list for what?
Voter list to show the name of the defendant and the wife, name of the wife, the mother of the plaintiff. Discard ಮಾಡ್ತಾರೆ 2008 after the filing of suit.
ಆಯ್ತು, ರಿಲೇಶನ್ಶಿಪ್ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಯಾರ್ದು ತೋರಿಸಿ, ಯಾರ್ದು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೀರಾ?
The voter list showing that the name of the plaintiff's mother and defendant.
ಸಾಕಾಗಲ್ವಲ್ಲ, ಮದುವೆಯಾಗಿ ತೋರಿಸ್ಬೇಕಲ್ಲ. How have you proved the relationship?
Relationship part, it is the whole marriage because only the
who are this PW2 and PW3 are?
PW2 and PW3 are the residents of the village.
ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
They got married with tenant, got married to mother of the plaintiff and they are staying there. One more 41 years good for maintenance is filed by the wife. That will dismiss now it is pending for this honorable court.
It is dismissed on what ground?
Relationship.
Okay.
Waiting was there in the
Issue notice. Yes, Mr. Rahul Reddy.
I appear for the appellant in this matter, Your Lordship. Lordship, Didrali, the respondent and her daughter, one Prema Kumari, she files a suit against the appellant and his son Shiv Kumar, seeking a relief of declaration and for mandatory injunction, declaring that the partition deed entered into between the appellant and his brother are null and void and not binding, and also a prayer seeking to pay maintenance of rupees 3,000 to the respondent and 2,000 to her daughter Prema Kumari. Your Lordship, during the pendency of the suit, Your Lordship, the second plaintiff, Prema Kumari, that is the daughter of the respondent, she files a memo for not pressing her suit against the claim, and hence she will be discarded, Your Lordship. Idralli, Your Lordship, it is the contention of the respondent stating that she got married to the appellant 25 years back at Tirupati temple in Andhra Pradesh. They stayed together for 2 years, and thereafter the appellant got married to his own sister's daughter, one called Reddamma. And after getting got married to Reddamma, he deserted the respondent and did not maintain her, and hence she filed this suit. And also she comes to know in the year 2003, the appellant and his brother will get into a partition, and as per the partition deed, all the property goes to the second wife's son, Shiv Kumar, who is also part in the suit. Our basis mele she will file a suit stating that for maintenance and all. Idralli, Your Lordship, I will, my written statement is, I am not at all married to the respondent. Respondent, I am not married to respondent. And
How does the respondent marriage? How does the respondent do the marriage?
she has not placed any material, Your Lordship. And also in the cross-examination, she has.
Who are these witnesses?
Witnesses, Your Lordship. One is her brother. PW1 is respondent only. PW2 is her brother.
Yes, brother.
PW3 is a ಪರಿಚಯ ಇರೋರು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದೇ ಊರವರು ಏನು ಅಂತ ಅದನ್ನು ಹೇಳಿಲ್ಲ ಅವರು. ಪರಿಚಯ ಇರೋರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. PW4 is her daughter. Daughter has been discarded. She files a memo and ಇದು.
But did she face the cross examination?
Yes, Your Lordship. She has faced the cross. ಇಲ್ಲ ಮಗಳು cross examination. Oh, 1 second, Your Lordship. Yes, Your Lordship. The daughter has also faced cross examination.
How do you overcome these documents? SSLC marks card, hospital card, study certificate. How do you overcome these documents, and how do you overcome the evidence of PW2?
PW2 evidence, Your Lordship, ಅವರೇನೆ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. I have been married in the year 1986 to one Reddamma, and as per that ನಾವು ಮದುವೆ ಇನ್ವಿಟೇಷನ್ ಕೊಟ್ಟು ಹಿಂದೂ ರಿಚುವಲ್ಸ್ ಪ್ರಕಾರ ನಾನು ಮದುವೆ ಆಗಿದ್ದೀನಿ ಅಂತ PW2 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
PW2.
Yes, Your Lordship.
Brother.
ಹೌದು, brother.
What does he say?
He stated that I have been married to Reddamma ಅಂತಾನು ಹೇಳ್ತಾರೆ. In the year 1986, clear ಆಗಿ as per the Hindu rituals, I have given the invitation card to all the villagers. ಅದ್ರ ಪ್ರಕಾರ ಮದುವೆ ಆಗಿದ್ದೀನಿ ಅಂದ್ರೆ ಹೌದು ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾನೆ PW2. ಅಂದ್ರೆ ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ರದರ್.
What about the marriage of PW1 with Govinda Reddy? What does he say?
He says that I have been married in the 28 years back ಅಂತ ಒಂದು ಹೇಳ್ತಾರೆ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ತಾರೆ.
How do you overcome that?
There is no document, ಏನು ಡಾಕ್ಯುಮೆಂಟ್, ಒಂದು ಪೀಸ್ ಆಫ್ ಪೇಪರ್ ಹಾಕಿಲ್ಲ ಅವರು. ಇನ್ಫ್ಯಾಕ್ಟ್ PW1 ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಾವು ಕೇಳಿದೀವಿ ಏನಂತ, ಡು ಯು ನೋ ದ ಎಕ್ಸಾಕ್ಟ್ ಡೇಟ್ ಅಂತಂದ್ರೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ, ಯಾವಾಗ ಮದುವೆ ಆಗಿದ್ದು ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ದಾಖಲೆ ಇದೆ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಅವ್ರು 2 ವರ್ಷ ಸಂಸಾರ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅದಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇಲ್ಲ? ಇಲ್ಲ, ಏನು ಇಲ್ಲ, ನಮ್ಮ ಹತ್ರ ದಾಖಲೆ ಇಲ್ಲ. ಅವರಿಬ್ರು ಸಂಸಾರ
ದಾಖಲೆ ಇದೆಯಲ್ಲ, SLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ.
ದಟ್ ಈಸ್ ಸರ್ ಸನ್ಸ್ ಅಂತ. ಅದನ್ನು ಲಾರ್ಡ್ಶಿಪ್ PW2 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನಾವು ಕ್ಲಿಯರ್ ಆಗಿ ಕೇಳಿದೀವಿ. ಯುವರ್ ಡಾಟರ್ ಅಡ್ಮಿಷನ್ ಯಾರು ಬಂದಿದ್ರು ಅಂದ್ರೆ, ಇಲ್ಲ ಮದರ್ ಹ್ಯಾಸ್ ಗಾನ್ ಅಂಡ್ ಗಾಟ್ ಹರ್ ಡಾಟರ್ ಅಡ್ಮಿಟೆಡ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ. ತಾಯಿ ಹೋಗಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಗೋವಿಂದ್ ರೆಡ್ಡಿ ಅಂತ ಹೆಸರು ಹೇಳಿ ಶಿ ಹ್ಯಾಸ್ ಗಾಟ್ ಇಟ್ ಅಡ್ಮಿಟೆಡ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ನಾನೀಗ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಒನ್ IA. ಅದರಲ್ಲಿ ದ ಸೆಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಶಿ ಗಾಟ್ ಮ್ಯಾರಿಡ್ ಟು ಒನ್ ಮಂಜುನಾಥ್ ಅಂತ ಅವ್ರದೊಂದು ಇನ್ವಿಟೇಷನ್ ಕಾರ್ಡ್ ಹಾಕಿದೀನಿ. 1980 she has got married to Manjunath. And Your Lordship, my second document is my marriage invitation. 1986 ಅಲ್ಲಿ I got married to Reddamma ಅಂತ ನನ್ನ ಇನ್ವಿಟೇಷನ್ ಕಾರ್ಡ್. And Your Lordship,
ಇಲ್ಲ ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ, Reddamma ಜೊತೆ EMI ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ.
ಇಲ್ಲ ಥರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ Your Lordship, ಯಾರು my daughter with Reddamma, Shilpa, she was born in the year 1987. ಈ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಗಳು, she was born in the year 1990. She claims that she was the first wife and Reddamma is the second wife. Reddamma ಜೊತೆ 1986 ಅಲ್ಲಿ ಮದುವೆ ಆಗಿದೆ, 1987 ಅಲ್ಲಿ I've got a daughter. 1990 when she has stayed with me for 2 years and then I have deserted. 1990 how can the
all for records.
Plaintiffs in the field. Plaintiffs have filed a suit for mandatory injunction against the defendant. They have encroached the special property, and the suit of the plaintiff was decreed by the trial court. And the appellate court reverses the decree and dismisses the suit. On the ground, paragraph 13 says that paragraph 13 of the appellate court judgment, my lord. As per Article 58 of the Rendition Act, the suit relating to declaration to obtain any other declaration, the period of limitation is 3 years. All of action being done when the right to sue first approach. The case on hand, as admitted by Figure 1 in 2008, defendant had constructed the compound wall, but the result suit was filed in 2013. There is no explanation by the plaintiff why they did not obstruct the defendant from proceeding construction of the compound and encroaching the portion of the restricted property. It was not very short given an assumption of encroachment of the defendant. So, all the time saying to submit your copy that this when this compound was put up by the defendant, it's a continuing offense. And defendant did not enter the witness box. Whatever he pleaded, he has not substantiated by pleading any evidence.
But you yourself say that you constructed the compound wall in the year 2008.
No, but then the trial court has held that as per exhibit P63 even photographs, that some of these properties is the defendant was constructed in 2011.
Issue notice. Issue notice.
Trial court did not have this.
Just issue notice now. And this is a suit for injunction. Mr. Bhuvanendra Raju. Password. Password. 43
appearing for appellant, my lord. Plaintiff
54.
Plaintiff second appeal. Suit for partition and separate possession. Trial court dismissed the suit, holding that, my lord, there is a previous partition, for which, my lord, the exhibit D5 has been marked before the trial court. That is the judgment and decree passed in OS 78 of 2002. My lord, the suit schedule property, my lord, totally 14 items are there. My lord, the defendant number 3 alone appeared before the trial court and filed the written statement, admitted that all the suit schedule property are the joint family properties. My lord, the previous suit OS 78 of 2002. My lord, the item number 9 to 12, my lord, is the present suit schedule property is the schedule in the previous suit OS 78 of 2002. With respect to remaining items, my lord, item number 1 to 8 and 13 and 14, my lord, is not the subject.
9 to 12 are the subject matter of the earlier suit.
Yes, my lord. And
9 to 12.
Is 9 to 12. So far as, my lord, the item number 1 to 8 and 13 to 14, my lord, is not the subject matter. Though in the written statement, my lord, the third defendant has taken the specific stand, my lord, with respect to item number 1 to 8 and 13 to 14. There is a previous partition, my lord, during the lifetime of the father Kempaya. I would like to take, my lord, attention to page number 55, the genealogy. The third defendant, my lord, the Katyayani, she is the wife of Mallappa and the original prepositor Kempaya. item number 1 to 8 and 13 and 14, my lord, her contention in the written statement, there is a previous partition for which, my lord, no documents has been placed before the trial court. And so far, my lord, the trial court, there is no finding. Previous partition, there is no, my lord, though she has taken the contention with respect to previous partition, Mallappa and Honnegowdan Mati Aitu anta heltare.
Mallappa and
Honnegowda. And her contention in the written statement, previous party with respect to item number 1 to 8 and 13, 14, there is a previous partition between Mallappa and Honnegowda during the lifetime of Kempaya. And certain properties, my lord, in that partition, certain properties fall to the share of Kempaya. That is item number 9 to 12. Since there is no partition, hence the suit has been filed in OS, my lord, the 78 of 2002. So far as, my lord, the previous partition is concerned, my lord, there is no, my lord, no issues has been framed, no findings has been recorded by the trial court, not by the first appellate court. But the findings recorded by the court below is that, my lord, there is a previous partition in the suit filed in OS 78 of 2002. Plaintiff is one of the, he is arraigned as a third defendant in OS 78 of 2002. The judgment and decree passed in OS 78 of 2002 has reached its finality. Plaintiff has, though she was a party to those proceedings, she has not filed any appeal. Hence, the present suit is not maintainable. That is the findings recorded by the trial court.
Please tell me whether a statement was made in OS number 78 of 2002 that there was a partition between Kempaya, Honnegowda and Mallappa.
No such statement has been made. Exhibit D5 is the judgment and decree passed in OS 78. For the first time, defendant number 3 has made a statement in the has filed the written statement in the present suit, and she has contended that there is a previous partition. Please.
Notice call for it.
Much obliged, my lord.
Father's father, grandson of one Muniventappa. Muniventappa has purchased the social property out of the land is 714. 3 shares have been one. Krishnappa is the proposed despite his grandfather. He had 4 sons: Buddhappa, Mariappa, Muniappa, and Shantappa. Among them, 3 shares have been purchased by them. Buddhappa. Buddhappa antare Buddhappa. Krishnappa's first son. Krishnappa's first son. Krishnappa was the proposed. He had 4 sons. Krishnappa had 4 sons: Buddhappa, Mariappa, Muniappa, and Shantappa.
Muniappa and Shantappa.
Among them, out of 4 persons, these Muniventappa has purchased property from in-laws of Buddhappa, Muniappa, and Shantappa.
Buddhappa,
Muniappa, and Shantappa.
Yes,
they have produced the sale deed also. It was approved by the plaintiffs also. This Mariappa, they said this Mariappa shares impact with the plaintiffs.
The plaintiffs are the children of Mariappa.
Children of Mariappa have filed the suit against these difference for their share, 1/4 share. It is intact, it remains with the plaintiffs. But in fact, the entire property has been continued in the name of Muniventappa, defendant's grandfather name. From 1980. Along with this property, whatever the property purchased there, property also continued in the name. They have not, there is no issue with regard to this. They have not
purchased 3 shares. 1 share shoot ಹಾಕಿದ್ದಾರೆ ಡಿಗ್ರಿ ಆಗಿದೆ ತಪ್ಪೇನಿದೆ
case is for declaration and possession. Not they are not asking for possession.
Sale check ಬಂದಿದೆಯಾ?
Yeah, but they are continuing to be in possession enjoyment of the
entire extent. How
They are not acknowledged the entries made in the.
This appeal is filed by.
No pleadings with regard to the same.
This appeal is filed by the. No. If you have not got it to a sale, the suit must be defeated. This appeal is filed by the.
Revenue entries ಬಗ್ಗೆ declaration
Revenue entries ಡೇಟ್ ಆದ್ಮೇಲೆ ಡೇಟ್ ಇಲ್ಲದೆ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಹೆಂಗ್ ಬಂತು ನಿಮ್ಗೆ? ಮನಿ ಇರ್ಲಿ, ಹೌ ಡಿಡ್ ಯು ಗೆಟ್ ಯುವರ್ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ GDR ನೇ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಶೇರ್ ಆಫ್ ಮರಿಯಪ್ಪ ಅವ್ರು ಹೆಂಗ್ ಬಂತು ನಿಮ್ಗೆ? ಬರ್ಕೊಳ್ಳಿ. This appeal is filed by the. This appeal is filed by the.
Inam land. They have after coming Inam the mobile is not payment to the court. They are not filed any application for re-grant of occupancy rights in their favor.
Who are this appellant number 1 and 2?
They are the LS of purchaser Muniventappa. Muniraja was the only one son of Muniventappa. They are the sons of Muniraja.
This appeal is filed by the defendant number 2, 3, 4. Invoice number 240 of 2011, as well as the purchasers from the said defendants, challenging the concurrent finding of fact that the plaintiffs are entitled to the declaration of their right, title, and interest in respect of the suit property and for consequential relief of perpetual injunction. We'll stop. Next para. The parties shall henceforth be referred to as they were arraigned before the trial court. Next para. The plaintiff averred in the plaint that Krishnappa was the original proprietor of a joint family, which then comprised of his 4 children, namely Uddappa, Mariyappa, Muniyappa, and Shantappa. We'll stop. The suit property was the Inam land, which was endowed to the village office of Bhajantri, and Krishnappa was the Barabardar. We'll stop. It is claimed that all the 4 sons of Krishnappa divided the suit property into 4 equal shares. Is a re-grant agidya?
The re-grant and execution. No re-grant was made in the process. Re-grant agidya.
ನಿಮ್ ಟೈಟ್ಲ್ ಏನ್ ಬರ್ತದೆ? ನಿಮ್ಗೂ ಟೈಟ್ಲ್ ಇಲ್ಲ.
The parties have not made their any.
Notice, the admit issue notice, the substantial question of law which arises by consideration this appeal is whether the suit being admittedly Inam land endowed to the village office of Bhajantri whether the plaintiffs could claim title, whether the plaintiffs could claim title to property, even though the same was not re-granted to, the Barabardars under the provisions of the Karnataka Village Officers Abolition Act. It's not personal business, Bhajantri is it's a village office. The Karnataka Village Offices Abolition Act. ನೋಡಿ ನಿಮ್ಗೂ ಕಟ್ಟಾಗುತ್ತೆ ರೀ, ಯೋಚನೆ ಮಾಡ್ಕೊಳ್ರಿ, ನಿಮ್ಗೂ ತೊಂದರೆ ಆಗುತ್ತೆ ನೋಡಿ. ನೋಡಿ ಯೋಚನೆ ಮಾಡಿಪ್ಪ. ಅಲ್ಲಿ ನಿಮ್ದು ತೊಂದರೆ ಆಯ್ತು, ನೀವು ಅವ್ರ ಒಂದ್ ಕಣ್ಣು ಕೀಳಕ್ ಹೋಗಿ ಎರಡು ನಿಮ್ ಕಣ್ಣು ಕಿತ್ಕೊಂಡ್ಬಿಡ್ತೀರ, ನೋಡ್ಕೊಳ್ಳಿ. Whatever it is, if you say that ಕೃಷ್ಣಪ್ಪಂಗೆ ಟೈಟ್ಲ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಇದು ನಿಮ್ಗೆ ಎರಡು ಕಣ್ಣು ಹೋಗುತ್ತೆ, ಅದು ಒಂದ್ ಕಣ್ಣು ಹೋಗುತ್ತೆ. What will you do? ನೋಡಿ ಯೋಚನೆ ಮಾಡಿ. Issue notice.
Second defendant is the
ಹೇಳಿಲ್ವಾ? Appeal is filed by the defendant number 2, voice number 126 of 1999, challenging the concurrent finding of fact accorded by both the courts. Plaintiff is entitled to
it is related to the loss of water. Died on 7/6/1950. It is a loss of water. This finding is a different. The different degree used to take over 331 of 96.
331 ಯಾರು ಮಾಡ್ಬೋದು?
331 different water to the
declaring that the plaintiff is entitled to a declaration that the decree passed in OS number 331 of 1996 by the Munsif, by the court of the Munsif Mangaluru, is null and void and does not plaintiffs. And also that the lease deed executed by the deceased defendant number 1 in favor of the defendant number 2, dated 19/2/1997, was null and void and not binding upon the plaintiffs. As well as the sale deed dated 24/11/1997, executed by the defendant number 1 in favor of the defendant number 7, does not bind, defendant number 2 does not bind the interest of the plaintiffs. And for consequential injunction, restraining the defendants, restraining the LRs of the defendant number 1 and defendant number 2 from interfering with the possession and enjoyment of the plaintiff in the suit properties. Extra. The plaintiffs claim that they are the owners of the properties, suit properties. Which earlier belonged to Mrs. Mary Magdalene D'Souza, which she purchased in terms of a sale deed dated 9/6/1924. Stop. She died on 7/6/1950, intestate, leaving behind leaving behind the plaintiff 7, 8, 9, 3, leaving 7 children, including the plaintiff number 7, 8, and 9. Full stop. The other plaintiffs are the legal representatives of the 4 children who are died intestate. Full stop. The plaintiffs therefore claim that all of them had succeeded to an undivided share in the aforesaid properties. These suit properties. Full stop. It is claimed that one of the legal heirs, Mr. Cyprian D'Souza, for himself and as the power of attorney of other co-owners, had rented out a residential premises situated in the aforesaid in the suit properties to the deceased defendant number 1 for a monthly on a monthly rent of ₹50. Full stop. The plaintiffs were residing at Bombay, and whenever they came down to Bangalore, they used to collect the monthly rent from the deceased defendant number 1. Full stop. It is claimed that the 9th plaintiff came down to Bangalore during 3rd week of November 1998, and she went to the suit property to collect rents from the deceased defendant number 1. At that time, she was asked to leave the compound, and it was declared that she had no right to demand any rent from him, as he had become the absolute owner of the suit property. Full stop. Thereafter, the defendant number 1 lodged a complaint with the police station at Kadri. Full stop. The plaintiff number 9 thereafter verified from the office of the village accountant of Kadri village and collected a copy of the RTC, which disclosed that the name of the defendant number 2 was transferred. Disclosed that the name of the defendant number 2 was entered in the revenue records on the basis of a purchase in terms of the mutation in MR 536 of 97-98. Stop. She thereafter verified and found that the mutation in MR 536 of 97-98 was based upon a sale deed dated sale deed and lease deed dated 19/2/1997 and 24/11/1997 respectively. Full stop. She also came to know that the deceased defendant number 1 had filed a suit against Mr. Edwin Joseph D'Souza and another in OS number 331 of 1996 on the before the court of the Municipality at Mangalore. Full stop. It was found that the deceased defendant number 1 had managed to obtain a compromise decree wherein it was declared that the deceased defendant number 1 had perfected his title to the suit property by adverse possession. Full stop. She also came to know that the deceased defendant number 1 had leased out 5 cents of land in suit item number 1 and an entire portion of the land is item number 2 on 10/9/1997 in favor of the defendant number 2. Full stop. He also came to know, plaintiff number 9. Plaintiff number 9 also came to know that the defendant number 1 had executed a sale deed of Moolageni right in respect of the suit properties in favor of the defendant number 2 on 24/11/1997. Mooli right on 24/11/1997. The plaintiffs therefore contended that the defendants had conspired to deprive their right title interest in the suit property and therefore filed a suit for declaration of their title to the suit property, and also that the decree obtained in OS number 331 of 1996 did not bind them. At 331 of 1996, the lease deed dated 19 to 1997, and the sale deed dated 24/11/1997 did not bind their interest, right title interest. These two properties. Next, the defendant number 2, defendants 1 and 2 contested the suit and denied the averments of the plaintiff. They claimed that the land in survey number 125/11 belonged to Francis Mascarenas, and he granted the same on Mulageni as per the document dated 1/4/1916 in favor of Juliana Disa Bai. Later, by a registered instrument dated 22/9/1963, Mr. Edwin Joseph D'Souza became the owner of the land in survey number 125/11. Thereafter, in terms of a registered deed dated 6/3/1967, Stella documents Stella D'Souza became the owner of the said property. Thereafter, in terms of a document dated 13/1/1972, Josephine Dipuna got the Mooli right in a portion of survey number 125/11. Then again, in terms of a registered instrument dated 13/1/1972, Josephine Dipuna got the soda chit of Mulageni right. Full stop. The defendant number 1 and 2 claim that the decree obtained in OS number 331 of 1996 was in respect of declaration of his title to the said property. The defendant number 1 claimed that the property in survey number 125/11, 125/118, and 125/12 of Kadri village formed one compact unit, which was enclosed by a compound wall, where the defendant number 1 was running a piggery and poultry. He claimed that the building was constructed in the year 1990 after obtaining a license from the municipality. He thereafter obtained a license from the municipality to run a flour mill in the year 1979-80, which was renewed to the year 1994. He also claimed that he was granted permission by the Karnataka Electricity Board for installation of a 5 HP motor for the flour mill, and that he had sunk a bore well, to draw water for irrigating the coconut plantation raised by him in the suit property. Stop. He claimed that the suit of the plaintiff was barred by the law of limitation, and also that he had perfected his title to the suit property by adverse possession. So based on these rival contentions, the trial court claimed the following issues. The GP holder of the plaintiff was examined as PW1, who marked documents at exhibit P1 to P23, while the defendant number 1B was examined as PW1, while the GP holder of defendant number 2 was examined as DW2, and they marked exhibits D1 to P33. Full stop. Based on the oral and documentary evidence, the trial court held that the plaintiffs had established their title to the suit properties. Full stop. It also held that the decree obtained in OS number 331 of 1996 was behind the back of the plaintiffs, and that the defendant number 1 did not derive any title on the basis of the decree passed in OS number 331 of 1996. Consequently, it declared that the decree passed in OS number 331 of 1996, as well as the consequent lease deed dated 19/2/1997 and the sale deed dated 24/11/1997 did not bind the right title and interest of the plaintiffs. It also granted decree of perpetual injunction restraining the defendant number 1 and 2, the legal representatives of B1 and defendant number 2 from interfering with the possession of the plaintiffs, and also from putting up any permanent structure or creating any document in favor of any third parties in respect of the suit properties. Next para. Being agreed by the aforesaid judgment and decree, the defendant number 2 alone filed RA 90 of 2016. The First Appellate Court secured the records of the trial court, heard the counsel for the parties, and framed the following points for consideration. Copy. The First Appellate Court, considering the oral and documentary evidence, held that the decree obtained in OS number 331 of 1996 was fraudulent in as much as the same was done behind the back of the plaintiffs, and that the defendant number 1 had no right, title, or interest, and that the defendants in OS number 331 of 1996 had no right, title, and interest to concede to the claim of the defendant number 1, and therefore the decree passed in the said suit did not bind the interest, the right, title, and interest of the plaintiffs in the suit property. The First Appellate Court therefore dismissed the appeal and confirmed the judgment and decree of the trial. With being observed by the aforesaid judgment and decree, the present appeal is filed by the defendant number 2. The learned counsel for the defendant number 2 submitted that the suit properties were in the possession and enjoyment of the defendant number 1 from a substantive number of years, and therefore the defendant number 1 had perfected his right, title, and interest in respect of the suit property, and he thereafter, for consideration, transferred this said properties in favor of the defendant number 2. Full stop. The learned counsel submitted that the suit filed by the plaintiffs was highly belated, and there was no explanation for the delay in filing the suit. Next para. The perusal of the impugned judgment and decree passed by the trial court and the First Appellate Court indicates that the plaintiffs claimed that the defendant number 1 was a tenant in occupation of the suit properties. Full stop. The plaintiffs were absentee landlords, and taking advantage of their absence, the defendant number 1 in collusion with the defendant number 2 had brought about, the defendant number 1 in collusion with strangers had brought about a tolerable compromise in OS number 331 of 1996, whereby the defendant number 1, an imaginary right of the defendant number 1 was attempted to be solidified by a decree of declaration that the defendant number 1 is the owner of the suit property. Full stop. The plaintiffs were not parties to the said suit, and therefore this decree definitely did not bind the plaintiffs who are the owners of the suit properties. Full stop. In view of the categorical finding recorded by both the courts that the said decree did not bind the interest of the plaintiffs in the suit properties, the consequent sale deeds and the lease deed executed by the defendant number 1 in favor of the defendant number 2 did not certainly bind the plaintiffs. stop. The trial court and the first appeal court have examined the evidence, examined the oral and documentary evidence, and have recorded a clear finding of fact that the decree obtained by the defendant number one was fraudulent, and therefore this court does not consider it appropriate to disturb the findings of fact recorded by both the courts. Hence, his appeal lacks merit and is dismissed. Please come again. Please come again. Please come again. I couldn't follow.
One is the right second one is earlier action. In this case, the second intention was sufficient that depending on one of the action. In this case, the general power of the government is but the signature which is one of the as also the signature which is one of general power of are one and the same better as a disaster.
So, in the power of attorney, you are represented as a. So, in the partition, you are represented as power of attorney.
Yes. So, I have mentioned is that I have never fixed my signature about if I face that time.
So, what is the property that was allotted to you at the partition?
I was doing 60,000. My other was 60,000. That is when there is an advancement by my father was executes the partition stating that he has received 60,000. If I do trace back in time, the execution deed is also the general power of God is against family arrangement. This family arrangement resulted in another than 60,000. No signature either by me or my father.
So, who are these so many defendants? Who are these defendants?
The properties then have has four children. The property is to be divided by these four children and a family arrangement. Now the areas of these four children are on record.
Who are they? Who are they?
Plaintiff Meadows is Plaintiff Meadows is one of the daughters of
Putraju's daughter.
Granddaughter.
Putraju's granddaughter.
Yes.
But yes.
Plaintiff is Marthamma's granddaughter. Now the property is to be distributed between Marthamma, Sagar, Peace, and Jay. There is a family arrangement.
Please wait. Marthamma's children. Prabhakar is defendant number one. So who is defendant number? Please wait. Defendant number? Of Vijay Saroja.
Then five is
Samuel Satyakumar. Vijaya Vinaya. Samuel Satyakumar. Nine. The partition deed is executed between whom?
The partition deed is executed by the LRs of Marthamma, the LRs of P. Sundar and Devadana.
P. Sundar and Devadana Putra. What is the date of the partition?
The date of the partition is the date of 23 2000.
20?
23 2000.
The
general power of the economy is probably executed within 14 prior to this there is a family arrangement which refers to the partition.
Family arrangement is also marked. What is it? What does the family arrangement say?
The family arrangement says that Bhartama and Savarkama will receive 60,000 rupees, whereas T. Sundar and Devedana Putra will receive half share of the property. The property consists of.
Marthama is dead and gone.
Yes, sir. Bhartama is dead and gone. That is exactly the point.
So therefore, how can you claim partition?
I get it from Bhartama.
Correct. You Marthama does not dispute it, and suit is filed in the year 2013. It is after almost 11 years. So Marthama does not dispute the power of attorney. She does not dispute the partition. How can you dispute it? Well, there's a signature to the power of attorney. That is why. What is the date of the settlement?
The date of the settlement is 16,000.
16,000. That is when Marthama was alive. When did Marthama die? What the courts below have done is correct. What the courts below have done is correct. There is a family arrangement, which is what is which document?
This one is expecting 116. Because in this specification, the timing is page 18.
Who is the signature of Marthama?
There is no signature of Marthama.
Who is Margaret? Who is Margaret?
One of the daughters of the wife of
Marthama, she is not signed.
Marthama is not signed. Only Savarkama, T. Sundar, and Devedana. There are only 6 signatures.
Issue notice. Please take out notice.
My lord, I appear for the appellant in this matter. My lord, it is a suit for specific performance. My lord, defendant's appeal. The trial court has decreed the suit, and lower first appellate court has also confirmed that judgment. My lord. The agreement has not been disputed. The execution of the agreement has not been disputed. However, the defense of the defendant is, my lord, the transaction, my lord, is a loan transaction. The defendant number one has received the 5 lakhs rupees from the plaintiff respondent. For the security, he has executed an agreement in respect of the property of the family. This loan has been availed by the defendant for construction of a house. My lord, he has also said, along with the agreement, he has given 3 checks, and that has been admitted by the plaintiff in the cross-examination also. In the written statement, very specifically said, the defendant has given 3 checks apart from this agreement in order to security. My lord, the defendant, the plaintiff. Please, my lord,
please read that portion where he says
judgment at page number 28, internal page number 12 of the lower appellate court judgment, my lord. It has been my lord, the second para after the Kannada portion. Admittedly, the defendant is not having scrap of paper to show that the borrowed loan from the plaintiff, and he has executed a P1 as security to the loan. The defendant claimed that after receipt of the legal notice, as per Exhibit P3, defendant approached the plaintiff and paid an interest of rupees 50,000 to the plaintiff. As already discussed, the defendant are not having any document support this contention. Apart from it, DW1 was unable to disclose the source of payment of 50,000 interest to the plaintiff. It is specific defense of the defendant that the defendant number one had constructed a house at Bangalore in site standing in the name of his brother. In order to discharge the loan taken construction of house, he borrowed a loan from the plaintiff. In order to demonstrate the construction of house, defendant number one has produced and marked the receipt of building materials, which are marked as D4 to D14. On careful perusal of so and so, forthcoming, it is forthcoming. Serial number of invoice is from 127 to 129. My lord, thereafter, my lord. Please, my lord. Please, my lord.
You say something and you read something else.
Please, my lord.
Check book there.
One moment. At trial court judgment, my lord, sorry, my lord, at page number 50, my lord, in the trial court judgment. Sorry, my lord. The other defense put forth by the second line, my lord, put forth by the was the retention of the 3 checks. There is serial number bearing so and so. During the cross-examination, PW1, he had admitted the receiving of 1 check. Mere retention of check cannot be a good ground to disbelieve the case of the plaintiff. My lord, in the cross-examination, this is the statement of the my lord plaintiff. I will read from the cross-examination, my lord. ಅದೇ ಸಾಲದ ವಿಚಾರಕ್ಕಾಗಿ ಭದ್ರತೆಗೆಂದು ಕರಾರು ಪತ್ರವಲ್ಲದೆ 1ನೇ ಪ್ರತಿವಾದಿಯಿಂದ ಅವರ ಖಾತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಖಾಲಿ ಚೆಕ್ಕುಗಳನ್ನು ಪಡೆದಿದ್ದು ಅದರ ಸಂಖ್ಯೆ 317653 ರಿಂದ 55 ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ಮದ್ದೂರಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು ಆಗಿದೆ ಎಂದರೆ ಸಾಕ್ಷಿ 1 ಚೆಕ್ಕು ಸಾಕ್ಷಿ 1 ಚೆಕ್ಕು ಪಡೆದಿದ್ದೇನೆಂದು ನುಡಿಯುತ್ತಾರೆ. So, my lord, it was executed for the purpose of loan.
Why was it taken? What is the further?
It was a blank check.
What was the cross-examination? Why it was taken?
My lord, in order to the interest portion, my lord, what happened? I have received 5.
Are you saying this or should the witness say this?
The PW1 plaintiff admits.
Have you cross-examined further?
It is in the cross-examination. It has been suggested to them.
Please understand what I am trying to ask from you.
Please,
madam. 1 check he received from you.
Please, madam.
For what did he receive? What is the cross-examination?
Mail-in sentence ali, that is the suggestion, my lord. Pura sentence ಓದ್ತೀನಿ. ಅದೇ ಸಾಲದ ವಿಚಾರಕ್ಕಾಗಿ 5 ಒಂದು ಲೈನ್ ಮೇಲಿಂದ ಓದ್ತೀನಿ. ಕರಾರು ಪತ್ರವನ್ನು ಬರೆಸಿಕೊಂಡಿದ್ದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ 5 ಲಕ್ಷಕ್ಕೆ ಪ್ರತಿ ತಿಂಗಳು 1% ಬಡ್ಡಿ ಕೊಡಲು ಮಾತುಕತೆಯಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅದೇ ಸಾಲದ ವಿಚಾರಕ್ಕಾಗಿ ಭದ್ರತೆಗೆಂದು ಕರಾರು ಪತ್ರವಲ್ಲದೆ 1ನೇ ಪ್ರತಿವಾದಿಯಿಂದ ಅವರ ಖಾತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಖಾಲಿ ಚೆಕ್ಕುಗಳನ್ನು ಪಡೆದಿದ್ದು ಅಂದರೆ ಸಂಖ್ಯೆ 317653 ರಿಂದ 55 ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ಮದ್ದೂರಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು ಆಗಿದೆ ಎಂದರೆ ಸಾಕ್ಷಿ 1 ಚೆಕ್ಕು ಪಡೆದಿದ್ದೇನೆಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಚೆಕ್ಕು ಸಂಖ್ಯೆಗಳ ಪೈಕಿ ಯಾವ ಚೆಕ್ಕು ಸಂಖ್ಯೆಯನ್ನು ಪಡೆದಿದ್ದೇನೆ ಎಂಬ ಬಗ್ಗೆ ಈಗ ನೆನಪಿಲ್ಲ.
ಏನಕ್ಕೆ ತಗೊಂಡಿದ್ದು?
Please, madam.
For what, Mr. Was it towards refund of the loan? Was it towards
No, my lord.
interest?
No, my lord. No, my lord. In order to establish that the transaction, the receiving of 5 lakhs is not a sale out and out. It is only for security of that amount which was received under the agreement. In order to repay the interest, he has taken the 3 checks also. That is the contention of the defendant.
How does the trial court deal with this evidence?
My lord, the trial court says mere such defense will not give rise to negate the agreement. My lord, ಅದೇ ಪ್ಯಾರಾದಲ್ಲಿ page number 50 ಅಲ್ಲಿ under middle allide, under such circumstances the defense although raised are in my opinion not sufficient to disprove the contents of the exhibit P1. Exhibit P1 has been admitted by the defendant also.
What is this legal notice antala?
Legal notice he has issued. The court has held. I have not replied at the time of before approaching the court to file the written statement.
The trial court speaks of some criminal notice. What is this criminal notice?
It is not criminal notice. It is a legal notice, I believe. One more thing is, my lord, it is only the property available to the defendant. That is what he has pleaded. In the hardship has not been considered. It is the contention of the defendants, my lord. The property, please.
Vikas M. Passover. Shivananda. ಅಪೆಲೆಂಟ್ ಅಂದ್ಮೇಲೆ ರೆಸ್ಪಾಂಡ್ ಅಂತ ಹೇಳಿ, ಅಪೆಲೆಂಟ್ ಅಂದು ಪ್ಲೈಂಟಿಫ್ ಅಂದು ರೆಸ್ಪಾಂಡ್ ಅಂದು ಡಿಫೆಂಡ್ ಅಂತ ಎಲ್ಲೆಲ್ಲ ಹೋಗ್ಬೇಡಿ. ಐ ಪ್ಲೀಸ್ ಸ್ಟಿಕ್ ಟು ದ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. What is the sale date of the sale agreement? 1985. The suit is filed in 92. 92. One-third share ಅಂತಾರೆ. Notice.
I represent the appellant, my lord. Is fifth defendant's appeal, my lord. Suit for partition. Suit for partition filed by the respondent 1, my lord. My lord, the plaintiff's contention was that the suit properties are all ancestral properties belonging to the family, and he sought for 1/7 share, my lord. The fifth defendant's contention was item number 1, was already sold in 1981 as per exhibit D27, my lord, to one Rudrappa. Item number 1, my lord, as per D27, and it is not available for partition.
ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ಯಾರು?
Iವರು father, dependent one, karta of the family, and as a minor guardian of children. That is not in dispute, my lord. He had sold several properties, my lord, belonging to the family. That is admitted. D27, my lord, produced by the
D27
sold item number 1, my lord.
Correct. ಆಮೇಲೆ
and as far as D12 and 13 to one Rudrappa.
ರುದ್ರಪ್ಪ ಇಂದ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತು?
ಅಲ್ಲ, Rudrappa has purchased it. By mistake, my lord, is this defendant's name has been mutated as Pavati Varasa. It was a mistake on the part of revenue authorities. That is one aspect.
ಸಂಬಂಧ ಇಲ್ವಾ?
ಆಗ ಏನು ಸಂಬಂಧ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದು.
Then why did you file an appeal then?
My lord, he has added properties which are not belonging to the proper family, and not added properties which belong to the family, my lord. And item numbers 12 and 13, my lord, 12 and 13 belong to exclusively to this appellant, because it was got from the panchayat, my lord, as per exhibit D23 and 26, my lord. As per exhibits D24 and 25, my lord. It stands in his name exclusively. And that apart, my lord, there is one more property, my lord, in Kolar, which was purchased by defendant 5, my lord, from the family nucleus, my lord. In fact, my lord, D13 is the mutation extract. The trial court said that no record is produced. In the lower appellate court, my lord, the appellant, my lord, filed application under order 21 rule 47, my lord. And after filing of the application, the plaintiff files an application, my lord, under order 6 rule 17 before the lower appellate court, seeking to amend the plaint and add that property as proper item number item number 14, my lord. That has been allowed. Notice, my lord.
Notice.
My lord, I sought for stay, my lord.
ಹೋಗ್ ಬರ್ಲಿ, ನೋಟಿಸ್ ಹೋಗ್ಬೋದು.
ಅಲ್ಲ, FDP ಯಾಕೆ ಇದಾಗ್ತಾ ಇದೆ, ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
ಆಯ್ತು, FDP, if you say that there is already a commissioner's report submitted, then will stay. Commissioner report submit ಆಗಿದೆ ಅಂತ ಹೇಳಿ stay ಮಾಡ್ತೀನಿ.
ಪೋಸ್ಟ್ ಮಾಡೋದು ಆಗೋದೇ ಕಷ್ಟ ಸ್ವಾಮಿ, ಅದರಿಂದ.
ಸರ್, ನಾವು ಪ್ರೋಸೆಸ್ ನಿಮ್ ಕೈಲಿ ಕೊಡ್ಸೋದೇ ಕಷ್ಟ ಆಗಿದೆ.
ಇಲ್ಲ,
ಪ್ರೋಸೆಸ್ ಕೊಡೋದಿಲ್ಲ ಸರ್.
ಇಮಿಡಿಯೇಟ್ಲಿ ಪ್ರೋಸೆಸ್ ಕೊಡ್ತೀನಿ ನಾನು.
ಫಸ್ಟ್ ಕೊಡಿ, ಅದಕ್ಕೆ ನಾವು ನಿಮ್ಗೂ ಟೆಂಟರ್ ಬುಕ್ಸ್ ಅಲ್ಲಿ ಇಟ್ಟಿರ್ತೀವಿ. ಪ್ರೋಸೆಸ್ ಕೊಡ್ಬೇಕು ಅಂತಾನೆ ಈ ತರ ಮಾಡ್ತಿರೋದು. ಬೇಗ ಪ್ರೋಸೆಸ್ ಕೊಡ್ತೀರಾ, ಬೇಗ ಸರ್ವ್ ಮಾಡಿಸ್ತೀರಾ. ಎಸ್. Appeal is by the defendant number 2. Suit is for what? What has happened? Plaintiff has not filed any appeal. So in respect of item number 3, 20 and 21, ಅದು ಅವರೇನು ಹಾಕಿಲ್ವಾ? Please wait. Who is this Venkatesh Ayya? Purchaser? Venkatesh. Venkatesh Iyer, son of late Venkappa. Is the different number 1. Is Venkatesh Iyer and Venkatesh are one and the same person? Really, yeah. How did you prove the partition? How did you prove it? ಪಂಚಾಯತಿ ಪಾರಿಕತ್ನ ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡಿದಿರಾ? ಆಯ್ತಪ್ಪ, ಈ ಡಿನೈಡ್ ಪಾರಿಕತ್ ಪ್ರಕಾರ ನಿಮ್ಗೆ ಈ ಶೇರ್ ಹೋಯ್ತು, ನಿಮ್ಗೆ ಈ ಶೇರ್ ಹೋಯ್ತು. ಏನಂತ ಖಾತೆ ಚೇಂಜ್ ಆಗಿದೆ? ಮ್ಯುಟೇಷನ್ ಏನಂತ ಆಗಿದೆ? ಎಕ್ಸಿಬಿಟ್ D13 and D14 ನೋಡಿ ಏನಂತ ಭಾಗ ಅಂತಿದ್ಯಾ? ಭಾಗ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು. ಭೌತಿಕ ಆಯ್ತದೋ ಪಂಚಾಯತಿ ಪಾರಿಕತ್ ಅಂತ ಏನೋ ಇದೆಯಾ ಮ್ಯುಟೇಷನ್ ಅಲ್ಲಿ? ಎಕ್ಸಿಬಿಟ್ D13 and D14 ಮತ್ತೆ ಹೆಂಗಾಗುತ್ತೆ? Plaintiff has not challenged the trial court has disbelieved your contention. Why this share is not given in item number 3, 20 and 21? It's sold by defendant number 2. I sold it to item number 3, 20, 21 ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಭಾಗ? D2 not D1 na. D2 is Timmegowda. Timmegowda na Venkatesha. ಅದರಲ್ಲಿ ಏನಾದ್ರು ಭಾಗದ ಬಗ್ಗೆ ಬರ್ದಿದ್ಯಾ ಸೇಲ್ ಅಲ್ಲಿ? Yes. ಶೇರ್ ಕೊಡ್ಬೇಕಿತ್ತಲ್ಲ ಐಟಮ್ 20 ನಲ್ಲಿ ಕೊಡ್ಬೇಕಿತ್ತಲ್ವಾ? ವೈ ಅಡಿಷನಲ್ ಇಶ್ಯೂ and finding ಏನಪ್ಪ? Admittedly, the fifth defendant is a purchaser of item 20 and 21 from the second defendant. Contention of the fifth defendant that she is a bona fide purchaser. No evidence is produced. Therefore, this issue is not proved by the fifth defendant. Then partition ಕೊಡ್ಬೇಕಿತ್ತಲ್ಲ ಈ ಐಟಮ್ ಅಲ್ಲಿ. Huh? Yes. ಇದೆ 59 ಅಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 12 ಅಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ 25 is not produce any documents in respect to sheet item 19 to 21. But different number 2 ಸೇಲ್ ಮಾಡಿದಾರಲ್ಲ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಬಂತು? ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ways of finding about that? Ways of finding that this item number 3, 20 and 21 are the self-acquired properties of defendant number 2. Ways of finding. At 2:30. Sorry.
The Lordship's kind permission, my lord. May I submit, my lord? Serial number 8, my lord, which is listed before your lordship. Last occasion I submitted, office objections is complied. There's a matter to be taken for admission, my lord. This honorable court has to clear the office objections, my lord, because office is not ready to clear it, my lord. The office objections, my lord. I have written a note also, my lord, to that extent.
How do I clear the office objections?
My lord, office is telling they cannot do it. We have cleared it already from our side, my lord. It may be taken up tomorrow. I'll clarify physically with my lord.
Please, number 8 and 10.
8, RSA 140, my lord.
Yeah, for India. Huh? Yeah, what are the office objections?
That the trustees who are no more, their legal has to be brought on record. As it is a public trust, it is not in public interest. It is not a private. So I've written the note on that.
This is objection.
The Lordship may kindly see, my lord, the office objection is one Narayan Bhatt is no more, who's a trustee. Ishwar Bhatt and
Narayan Bhatt or Ishwar Bhatt?
Ishwar Bhatt, sorry, my lord. Ishwar Bhatt, who's a party in a capacity of trustee, he's not in personal capacity. So his legal heirs need not be brought on record, my lord. With the public trust. So that is one office objection, my lord. Another one is Srinivasan, who is also in a capacity of a trustee. His legal also heirs cannot be brought on record, my lord. So that has to be overruled by this court, my lord. And IA1, which I filed, my lord, I'm not pressing for that IA. This also the office cannot overrule that, my lord. And the NOC Wakalat of the other advocate which has been filed, he was bedridden, so I've given a medical certificate that he couldn't sign it. And only thumb impression he has put. These are the
objections. Office objections raised at the open to be considered later.
Matter may be taken up for admission, my lord.
Now 50. 53 at the request of the council for appointment just after vacation. After vacation.
For admission, my lord.
Yeah, next week allow. Yes, tomorrow.
Court officer. Madam. Hello. Court officer. Sir, serial number 55 adjourn ಆಗಿದೆ ಸರ್. Sir. Court officer. Court officer. Serial number 55 adjourn ಆಗಿದೆ ಸರ್. Hello. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳುತ್ತಾ?
ಸರ್ ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಅಜರ್ನ್ ಆಗಿದೆ ಸರ್. ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. 55 55
ಇದೆ ಸರ್.
ಇದೆ ಅಲ್ಲ ಮಧ್ಯಾಹ್ನ
ಇದೆ.
ಸರ್. ಓಕೆ ಓಕೆ ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
plaintiff. ಏನಂತ? The suit is filed for what? Partition. ಏನಾಯ್ತು? ಯಾಕಂತ ಕೊಟ್ಟಿಲ್ಲ, ಶೇರ್ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? $350 is proved. True ಆಗಿಲ್ವಾ? Where's the finding regarding item number 320 and 24? Finding it. Item number 3 is not standing in the name of any of the members of the plaintiff. Plaintiff not produce any documentation. Yes. What is your now? What is your case? ಧೈರ್ಯವಾಗಿ ಹೇಳ್ರಿ. ಜೋರಾಗಿ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ. How you have proved the ಪಾಲುಪಟ್ಟಿ? ಪಾಲುಪಟ್ಟಿನ ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡಿದಿರಾ? This appeal is filed by the defendants 1 and 2, OS number 136 of 2012, challenging the concurrent finding of fact of both the courts. The plaintiff is entitled to and share in the suits properties. The partition in court is referred to as the right for the trial. The plaintiff contended that he and the defendants 1 to 4 are the children of Venkatappa, who was the proprietors of a joint family, which owned the properties mentioned in the suit. Full stop. Suit has B schedule property. Full stop. The B schedule properties were purchased by Venkatappa out of the income generated from the A schedule properties. He claimed that the revenue records of the A schedule properties stood in the name of his grandfather Govindaya, and it was not changed to the name of Venkatappa. Till Venkatappa died in the year 1994, the Sur properties were managed by him as the Karta. Full stop. It is claimed that the Sur properties were not partitioned, therefore continued to be the family properties of the plaintiff and defendant 1 to 4. The plaintiff was a government employee, and therefore he could not apply himself for the upkeep and management of the joint family properties. He claimed that he retired in the year 2006, and then he came to know that the defendants 2 and 3 were making arrangements to alienate the Sur properties. Full stop. It was then that the plaintiff realized that based on concocted documents, the defendants 2 and 3 had managed to change the revenue entries of the Sur properties to their names and were attempting to alienate the Sur properties behind his back. An attempt made by the plaintiff for amicable settlement through a panchayat that was convened proved futile. Hence, he filed a suit for partition and separate possession of his share in the social properties. Next para. The defendants 1 to 4 filed a written statement and admitted the relationship between the plaintiff and defendants, plaintiff and them. Full stop. They also admitted that the issued properties were the properties of the grandfather of the plaintiff and defendants 1 to 4. However, they claim that during the lifetime of their father, they had divided the Sur properties in terms of a panchayat parikat dated 20th of April 1981. And full stop. They claim that this partition was acted upon and the parties were put in separate possession and enjoyment of their respective shares. Full stop. They claim that as per the desire of Venkatappa, no property was allotted to the share of the defendant number 4. Full stop. The defendant number 4 did not claim any share in the Sur properties. Full stop. During the pendency of the suit, the defendant number 5 was impleaded at the instance of the plaintiff, since she had purchased suit item number 20 and 21 from the defendant number 2 in terms of a sale deed dated 25/7/2007. Full stop. The defendant number 5 claimed that she had demolished the old house situated in the property purchased by her and had constructed a
Wait, where?
Therefore, she claimed that she is the owner of suit item number 20 and 21, and the plaintiff is not entitled for a share therein. Alternatively, she prayed that suit item number 20 and 21 be allotted to the share of the defendant number 2 in the event of the suit being decreed. Based on these rival contentions, the trial court framed the following issues. The plaintiff was examined as PW1 and remarked exhibits P1 to P16. The defendant number 2 was examined as DW1 and he produced the marked documents as exhibit D1 to D15. The defendant number 3 was examined as DW2, who marked documents as exhibit D16 to 18. Full stop. The defendant number 5 did not enter the witness box. Based on this oral and documentary evidence, the trial court held that the plaintiff had not proved that suit item number 3 was not the property which belonged to the joint family. Likewise, it held that the suit item number 20 and 21 for the joint family ancestral properties of the plaintiff and defendants 1 to 4, and thus decreed the suit in part and declared that the plaintiff is entitled to 6/25th share in the suit items 1, 2, 4 to 15, 17 and 18. Stop. Next, being agreed by the aforesaid judgment and decree, the defendants 1 and 2 filed RA 329 of 2018. The first appellate court said, you filed some application, isn't it? Did you file any application before the first appellate court? The first appellate court secured the records of the trial court, heard the counsel for the parties, and framed the following points for consideration. Topic. First appellate court held that the defendant number 2 that the defendant number 2 relied heavily on the Panchayat Parikat at Exhibit D15, but the said document did not contain the signatures of the plaintiff and defendant number 3. At page numbers 1 to 4 of the said document, it further held that the evidence of DW2 disclosed that the partition deed was created for the purpose of denying the plaintiff of his share in the suit property. Therefore, the first appellate court held, based on the oral and documentary evidence, that the defendants 1 and 2 were not able to prove the execution of the Panchayat Parikat will stop. Therefore, the first appellate court held that since the defendants 1 and 2 had admitted that the suit properties were joint family properties, the first appellate court held that the judgment and decree passed by the trial court was proper and did not require interference, and hence dismissed the appeal. Being agreed by the aforesaid, the defendants 1 and 2 have filed the present second appeal. Next paragraph. The learned counsel for the appellant submitted that Exhibit D15 was a document which contained the signature of the father of the plaintiff and defendants 1 to 4, and therefore, the trial court and the first appellate court did not consider this relevant fact. Stop. He also submitted that the suit item number 20 and 21 had fallen to the share of the defendant number 2, and that he had disposed it off to the defendant number 5, which fact must have weighed in favor of the defendants. Stop. He further stated that except the self-serving contention of the plaintiff that the suit properties were joint family properties, he did not place any convincing material before the trial court. The learned counsel invited the attention of the court to the finding recorded by the trial court at page number 19, where the trial court held that the plaintiff had not produced any document in respect of suit items 19 to 21. And therefore contended that the trial court committed an error in declaring the suit next para. I considered the submissions made by the learned counsel for the defendants 1 and 2. I perused the influence judgment and decree passed by the trial court in the first application, and also perused the grounds of appeal. Stop. Next para. It was the case of the defendants 1 and 2 before the trial court that the properties of the family were partitioned in terms of Exhibit D15. It was not his case, it was not their case, that the suit properties were not the subject matter of Exhibit D15. Stop. The trial court and the first appellate court have concluded that that the defendants 1 and 2 did not adduce convincing evidence to establish the lawful execution of Exhibit D15. Even otherwise, the signature of the plaintiff is found on only one page of the Panchayat Parikat. Therefore, the trial court found it to be suspicious. Full stop. It also found from the revenue records that the partition was not acted upon. That way of the matter, the trial court and the first appellate court were justified in declaring the suit. I do not find any merits in this appeal, hence the appeal is dismissed. Sir?
What the court will not see the hearing petition. Procedural document secretary but we not in a kindly alternate court. Yes, they will be permitted to get use of it in the length of the admin question. But you are not putting possession. Is how the seventh court says.
How did you enter possession?
Actually, the partition I get this property. And in the meanwhile, subcleaner, immediately his family member, a real deed was executed between me and my father. And thereafter, the position was not handed over, we continue to be in possession of the property. And that has been admitted the earlier suit by the brother. Now we not really take just to read this, or we are not explaining. I have 20 of these custom record. In the event of the above material available on the card, the learner educated basically argued that except one legal error of the defendant, the other defendants are not contesting the case. He argued that the other defendants are not contesting only because they admit they did the defendant.
Where are reading paragraph?
Paragraph 20 of the first report.
In this regard, I have produced the judgment of the Honorable Trial Court in the Surat.
Later, page 16, page 51.
That is trial court judgment.
The first report.
One is,
Sir,
51 is trial. Page 51 is trial court judgment.
Paragraph 16.
ಇಲ್ಲಿ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
The radio statement filed by University Law in OS 16 of 1981 and argued that the defendant for one arbitrated possession for the hidden properties. As such, the plaintiffs are entitled to execute the suit. In this regard, I have proposed exhibit B40, where the defendant is the suit, who is the father of the defendant of this suit, was that he executed a document dated 7/4/1953 in favor of that suit, who is the father of the plaintiff, the defendant. Permitting him to enjoy the ease realized from the suicidal property for maintenance till his death. Now, whether this can be construed that we are in possession of property, because
When did it
they
become
have not produced any document to show that they have taken back the possession of us. So
So
therefore,
what happened to that suit?
that suit was ultimately dismissed for want of possibility.
The suit is for what?
That suit is for the
Pension. Then you lost it.
this is not this is good for declaration and injunction. Now, declaration in respect of perfecting my title by way of purpose. So far as that is concerned, then we
ಬರ್ಕೊಳ್ಳಿ.
yes, without the position.
Sir, you ಆಗ್ಲಿ you lost the suit in 81. ಯಾವುದು? Yelloji Rao was the defendant in that suit. He was the defendant in that suit, sir. 16 of 81 was filed by you. ಮತ್ತೆ ಆ ಸೂಟ್ ಹೋಯ್ತಲ್ಲ ಅದು ಹೋಯ್ತಲ್ಲ. You did not pursue that suit. ಅದು
ಆಮೇಲೆ ನಮ್ಮೆಲ್ಲ ಯಾರು ಪಾಸ್ಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. Another suit was filed by the Ellas of the plaintiff who was cited by
again is your brother ಪ್ರಾಪರ್ಟಿನೂ ಅಡಾಪ್ಟ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ನಾವು ಬಿಟ್ಕೊಟ್ಟಿದ್ದ ಪ್ರಾಪರ್ಟಿ ನಾವು ಬಿಟ್ಕೊಟ್ಟಿದ್ದ
ಬಿಟ್ಕೊಟ್ಟಿದ್ದಲ್ಲ ಸರ್, ನೀವು ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ. ಸೊ ರಿಲಿಂಕ್ವಿಶ್ This appeal is filed by the unsuccessful plaintiffs challenging the judgment and decree of the trial court in OS number 30/1992, which was confirmed by the first appellate court in RA 46 of 2017, by which both the courts dismissed the claim of the plaintiffs for declaration of their title to the suit property by adverse possession. Next para. The parties shall henceforth be referred to as they were arraigned before the trial. Next para. The plaintiffs claim that the suit properties were the ancestral and joint family properties of the plaintiff's father, bracket Ramoji Rao, and defendant's father, Yelloji Rao. Full stop. It is claimed that the father of the plaintiffs executed a relinquishment deed dated 5/12/1952 in favor of the father of the defendants. However, the possession of the suit property was not delivered even after the execution of the relinquishment deed. Sir, Kutkoli, even after the execution of the relinquishment deed, and that the plaintiff's father, mother, and the plaintiffs continued in possession and enjoyment of the suit properties. Full stop. Thereafter, the father of the plaintiffs died on 13/3/1981, and the plaintiffs and their mother continued in possession and enjoyment of the suit properties. The plaintiffs claimed that they were growing ragi, paddy, and other crops in the suit properties, and that they were in possession of the suit properties for more than 20 years, and that they had perfected their title to the suit properties by adverse possession. They alleged that the defendants were strangers to the suit properties, and they had no subsisting right, title, or interest therein. And thus, full stop. Nonetheless, the defendants, colluding with the revenue officials, had managed to get their names entered in the revenue records. Therefore, the plaintiffs claimed that the defendants had denied the title of the plaintiffs over the suit properties, and hence sought for a declaration that they had perfected their title to the suit property by adverse possession, and also sought perpetual injunction to restrain the defendants from interfering with their possession and enjoyment of the suit properties. Next para. Initially, the defendants 1, 6, and 7 appeared before the court and filed a memo on 10/3/1992 stating that they have no objection to decree the suit. Thereafter, the defendant number 1 appeared before the court and filed an affidavit stating that he had not consented to decree the suit, and that the defendant number 7 and 9 had falsely impersonated him before the trial court. The defendant number 1 contended that the plaintiffs were residing at Bangalore and Linga Devara Palya, which were far away from the suit properties. Further, they claimed that their father was enjoying the suit properties after the execution of the release deed in the year 1952. They denied the contention that the plaintiffs were in adverse possession of the suit property. Based on these rival contentions, the trial court framed issues and set down the case for trial. The plaintiffs were examined as PWs 1 to 3 to mark exhibits P1 to P35, while the legal representative defendant number 1 was examined as DW1, and he marked exhibits D1 to D47. Based on the oral and documentary evidence, the trial court held that the plaintiffs had not proved that they were in possession of the suit property after the execution of the relinquishment deed. The trial court noted from the revenue records that it was the defendants who were in possession of the suit property. Thus, dismissed the suit. Since the plaintiff had not established the requirements of a claim for adverse possession. Being agreed by the aforesaid judgment and decree, the plaintiffs filed RA 46 of 2017. The first appellate court secured the record for the trial court that the counsel for the parties framed the following points for consideration. The first appellate court held that the plaintiffs had failed to prove that they were in adverse possession of the suit's real property. Properties or property now? Suit's real properties. Stop. It also held that the plaintiffs had failed to prove that they were in possession of the suit property as on the date of the suit, and hence dismissed the appeal and confirmed the judgment and decree of the trial court. Feeling ignored by the aforesaid judgment and decree, the present second appeal is filed. Next para. Right. Next para. The learned counsel for the plaintiff submitted that the plaintiffs had earlier filed, plaintiffs had earlier filed OS number 16 of 1981 for perpetual injunction in respect of the suit properties against the father of the defendant, against the defendant number 1. Stop. He submitted that they said suit. He submitted that Exhibit D40 was the written statement filed by the defendant number 1 in the said suit, where he admitted that he had executed an agreement dated 7/4/1953 in favor of the plaintiff, permitting the plaintiff to enjoy the yield realized from the suit's real properties for his maintenance till his death. Full stop. He therefore submitted that the defendants have admitted that the plaintiff was in possession of the suit's real property and that there was no contra evidence to establish that the possession was recovered back by the defendants. Next one. The full stop. He also submitted that the earlier suit, the suit in OS number 16 of 1981 was dismissed for non-prosecution. Non-prosecution was dismissed for not taking steps to bring the legal representatives. Why was it dismissed? Dismissed as it was not prosecuted effectively. Full stop. However, he submitted that the plaintiff have continued in possession and therefore the trial court must have decreed the suit for perpetual injunction against the defendant. Next one. The perusal of the impugned judgment and decree passed by the trial court and the first appellate court makes one point clear, namely that the plaintiffs and defendants were claiming independent title with respect of the suit properties by virtue of the relinquishment deed executed by the father of the plaintiffs in favor of the father of the defendants. Full stop. The perusal of the relinquishment deed, as noted by the trial court, indicates that the possession of the property relinquished was delivered to the father of the defendants. Full stop. It may be that as per Exhibit D40, the plaintiff was permitted to utilize the usufructs from the suit properties for his maintenance till his death. However, that in itself would not create any interest in the suit's real property, and the plaintiff cannot claim that he was in possession of the suit's real properties. Full stop. Since the plaintiff did not establish the requisites for proving the case of adverse possession, about the trial court and the first appellate court were justified in dismissing the claim. Full stop. Since there is nothing on record to establish that the plaintiffs are in possession of the suit's real properties, the trial court and the first appellate court were equally justified in dismissing the suit as regards the relief of injunction. No merit in this appeal and dismissed. Without giving opportunity, ಏನ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು? ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ನೋ ಅಂತ ಹೇಳಿ ಹಿಂಗಿಂಗ್ ನಾಟ್ ಫೈಲ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ವಾ? ನಾಟ್ ಆಪರ್ಚುನಿಟಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿಲ್ವಾ? ಆಯ್ತು, ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳ್ರಿ. Whatever the defendant. ಎಲ್ಲಿ ಹುಡ್ಕೋಬೇಕಲ್ಲ ನೀವು? ನಿಮ್ ಪ್ರಾಪರ್ಟಿಗೆ ಅವ್ರದ್ದು ರೈಟ್ ಇಲ್ಲ. No, Mr. Please understand. Plaintiffs have nothing to do with the property of the defendant. Defendant को grant आगे. Then you challenge the order of grant made in favor of the defendant. Defendant ತಂದೆಗೂ grant ಆಗಿದೆ.
And after the grant, he has to they are trying to make it.
ನಿಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್?
6 only.
6 ಒಳಗೆ at that time 6 ಅಲ್ಲ ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಡಿಫೈನ್ಡ್ ಎಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿರೋದು? 6 ಅಲ್ಲ. ಅಲ್ವಾ? ಆ ಬ್ಲಾಕ್ ನಂಬರ್ ಎಲ್ಲಿ ಪ್ರೂವ್ ಮಾಡಿದ್ರಿ ನೀವು? ನಿಮ್ಮ ಬ್ಲಾಕ್ ಯಾವುದು ಅಂತ ಎಲ್ಲಿ ಪ್ರೂವ್ ಮಾಡಿದ್ರಿ ಮಿಸ್ಟರ್? ಗ್ರಾಂಟ್ ಮಾಡುವಾಗ ಒಂದು ಸ್ಕೆಚ್ ಕೊಡ್ತಾರಾ? ಗ್ರಾಂಟ್ ಸ್ಕೆಚ್ ಇಲ್ಲಿ. Where have you produced a grant sketch? ಎಲ್ಲಿದೆ ಗ್ರಾಂಟ್ ಸ್ಕೆಚ್ ತೋರಿಸಿ. ಗ್ರಾಂಟ್ ಸ್ಕೆಚ್ ಇಲ್ಲಿದೆ. Mister, I asked you grant sketch ಎಲ್ಲಿದೆ ಅದು? ಮಾರ್ಕ್ ಆಗಲಿ, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಮಾರ್ಕ್ ಆಗಲಿಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡದೆ ಹೊರತು ಹೌ ವಿಲ್ ಯು ಐಡೆಂಟಿಫೈ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಯಾರ್ದು, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಯಾರ್ದು? ಫಾರ್ ವಾಟ್ ಮಿಸ್ಟರ್? ಅಲ್ಟಿಮೇಟ್ಲಿ ಏನಾಗುತ್ತೆ? Notice. Know what happened. If you want, I can dictate the judgment right now if you want. COVID give it ಅಂತ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೆ ನೋಟಿಸ್ ಅಷ್ಟೇ. First respondent
filed a suit for procedural against the respondent number 2, Kelly, as well as against the appellant. Appellant is the purchaser of the suit to the respondent number 3. That is different. But I have purchased the property on 5/1/2013 by way of registered sending. It's an agricultural property. It has a subsidy. And 28/2013.
So when did you purchase?
But I have purchased this property on 5/1/2013. Executed the registered certificate made for a very respondent. The plaintiff has filed a suit by fabricating the document, the agreement of sale, and 28/2013. Alleging that the respondent has executed the agreement on 29/4/2006. An enhancement was made on 29/4/2008 and 19/4/2008. On the basis of that plan, the fabricated agreement was dismissed. And so was decreed before the plaintiff. Then appeal was filed. But without considering the appeals of the staff, informed the court of the admit of the trial. We conclude with this matter before first and foremost, once it is the suppose this is a specific
for how much did you purchase?
But I have purchased for 5 lakhs.
Yes.
So 2006. According to them, the agreement was executed in 2006. Adjacent to another owner. He has paid a part payment on the 2006. 2006. And he has, according to them, he has paid a month of part payment on 2008. Then 2010. But this document has been created. But exactly what I'll be comparing to the suit is not cancellation of selling, right? Because it's required. Cancellation. When the plaintiff is disclosed that this two property was sold, and it is in his knowledge that the suit, the selling has been executed in between the but it is required to seek cancellation of selling. Right. Because the Supreme Court just provides that. Also, yeah, that's it. This is a bit of order. That's 17 in the last the distance in this group is not other. Firstly, Noted. So aware of two conventions. There is a two conventions of the same property. The plaintiff did not ask for their cancellation. This again would stand in the way of the clear discussion about unless the same made by the different one, different two, and thereafter by the different two to different three.
Sir, you are made a party in the suit. Specific performance ನಿಮ್ಮ ಮೇಲೆ ಕೊಟ್ಟು ನೀವು ಸೇರ್ಕೊಂಡೆ ಕೊಡೋದಲ್ವಾ? You will be asked to join in the execution of the sale deed. ನಿಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಲ್ವಾ ಕೇಸಲ್ಲಿ? ಅರ್ಥ ಏನು? ಕ್ಯಾನ್ಸಲೇಷನ್ ಏನಕ್ಕೆ ಬೇಕು? ನಿಮ್ಮನ್ನ ಸೇರಿಸಿದಲ್ಲ ಕೇಸಲ್ಲಿ. Really at 1964 is 60. There are two 1964 is.
There is a two instruments. There is a same purpose. But one instrument, there is no, the instrument executed this. It is required to cancel.
Sir, you have made a party in the suit. ನೀವು ಬಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಇರೋದು.
ನಾನು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡಿದ್ದಿಲ್ಲ.
ಅಲ್ಲ, you have made a party in the suit so that you join in the execution of the
Prayer is not like that. Prayer is not like this. It's good. That's why the prayer is not like that. I made the prayer. Someone ಬಂದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೇಳಿಲ್ಲ ಅಥವಾ ಡೈರೆಕ್ಟ್ ಡಿಪೆಂಡ್ ಟು ಎಕ್ಸಿಕ್ಯೂಟ್ ದ ರೆಗ್ಯುಲರ್ ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್ in terms of the agreement dated 26 February 2009 we are receiving the remaining sale consideration of 50,000 to be paid to the first deferment at the cost of the client. It is for the first deferment because he is the according to them they have executed an agreement. That agreement has been for both. That has been denied by the return statement. Once it is denied in the return statement, but it is the duty of the court to send it for comparison of the parties. But I can understand what on section 73, but court can exercise the power to compare signature. But there is a case where the signature itself is denied. But it is the court should not take the burden and accept the Supreme Court is there. Usually the court should not take a burden and send it for Supreme. 2006 the Supreme Court is very clear. The burden of proving the agreement lies on the Imada on the part of the plaintiff. That's what section 43 and 145 and 145.
What is the position of the decree now?
Decree now knows the execution according to the fact. Decree is not to go and execute directed the first difference to execute the sale deed in front of the fact. So execution is not in the blood that they wanted to execute the sale deed in front of the fact.
What is notice serve out for money? Notice. No.
Suppose the sale deed is executed in the name of law. Again, multiple decrees. But not the tension.
Sir, you please get it served, move the matter immediately, not grant any. Sorry.
Application. Right. There was an order for the application. Application to that. There was an order. Still not disposed of the appeal. There was an interim order. Interim order also produced.
Please serve the notice. Issue emergency notice. In addition, the Reference Counsel for the appellant is at liberty to serve the counsel representing the decree holder. Execution petition number
13 December 47
what?
14
about 2017. Installed. 18th April 2020. Serve ಮಾಡ್ಕೊಂಬಂದು serve ಮಾಡ್ಕೊಂಬಂದ್ರೆ can do something.
next week
ಮಾಡ್ಕೊಂಬನ್ನಿ ಫಸ್ಟ್ ಪ್ರೋಸೆಸ್ ಕೊಡಿ ಇವತ್ತು.
ಆ ಕಂಡೀಷನ್ condition.
No conditions.
On that condition, I will do
Please get it served. Otherwise, I will not. Because if you want, I can dictate the judgment also now. Please get it served. ಏನಾದರೂ ದುಡ್ಡಿಗೆ ಜಾಸ್ತಿ ಕೊಡಿಸ್ಬಿಟ್ಟು ಏನೋ ಮಾಡ್ಸಕ್ಕಾಗುತ್ತೋ ನೋಡೋಣ ಅಷ್ಟೇ. Otherwise, it's a clear case of special performance. Clear case. Scribe, ಇವರು witnesses, ಎಲ್ಲರೂ ಕರೆಸಿ ಹೇಳಿದ್ದಾರೆ. What more is required? And they have taken effective steps. They have taken effective steps. They have done everything that is required of them. What more is required for a special performance? Please get it served. Let us see. Yes. How many sisters and brothers she has got?
Number 3.
But 1/4 correct ಮಾಡಿದ್ರು. Why is the judgment set aside?
That was granted in favor of the
Emergency notice. Parties are directed not to alienate district properties. Filed by the granddaughters. That was filed for partition. What ground was it discussed? It's not decided on merits.
Asking the trial court to pay an issue the trial court holds that the court would not have entered a judgment. The plaintiff could not have did not also put the case ahead. The resume data is answered against. Issue number 1. And also number the defendant was alive when the suit was filed by the daughters in version of the 19th. They claim it is a joint family. They have taken up a contention that item number 69 is doing of 2009. They have purchased the property. Other is the owner of the property. Property. Used to be the independent business. Dependent number 1 is the husband of the father of 3, 4, and 5 and granddaughter.
What are the properties in the name of dependent number 2?
Dependent number 2, item number 6 to 9 numbers.
2 9. They stand in her name.
2 months. They have taken a contention to purchase out of the income derived by benefits.
Will it stand in her name?
So it stands in the name of the dependent number 1.
Okay.
They taken a contention.
Yeah.
So the contention. But he does not prosecute.
But see, the earlier suit, he did not enter the witness box.
But he did keep examination. cross-examination.
Therefore, order 17 rule 1 is applicable.
That is binding on the orders. The certificate on the very same property members, not the land of the lifetime of the father.
Why they can't pay? Those are co-personers.
Yes.
They are co-personers.
You have the earlier judgment that binds them to.
But if that judgment is not binding upon them.
But they won't seek that.
They will not seek it, but if the father does not enter the box, then it is no good. It's not a judgment at all.
But when number 1 has a examined and
What is the defendant number 1 content induction?
defendant number 1 still contains that it is separated.
What? The defendant number 1.
Defendant number 2. But then defendant is also made as a party.
So what is the finding in that slip? What is the finding regarding the nature of the property? Does it say? Then
but at least 6 to 9 seems to be becomes as required property.
ಎಷ್ಟು ಜನ ಮಕ್ಕಳು ಇವ್ರಿಗೆ ಇಬ್ಬರೇ ತಾನೆ 3 ಜನ ಮಕ್ಕಳು. ಡಿಪೆಂಡ್ ನಂಬರ್ ಡಿಪೆಂಡ್ ನಂಬರ್ 3 ಆಯ್ತು 1/4 ಶೇರ್ ಅವ್ರು ಕೊಡ್ಲಿ ಅಷ್ಟು. So 1/16 is the correct share. 1/4 divided by 4. 1/16 correct ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು ಯಾವತ್ತು ಹೇಳ್ತಿರಲಿ ಐ ವಿಲ್ ನಾಟ್ ಇಶ್ಯೂ ನೋಟಿಸ್. ಹೇಳಿ ಯಾವತ್ತು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೇವೆ ಹೇಳಿ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ. Whenever you want for vacation, please pick the date of your choice. 18th. Just on 18th at the request of the government sponsor for the appellant to explore the possibility of the settlement. See number? Mr. Y.K. Narayan Sharma. Mr. Y.K. Narayan Sharma.
For respondent, my lord. My lord, in this case, it is my case, my lord, even though for argument's sake, it is admitted that the appellant claims that they have purchased the property by virtue of a sale agreement, my lord, for a consideration of 6,000 rupees each for 2 scheduled property. That was in the year 1975. It is also the case because of some legal technicalities, the matter could not be registered and it was postponed, my lord. And ever since they are in physical, they claim that they are in the alleged physical possession of the property, but till date they never took any steps for registration of the property. Neither they invited me for registration of the sale deed, nor they filed any suit for specific performance, requesting the court to direct me to go for the registration of the property, my lord. The fact stands at this, my lord. Now, it's my case that even for argument's sake, because in the cross-examination, the plaintiff has admitted that the signature on the stamp paper is his. He only denies the contents. He says that out of trust, he signed a blank paper because the defendant or the petitioner appellant hearing, he said that he want to take the electric connection. So that is why the signature is required. So on the trust, that signature was made. That's my case. Even for argument's sake, if we presume that a sale agreement only was executed and the entire consideration was received, and even they were put into physical possession of the property, in the absence of the registered document, they cannot claim ownership over the property, my lord. That is one thing. So thereafter, they have even failed to go for the specific performance. So now it is barred by limitation that they cannot seek specific performance. In the alternative, they also claim the adverse position, my lord, which is untenable, because at one point of time, they say that they are in physical possession of the property by virtue of sale agreement. So when they say that they are in a permissive position, they cannot take the defense of adverse position, my lord. So that being the case, now because the document was not registered, they cannot claim ownership over the property. So at this backdrop, I filed a suit for partition before the trial court, seeking 2/3 shares in the suit scheduled property. There are 2 scheduled properties which consist 5 acres each, my lord. So both the plaintiffs and defendant jointly purchased the property from the late Maharaja in the year 1975, wherein 10 acres in 2 schedules were purchased. So jointly they were entitled to 1/3 share in each of the property. Because the appellant herein was in a position to manage the property, so out of an understanding, he was allowed to manage the property or cultivate the property. But at no point of time, the entire position was given to him. I continue to enjoy the legal position, my lord. This is the facts of the case. Now, before the trial court, I have sought for partition and separate physical possession of the property, my lord. On the other day, there was little confusion that I have not sought for position, as a result of which the compromise was mooted, so that otherwise they can claim physical possession of the property, but they cannot claim ownership, and I can claim ownership but not physical possession, because I have not sought for physical possession of the property. But I have sought for physical possession of the property before the trial court, my lord. And I have also sought for the partition of the suit, wherein I sought for 2/3 shares in both schedule A and B of the property, my lord. So that being the case, when they have failed to get the property registered, so they cannot claim ownership over the property. As such, their defense of adverse position also fails. They only say that they are in physical possession by virtue of 53A, my lord. 53A comes into the picture only when I say that they are the trespasser. It is not my case that they are the trespasser, so you get out of the property. It is not my case. I am admitting their physical possession. Even though the Tahsildar has opined otherwise, even though the Tahsildar in his report, he has said that the respondents herein are physical possession of the property, even then, even if I concede that I am not in physical possession of the property, I have sought for position and 1/3 share each. I mean 2/3 share each in the suit scheduled property. So that being the case, when they have failed to prove that they are the owners of the property by virtue of a registered sale agreement, the appeal deserves to be dismissed, because the first appellate court has rightly observed that because they have failed to get the sale deed registered, and it is barred by limitation. And till date, even after filing of the original suit, they never made any attempt to go for specific performance. So they continued with the contention saying that they are the owner of the property by virtue of unregistered sale agreement. So that being the case, in the absence of any registered document, they cannot claim ownership over the property, and have specifically sought for position and
Sir, don't repeat the argument.
And so this is what my argument is, my lord.
Yes, sir.
ನಾನು ಕನ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮೊದಲು ಅವ್ರು he has taken over the argument.
ಆಯ್ತು ಬಿಡಿ, ಅವ್ರದ್ದು ಆಯ್ತಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು.
ನಾನು ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು, ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ರಿಪ್ಲೈ ಅಂತ ಹೇಳಲ್ಲ.
How do you prove your agreement?
ಒಂದ್ ನಿಮಿಷ, ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ ಸಿಗ್ನೇಚರ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. one submission I want to make is this: 2 things. One, agreement prove that is one item. Another is regarding the non-examination of the plaintiff himself. He has not come to box to deny it. Other plaintiff who has come to the box has admitted. Once he admits a signature and the other plaintiff does not come to box and does not deny the signature, and both the plaintiffs say that the signatures were given for a particular purpose on blank paper. Now the document is before your lordship, and if they admit the signature and they say that this is for a different purpose, the burden is heavily on them to prove. What is how they have discharged the burden, except saying that it was given for elective.
Can you look at the evidence and can we look at the evidence and decide that question? Please let us read the evidence.
ಅದಕ್ಕೆ ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ತಾವು ಹೇಳಿದ್ರಿ, in view of that full bench judgment I can continue in possession, but there is no title, so problem ಬರುತ್ತೆ, ಅದನ್ನ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿ. Your lordship observed that is how it went to for
that is gone, sir. Settlement, there is no settlement.
ಅದು ಹೋಯ್ತು ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನಾನು ನಿಲ್ಲಿಸಿದೆ ಅಂತ ಹೇಳಿದೆ ನಾನು. ನಾವು your lordship ಖಂಡಿಸಿ ಎವಿಡೆನ್ಸ್ ಹೇಳ್ತೀನಿ. The judgment of the full bench based on that, I was saying that they are not entitled to claim possession from me. And proving of a agreement also, may I take your lordship to the page 20 paper book ide adralli avara evidence tavu kelidralla evidence alli PW 1 and 2 inadu nodi page 22 alla 21 page 21 of paper book.
Yes, please.
Your lordship got 21.
Yes.
ನಾನು ಹಾಗೂ ಮೊದಲನೇ ವಾದಿ ಕರಾರು ಪತ್ರ ಬರೆಸಿ ಸಹಿ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತದೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಕಂದಾಯ ಕಟ್ಟುತ್ತೇನೆಂದು ಪ್ರತಿವಾದಿ ಪುಟ್ಟಲಿಂಗವೇ ಖಾಲಿ ಹಾಳೆಗೆ ನನ್ನ ಸಹಿಯನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಕರಾರು ಪತ್ರವನ್ನು ಬರೆಸಿ ನಾನು ಮೊದಲನೇ ವಾದಿ ಸಹಿ ಪ್ರತಿವಾದಿ ಕರಾರು ಪತ್ರವನ್ನು ಸುಳ್ಳು. ಸೊ ಸಿಗ್ನೇಚರ್ ಇಸ್ ದೆನ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 22 ಅಲ್ಲಿ could your lordship see 22?
Yes, sir.
ದಿನಾಂಕ 15/75 ದಿನಾಂಕದ ಕರಾರು ಪತ್ರದಲ್ಲಿ ಸಹಿಯನ್ನು ಸಾಕ್ಷಿಗೆ ತೋರಿಸಲಾಗಿ ಸಾಕ್ಷಿಯು ತನ್ನ ಸಹಿಯನ್ನು ಗುರುತಿಸಿದ್ದು ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆ D1 ಎಂದು ಸಹಿಯನ್ನು D1A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. D1 ದಾಖಲೆಯ ಮೊದಲನೇ ಪುಟದಲ್ಲಿಯೂ ಸಹ ನನ್ನ ಸಹಿ ಇದ್ದು ಅದನ್ನು ನಿಶಾನೆ D1B ಎಂದು ಗುರುತಿಸಲಾಯಿತು. Both the pages have signed. It is not given for electricity. Then ಸದರೀಕರಣಂತೆ ನಾನು ಹಾಗೂ ವಾದಿಯ ಚಿಕ್ಕಮ್ಮನ ಒಟ್ಟಾಗಿ 6,000 ಸರಿಯಲ್ಲ. ದೆನ್ ನೆಕ್ಸ್ಟ್ ಕೆಳಗಡೆ 74ನೇ ದಿನಾಂಕ ಕ್ರಯಪತ್ರ ವಾದಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ವಿದ್ಯುತ್ ಸರಬರಾಜು ಪಡೆಯಲು ಪ್ರತಿವಾದಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. ಸಾಕ್ಷಿಯು ಸದರೀಕರಣ ಪತ್ರವನ್ನು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಸೊ ದಿಸ್ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್, ಒರಿಜಿನಲ್ ಸೇಲ್ ಡೀಡ್ ಇಸ್ ವಿತ್ ಮೀ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಆಸ್ ಎಕ್ಸಿಬಿಟ್ D2. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಐ ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು 23. 75ನೇ ಸಾಲಿನಲ್ಲಿ ದಾವೆ ಸೊತ್ತಿನ ಸ್ವಾಧೀನ ಪ್ರತಿವಾದಿ ಹೊಂದಿದ್ದು ಈ ದಾವೆಯನ್ನು ದಾಖಲು ಮಾಡುವ ಸಮಯದಲ್ಲಿ ಪ್ರತಿವಾದಿ ದಾವೆ ಸೊತ್ತಿನ ಸಂಪೂರ್ಣ ಮಾಲೀಕನಾಗಿದ್ದರೆ ಸರಿಯಲ್ಲ. ಮೊದಲನೇ ವಾದಿ ಚಿಕ್ಕತಮ್ಮಯ್ಯ ನಗರದ ಮೇಯರ್ ಆಗಿದ್ದು ಎಂದರೆ ಸರಿ. ಸದನಿಯವರು ಬಹಳ ವಿದ್ಯಾವಂತರಾಗಿದ್ದರು ಎಂದರೆ ಇರಬಹುದು. ಸದನಿಯವರು ಖಾಲಿ ಹಾಳೆಗೆ ಸಹಿ ಮಾಡುವ ಅಭ್ಯಾಸವಲ್ಲ ಎಂದರೆ ತುರ್ತು ಕಾರಣದಿಂದ ಆಮೇಲೆ ಹೇಳಿದ ಸಹಿಯನ್ನು ಖಾಲಿ ಹಾಳೆಗೆ ಮಾಡಿರುತ್ತಾರೆ. ಸೊ ಈವನ್ ಪ್ಲೇಂಟಿವ್ ಸಿಗ್ನೇಚರ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್ ಬೈ ದ ಅದರ್ ಪ್ಲೇಂಟಿವ್. ದೆನ್ ಈ ನಿಶಾನೆ ದಾಖಲೆಯನ್ನು ನಾನು ಹಾಗೂ ಚಿಕ್ಕತಿಮ್ಮಯ್ಯ ಓದಿ ಅವರ ವ್ಯವಹಾರವನ್ನು ತಿಳಿದುಕೊಂಡಿದ್ದರೆ ಸರಿಯಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ನೌ ದಿಸ್ ಮೇಯರ್ ಚಿಕ್ಕತಿಮ್ಮಯ್ಯ ಇಸ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ಡ್. He is plaintiff number 1. 114G of Evidence Act, your lordship knows adverse inference has to be drawn because once the signature is admitted by both the plaintiffs and they say that it's for a different purpose, then heavily burden is on them. Number 2, he has not entered the witness box to explain why he has signed. So these 2 points, that's why I say that evidence is from the plaintiff side itself shows that there is an agreement. Even my learned friend's argument just now is that they have signed it for a different purpose, etc. But the document signed by them, the 91-92 section, your lordship note, once it is admitted that there is a document, their signature is admitted, burden is on them to prove that it is for a different purpose. I don't say that they can't lead evidence. They can lead evidence. But what is the evidence they have let in for a different purpose? Your lordship may kindly see this. That is why I say that my agreement is proved, and once the agreement is proved, the consequences will follow. Non-examination of PW1, plaintiff number 1, goes heavily under the circumstances, and your lordship may kindly proceed. And in fact, I take your lordship to the trial court judgment. Trial court has passed a judgment in my favor. It was dismissed. Appellate court reverses it.
Yes.
And the finding of the trial court is not properly appreciated or dealt with by the appellate court, and is simply reversing it. Now, so far as defendant's evidence is concerned, your lordship may kindly see DW1. Of course, PW2 ಬೇಕಿದ್ರೆ ನಾನು ಓದ್ತೀನಿ ಅದರಲ್ಲಿ. Of course, they say that ಇವರು ಏನೆಲ್ಲ ವ್ಯವಹಾರ ಮಾಡಿದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಪೇಜ್ 27 ಅಲ್ಲಿ ನೋಡಿ, ಪೇಜ್ 27. May I take your lordship to 27?
Document writer.
My lord.
Who is the document writer of exhibit D1?
He died ಅಂತ ಎವಿಡೆನ್ಸ್ ಬಂದಿದೆ.
ಅಲ್ಲ ಅವ್ರದ್ದೇ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, ಸತ್ತಿದ್ದಾರೆ ಅಂತ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಅಂತ. ಅವರು ಸತ್ತಿದ್ದಾರೆ. ಆಮೇಲೆ ಇದರಲ್ಲಿ ನೋಡಿ ಪೇಜ್ 27 ನಲ್ಲಿ PW1 ಕ್ರಾಸ್ ಅಲ್ಲಿ he went on saying that I know them and they have purchased. The purchase is not in dispute. Then in the 27 ಅಲ್ಲಿ ಅವರು ಹೇಳಿದ್ರು ನೋಡಿ, ಸದರಿ ಪಂಪ್ ಸೆಟ್ಟು ಪುಟ್ಟಲಿಂಗನ ಹೆಸರಿನಲ್ಲಿ ಇದೆ ಎಂದರೆ ಅದು ಯಾರ ಹೆಸರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ, ವಾದಿಗಳು ಹಾಗೂ ಪ್ರತಿವಾದಿಗಳು ಯಾವ ಮನೆಯಲ್ಲಿ ವಾಸವಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತು ಎಂಬ ಬಗ್ಗೆ ನನಗೆ ಮನೆ ನಂಬರ್ ಹೇಳೋ ಸಾಧ್ಯ ಇಲ್ಲ. ಅದೇ ರೀತಿ ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿ ಮಧ್ಯೆ ಏನೆಲ್ಲ ವ್ಯವಹಾರ ನಡೆದಿದೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬರಲು ಜೋಗಿ ಸಿದ್ದಯ್ಯ, ದಟ್ ಇಸ್ ದ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 2 ಹೇಳಿರುತ್ತಾರೆ. ನಾನು ಜಮೀನು ಗುತ್ತಿಗೆ ಮಾಡ್ತಿದ್ದೇನೆ, ಸಿದ್ದೇಗೌಡರ ಜಮೀನನ್ನು ಗುತ್ತಿಗೆ ಮಾಡ್ತೇನೆ. ಅದೇ ಸರ್ವೆ ನಂಬರ್ 102, ದಟ್ ಈಸ್ ನಿಯರ್ ಬೈ. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಕೆಳಗಡೆ ಈ ದಿನ ಬಂದಿರುವ ಇನ್ನೊಬ್ಬ ಸಾಕ್ಷಿ ಮಾದಯ್ಯ ಪರಿಚಯ ಇದೆ. ಅವರು ಮಾದಯ್ಯ ಅಂದ್ರೆ ಅಣ್ಣನಿಗೆ ಜೋಗಿ ಸಿದ್ದಯ್ಯನ ಮಗಳನ್ನು ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಲಾಗಿದೆ. ಎ ಕ್ಲೋಸ್ ರಿಲೇಟಿವ್ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 2, that is PW3, that is admitted. Then my lord, again page 32 ಅಲ್ಲಿ ನೋಡಿ, may take your lordship to page 32.
Yes.
Second witness says, ನನ್ನ ಚಿಕ್ಕಪ್ಪನ ಮಗನಿಗೆ ಎರಡನೇ ವಾದಿ ಯೋಗಿ ಸಿದ್ದಯ್ಯನ ಮಗಳನ್ನು ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಲಾಗಿದೆ. ಎರಡನೇ ವಾದಿ ನನಗೆ ಸಂಬಂಧಿಕನಾಗಿರುವುದು ಅವರ ದಾಕ್ಷಿಣ್ಯಕ್ಕೆ ಒಳಗಾಗಿ ನಾನು ಸಾಕಿ ಹೇಳಲು ಬಂದಿದ್ದೇನೆ, ಎಟ್ಸೆಟ್ರಾ. Whatever it is, there is no evidence on their side to disprove my possession and my entering into the agreement. That is of no use.
Can we read the document, agreement D1?
D1, my lord.
Yes, please read exhibit D1.
D1. Your lordship get page 77. Your lordship got it? Your lordship is reading that.
Yes, yes.
1975 ಜನವರಿ 15 ಬೆಂಗಳೂರು ಮೈಸೂರು ಸಿಟಿ ಚಾಮರಾಜ ಮಹಲ್ ಅಶೋಕಪುರಂನಲ್ಲಿ 9ನೇ ಕ್ರಾಸ್ನಲ್ಲಿ ವಾಸವಾಗಿರುವ ಮನೆ ನಂಬರು 2013 ಲೇಟ್ ಮಹಾಲಿಂಗಯ್ಯನ ಮಗನಾದ 48 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ಪುಟ್ಟಲಿಂಗಯ್ಯನವರಿಗೆ, ದಟ್ ಇಸ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಅಂಡ್ ಅಪಲೆಂಟ್. ಡಿಟೋ ಸ್ಥಳ ಡಿಟೋ ಬೀದಿಯಲ್ಲಿ ಅಂದರೆ CHI 3ನೇ ಕ್ರಾಸ್ನಲ್ಲಿ ವಾಸವಾಗಿರುವ ಮರಿದಂಡಯ್ಯನವರ ಮಗ ಸುಮಾರು 45 ವರ್ಷವುಳ್ಳ ಶ್ರೀ ಚಿಕ್ಕದಮ್ಮಯ್ಯ ಒಂದು. ಡಿಟೋ ಸ್ಥಳ ಅಶೋಕಪುರಂ 9ನೇ ಕ್ರಾಸ್ನಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಇರುವ ಸಿದ್ದಯ್ಯನವರ ಮಗ ಜೋಗಿ ಸಿದ್ದಯ್ಯ ಸುಮಾರು 53 ವರ್ಷ ವಯಸ್ಸಿನ ಎರಡು. ನಾವು ಈರುವರು ಸೇರಿ ಬರೆದುಕೊಟ್ಟ ಒಪ್ಪಂದ ಕರಾರು ಏನೆಂದರೆ, ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಶ್ರೀಕಂಠದತ್ತ ನರಸಿಂಹರಾಜ ಒಡೆಯರಿಗೆ ಸೇರಿದ ರಾಯನಕೆರೆ ಡೈರಿ ಫಾರಂನಲ್ಲಿ ನಮಗಳಿಗೆ ಹೆಸರಿಗೆ ಕ್ರಯವಾಗಿರುವ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ 2338ನೇ ವರೆಗೂ ನೀವೇ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಸರಿಯಷ್ಟೇ. ಲಕ್ಷ್ಮಿ ಕಳಿಸಿ, ನೀವೇ ಸಾಗುವಳಿ ಮಾಡುವುದು ಸರಿಯಷ್ಟೇ. ಸದರಿ ಜಮೀನನ್ನು ನಮ್ಮೀರುವರ ಸಾಗುವಳಿ ಮಾಡುವುದು ಸಾಧ್ಯವಿಲ್ಲವಾದ್ದರಿಂದ ಸಾಗುವಳಿಗೆ ತಗಲುವ ಖರ್ಚು ವಗೈರೆಗಳು ನಮ್ಮಿಂದ ಸರಿದೂಗಿಸಲು ಶಕ್ತಿ ಇಲ್ಲವಾದ್ದರಿಂದ ಈ ದಿವಸ ನಮಗೆ ಈರುವರ ಖುದ್ದು ರಾಜಿಯಿಂದ ನಾವುಗಳು ರಿಜಿಸ್ಟರ್ ಆದ ಕಾಲದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದ 6,000 ರೂಪಾಯಿಗಳನ್ನು ಹಿಂದಕ್ಕೆ ಪಡೆದುಕೊಂಡು ಈ ದಿವಸವೇ ಸದರಿ ಸ್ವತ್ತನ್ನು ನಿಮ್ಮ ವಶಕ್ಕೆ ಒಪ್ಪಿಸಿರುತ್ತೇವೆ. ಸದರಿ ಜಮೀನಿನ ಕಂದಾಯ ವಗೈರೆಗಳನ್ನು ಇನ್ನು ಮುಂದೆ ನೀವೇ ಕಟ್ಟಿಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಹೋಗಬಹುದೆಂತಲೂ, ಇದರ ಬಗ್ಗೆ ತಂಟೆ ತಕರಾರುಗಳು ಉದ್ಭವಿಸಿದ ಪಕ್ಷದಲ್ಲಿ ನಮ್ಮೀರುವರ ಸ್ವಂತ ಖರ್ಚಿನಿಂದ ಪರಿಹರಿಸಿಕೊಡುವುದೆಂತಲೂ ಈಗ ಹಾಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಳ್ಳಲು ಅವಕಾಶ ಇಲ್ಲದಿರುವುದರಿಂದ ಈ ಛಾಪ ಕಾಗದ ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇವೆ. ಮುಂದೆ ಆರ್ಡರ್ ಬಂದ ಕೂಡಲೇ ಸದರಿ ಸ್ವತ್ತನ್ನು ರಿಜಿಸ್ಟರ್ ಪತ್ರ ಮೂಲಕ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುತ್ತೇನೆ ಎಂದು ನಾವುಗಳು ಒಪ್ಪಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಪತ್ರ ವಗೈರೆ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಈ ಕೆಳಗೆ ನಮೂದಿಸಲ್ಪಟ್ಟ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ನಿಮಗೆ ವಹಿಸಿಕೊಟ್ಟು ಕ್ರಯ ಮೊಬಲವು 6,000 ರೂಪಾಯಿಗಳನ್ನು ಪೂರ್ಣ ಪಡೆದು ನಮ್ಮ ಖುದ್ದು ರಾಜಿಯಿಂದ ಈ ಕೆಳಗಂಡ ಸಾಕ್ಷಿಗಳ ರೂಬು ಪಡೆದಿರುತ್ತೇವೆ ಎಂದು ಬರೆದುಕೊಟ್ಟ ಕರಾರು ಸೊತ್ತು. 2 ಐಟಮ್ ಬರೆದಿದ್ದಾರೆ. ಸೊ they had advanced money at the time of purchase. They took back the money and agreed to transfer their 2 shares to them. And these are the details of the properties, my lord. Is it?
What is the date of the sale deed?
Sale deed, my lord, it is dated 74. ಇದು 75. ಆಮೇಲೆ ಅವರಿಗೆ ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಟರು. ಅದು ಎಕ್ಸಿಬಿಟ್ P1 and D2. ಒರಿಜಿನಲ್ ಇದು 14/8/74. The date. Exhibit D2. Original is produced by me. It is in my custody. 14/8/74.
Yes.
Your lordship can see the original agreement if your lordship wants to authenticate. ಸರಿಯಾಗಿ ನೋಡ್ಬೇಕಾದ್ರೆ ನೋಡಬಹುದು, ನನ್ನೇನು ಅಡ್ಡಿ ಇಲ್ಲ. But what I am saying is, this is a clear case where all of them jointly got a sale deed in the names of 3. They did not want the property. Maybe that they had taken money. They gave back the money and took the entire amount and executed the agreement, giving up the whole thing. They kept quiet all these years up to 94, and then they started dispute. Till then, they never exercised their power, and they did not make any claim. And they are not their relatives. There is no question of partitioning as such, except that they are joint owners. Joint owners our share and then why is the question of sharing? That is one thing. Now DW1 and DW2, your lordship may kindly see. If your lordship permits, I will also say that what is the type of cross-examination and if necessary, and what are the developments I made, and how investment was made subsequently. All these things clearly indicate that. And the one more thing is, even the electricity supply and other things are all in my name, and I have been paying the charges. And pump set ಎಲ್ಲ ಹಾಕಿ ನೀರಾವರಿ ಮಾಡಿ ಆದ ಮೇಲೆ ಕಣ್ಣು ಕೆಂಪಾಯ್ತು. Then they want to come back because the defect in not registering the deed.
Yes, please. Next.
Now you lordship kindly see page 34 ನಮ್ಮ ರುದ್ರ ಡಿಫೆಂಡೆಂಟ್ ಅವರು ಎಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ ಸತ್ತೋದ್ರು, ಅವರು ಎಲ್ಲಾರು ಬಂದ್ರು, ಎಲ್ಲಾರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
Yes.
And he refers to the spot inspection, possession, everything. And in the cross examination also, your lordship kindly see the documents produced. Page 41 ನಲ್ಲಿ the document ಗೆ ರೆಫರೆನ್ಸ್ ಹೇಳಿದ್ದಾರೆ. And D1B ಅದನ್ನು ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ಮಾಡಿದ್ದಾರೆ. ಸಹಿ ಮಾಡಿದ್ದನ್ನು ಮಾಡಿದ್ದಾರೆ. ಸಹಿ ಮಾಡಿದ ಆಫ್ ಕೋರ್ಸ್ ದೇ ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್. ದಾವೆ ಶೆಡ್ಯೂಲ್ಸ್ ಅಂತ ಪಂಪ್ ಸೆಟ್ ಅಳವಡಿಸಿ ಅದಕ್ಕೆ ವಿದ್ಯುತ್ ಸರಬರಾಜು ಪಡೆಯಲಾಗಿದೆ. ಸದರಿ ಪಂಪ್ ಸೆಟ್ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ವಿದ್ಯುತ್ ಬಿಲ್ ಅನ್ನು ಪಾವತಿ ಮಾಡಬೇಕೆಂದು ಕೇಳಿ 6 ಡಿಮಾಂಡ್ ನೋಟಿಸ್ಗಳು 3 ರಿಂದ 8 ರವರೆಗೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಸದರಿ ಪಂಪ್ ಸೆಟ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ವಿದ್ಯುತ್ ಬಿಲ್ ಅನ್ನು D9 ರಂತೆ ಮತ್ತು 11 ರಂತೆ ರಸೀದಿಯನ್ನು 10-20 ರಂತೆ ಹಾಜರುಪಡಿಸಿರ್ತೇನೆ. ಅಲ್ಲಿಂದ 10 ರಿಂದ 20 ರವರೆಗೆ ರಸೀದಿಗಳು. ಸದರಿ ಪಂಪ್ ಸೆಟ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ವಿದ್ಯುತ್ ಪೂರೈಕೆ ನನ್ನ ತಂದೆ ಹೆಸರಲ್ಲಿರುವ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಯವರು ನೀಡಿರುವ ದೃಢೀಕರಣ ಪತ್ರ D21 ಅನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಸಂಬಂಧಪಟ್ಟ ರೆವೆನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮಾಡಿರುವ ಮಹಾಜನ ದೃಢೀಕರಣ ನಕಲು D22. ಅದರಲ್ಲಿಯೂ ಪೊಸೆಷನ್ ಇಸ್ ಮೈನ್. ದಾವೆ ಶೆಡ್ಯೂಲ್ಸ್ ಅಂತಿನ ಅಳವಡಿಸಿದ ಪಂಪ್ ಸೆಟ್ಗೆ ಖರೀದಿಸಿದ 2 ಕ್ಯಾಶ್ ಬಿಲ್ಗಳು ನಿಶಾನೆ D23, 24 ಎಂದು ಹಾಜರುಪಡಿಸಿರ್ತೇನೆ. ಸದರಿ ಪಂಪ್ ಸೆಟ್ ಅನ್ನು ಡೆಲಿವರಿ ಕೊಟ್ಟ ಬಗ್ಗೆ ಡೆಲಿವರಿ ನೋಟ್ ಅನ್ನು D20 ಹಾಜರುಪಡಿಸಿರ್ತೇನೆ. ದೆನ್ ಕ್ವಶನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪಾರ್ಟಿ ಸವಾಲು. 74ನೇ ಸಾಲಿನಲ್ಲಿ 2ನೇ ವಾದಿ ಜೋಗಿ ಸಿದ್ದಪ್ಪ ದಕ್ಷಿಣ ರೈಲ್ವೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದನು. 1ನೇ ವಾದಿ ಚಿಕ್ಕ ತಿಮ್ಮಯ್ಯ ಮೊದಲಿಂದಲೂ ರಾಜಕೀಯದಲ್ಲಿ ಇರುತ್ತಾನೆ. 74ನೇ ಸಾಲಿನಲ್ಲಿ ನನ್ನ ತಂದೆಗೆ ಯಾವುದೇ ಸರ್ಕಾರಿ ನೌಕರಿ ಆಗಲಿ ಅಥವಾ ಖಾಸಗಿ ನೌಕರಿ ಆಗಲಿ ಇರಲಿಲ್ಲ. 74ನೇ ಸಾಲಿನಲ್ಲಿ ದಾವೆ ಸ್ವತ್ತುಗಳನ್ನು 1 ಮತ್ತು 2ನೇ ವಾದಿಗಳು ಹಾಗೂ ಪ್ರತಿವಾದಿ ಜಂಟಿಯಾಗಿ ಖರೀದಿಸುತ್ತಾರೆ. 74ನೇ ಸಾಲಿನಲ್ಲಿ ನನಗೆ 9 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು. 66ರಲ್ಲಿ ಜನಿಸುತ್ತೇನೆ. ಖರೀದಿದ ನಂತರ ದಾವೆ ಸ್ವತ್ತುಗಳನ್ನು ಪ್ರತಿವಾದಿಗಳು
ಇದು you please come to exhibit D1 again.
D1 my lord.
ನಮ್ಮ ಕುತ್ತೂರಾಜಿಯಿಂದ ಈ ಕೆಳಕಂಡ ಸಾಕ್ಷಿಗಳ ರೂಬು ಪಡೆದಿರುತ್ತೇವೆಂದು ಬರೆದ ಒಪ್ಪಂದ ಕರಾರು ಸಹಿ. ಯಾರಿದ್ದಾರೆ ಸಾಕ್ಷಿಗಳು? ಯಾರಿದ್ದಾರೆ
ಅದರಲ್ಲಿ? ಟೈಪ್ ಮಾಡಿದಂಗಿಲ್ಲ, ನಾನು ನೋಡ್ಬೇಕು, ಒರಿಜಿನಲ್ ನೋಡಿ ಹೇಳ್ತೀನಿ ಯಾರು ಅಂತ. ಬಟ್ ದೇ ವರ್ ನಾಟ್.
ಸಾಕ್ಷಿಗಳು ಯಾರಿಲ್ಲ.
ಇಲ್ಲ, ಒಂದು ನಿಮಿಷ, ನಾನು ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ kindly permit me to see the original. Your lordship got the original agreement?
Yes, I have the original.
ಅದೇ ಅದರಲ್ಲಿ ಸಾಕ್ಷಿಗಳು ಖಾಲಿ ಇದೆಯಾ?
ಖಾಲಿ ಇದೆ.
ಸರಿ. ಬಸ್ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ದ ಕಾಪಿ. ಇದು ಟೈಪ್ ಮಾಡಿದ್ದು ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ. Maybe that is the reason why no other witness has come for that. ಇದು ಮಾಡಿದವರು ಬರೆದವರು ಸತ್ತಿದ್ದಾರೆ. There is evidence. So between themselves, jointly purchased, and it is not a stranger who has executed the agreement. Between themselves, there is adjustment, and they have signed it. Even without the witnesses, it is a valid document. It's not a registered deed, nor it call for any witness as such. That is why a witness was not examined, most probably. Then, my lord, your lordship kindly see from the document, your lordship could see that 2 pages they are signed. If it is a blank, it could not be in that form. Generally, your lordship see any document blank signature is obtained, it will not be in the position of that place. Signatures, nodidre. Now I got the copy of that, my lord. In the usual course, if blank signatures are obtained, the second page signature. So in the normal course, type sign there is no what you call as suspicion about this document. So I could not prove anything else other than this. And plaintiff number 1 has not come to box. Plaintiff number 2 says that they both of them have signed this. ಇನ್ನೊಂದು ಹೇಳ್ತೀನಿ, if the pump setting a signature ಇವರಿಗೆ ಬೇಕು ಅಂದ್ರೆ ಮೂವರ ಹೆಸರಿಗೆ ಇರೋದನ್ನ your lordship ಕಳಿಸಿ, they could have obtained for 3. Why only in the name of this person electricity has to be obtained? They never objected. ಇದು ಸುಮ್ಮನೆ ಕತೆ ಹೇಳೋದು, ನಾನು electricity ಈಗ ಬೇಕಾದ್ರೆ ನಾವು ಸೈನ್ ಮಾಡಿಕೊಟ್ಟೆವು ಅಂತ. Where is the need for them? If they are also the owners ಆದ್ರೆ they could have taken the electricity in the joint names or in their names. So adrinda this story that it was signed for some purpose other than the agreement purpose cannot be believed under the circumstances of the case.
Yes, Mr. Mohan.
And ಇನ್ನೊಂದು ಹೇಳಬೇಕು ಅಂತ ನನಗೆ what I am submitting is this judgment. ನಮಗೆ of course your lordship is well aware of this judgment. ಅದನ್ನು ನಾನು ಹೇಳಬೇಕು ಅಂತ ಇದ್ದೀನಿ. IRR 1998 Karnataka. 1998 Karnataka full bench. Narasimha Shetty versus Padma Shetty. Last time I referred to your lordship, then your lordship said your lordship knows about it. That is how I stopped there. May I refer to that, my lord? Or
not.
Because my learned friend was just a few minutes back argued, saying that my possession, it has not become perfect and etc. etc. I am not saying for a moment that the possession is not to be protected or how it is to be protected. There are 2 ways, my lord. One is under 53A, as per the full bench judgment. Once I establish that I am in part performance possession, this is a part performance possession because there is no denial of this agreement by plaintiff number 1, and plaintiff number 1 does not come to box. Then if the agreement says that I am in part performance, then in possession in part performance, then notwithstanding the limitation expiring for specific performance, I am entitled for possession. That is why
I am going to declare.
Yes, madam.
I am going to declare that the plaintiffs are not entitled for any share. But at the same time,
yes,
defendant number 1,
yes,
does not get ownership, but is only entitled for perpetual injunction to protect his possession. That is all you are entitled.
Very well, my lord. All right, start ಮಾಡಿ ನಾನು ನೋಡೋಣ ಮತ್ತೆ let them come forward if the same they come for a reasonable settlement ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳೋಣ ಬೇಕಿದ್ರೆ. What else I can do? Your lordship kindly see, ಇದನ್ನು ಹೇಳಿದೆ ನಾನು, there is a land acquisition of some portion. We are not able to find out exactly what it is. ಅವರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ನಮಗೂ ಗೊತ್ತಿಲ್ಲ. ಯಾಕಂದ್ರೆ ನಮ್ಮವರು ಪಾಪ ಅವ್ರಿಗೆ ಅವ್ರ ಸತ್ತೋದ್ರು, ಮಕ್ಕಳಿಗೆ ಅದರ ವಿಷಯ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಅದನ್ನ ಮಾಡ್ಕೊಂಡು ಮುಗಿಸಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು ಹೋಗ್ತಾ ಇಲ್ಲ, 1/3 ತಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರೆ. I went for surrendering 1/3, even though I paid for the full amount, full property, so that there may be some settlement for rights. ಅದಕ್ಕೆ ಹೋಗ್ತಾ ಇಲ್ಲ ಅವರು.
Please see circumstance also, Mr. Sharma.
Yes.
This property was purchased in the year 1974.
Yes.
The sale consideration paid was
yes, sir.
9,000.
7,200.
7,200. Correct.
6,000 ಇವರದ್ದು ಅದನ್ನು ವಾಪಸ್ ಕೊಟ್ಟರು 75 ಅಲ್ಲಿ.
6,000 ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ.
ಹೌದು. ಅದೇ ನಾನು ಹೇಳ್ತಾ ಅದ್ರ ಬರ್ದದ್ದು ಈಗ ಓದಿದೆಯಲ್ಲ, ಅವರು 6,000 ಹಾಕ್ಬಿಟ್ಟಿದ್ರು ಅವರು ಪ್ಲೇಟಿವ್ಸ್ 1 and 2, ಅದನ್ನ ಅವರು ವಾಪಸ್ ಕೊಟ್ಟೆವು ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಬೋದು.
Please listen to me. 4,800 rupees. 4,800 rupees is the total contribution. 4,800 rupees is the contribution by the plaintiffs. Correct?
Yes.
What is the registration cost? How much is the registration cost?
ನಾನು ಅಷ್ಟು ನೋಡ್ಲಿಲ್ಲ, ಅದನ್ನ ನೋಡ್ಬೇಕು.
7 ರೂಪಾಯಿ.
But they have quantified 6,000. They have quantified and taken it back.
I am coming to your point.
Yes.
4,800 plus say about 70 rupees. Registration cost.
D12 endorse ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು ತಾಳಿ. ಸ್ಟಾಂಪ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು? 50, 100, 150, 200, 140. 240 ರೂಪಾಯಿ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ
ಅಷ್ಟೇ.
ಪ್ಲಸ್ 40 ರೂಪಾಯಿ ಕಾಗದಕ್ಕೆ 280 ರೂಪಾಯಿ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಆಗಿದೆ.
240 ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ.
240 ಪ್ಲಸ್ 40 ಎಕ್ಸ್ಟ್ರಾ ಇದೆ ನೋಡಿ. 280 ಅಂದ್ರೆ ಡಿವೈಡೆಡ್ ಬೈ 3, 90 ರೂಪಾಯಿ 280.
ಅಲ್ಲ ತಮಗೆ ಇದರಲ್ಲಿ ಪೇಜ್ 2 ಆಫ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕಾಗದ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸರಿ,
ಪ್ಲಸ್ 40 ರೂಪಾಯಿ ಕಾಗದಗಳು ಕೊಟ್ಟಿರುತ್ತೆ.
ಸರಿ,
280, 250, 5,050 ರೂಪಾಯಿ.
ಸರಿ,
5,050 ರೂಪಾಯಿಗೆ 6,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದೀರಿ.
ಸರಿ, ಅದಕ್ಕಾಗಿ ಅವರ ರಿಸೈಟಲ್ ನೋಡಿ, ನಾವು ಕೊಟ್ಟ ನಮ್ಮ 6,000 ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಆ ತರ ಬರೆದಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ದಟ್ ಮೀನ್ಸ್ ವಾಟ್ ದೇ ವರ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಬ್ಯಾಕ್ ವಾಸ್ ಓನ್ಲಿ 6,000. ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಎಲ್ಲ ಸೇರಿಸಿ ಇರಬಹುದು.
6,000 ರೂಪಾಯಿ ಏನ್ ಖರ್ಚಾಗಿತ್ತು ಅದು ವಾಪಸ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಹೌದು.
It is not as if they got a profit out of this.
ಇಲ್ಲ, ಪ್ರಾಫಿಟ್ ಇಲ್ಲ. That's what I'm saying. They purchased jointly and they invested. They did not want that investment. They wanted the amount back. The amount was quantified as 6,000, paid back. So ಅದನ್ನ ಅವ್ರಿಗೆ ಏನು ನಷ್ಟವಿಲ್ಲ, ಏನೂ ಇಲ್ಲ. They agreed, all of them. That is what I'm saying. Once they come to that, now going back after the entire thing has been developed, pump ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಎಲ್ಲ ಡೆವಲಪ್ ಆಗಿ ಕೃಷಿ ಮಾಡಕ್ಕೆ ಶುರು ಮಾಡಿದ ಮೇಲೆ in 94 they wake up.
Yes.
That is why the conduct also ನೋಡಿ, ಅದು ಸೈಲೆಂಟ್ ಆಗಿ ಅಷ್ಟು ವರ್ಷ ಇದ್ಬಿಟ್ಟು ಇದ್ದಕ್ಕಿದ್ದಂಗೆ ಬರ್ಬೇಕಾದ್ರೆ
ಫ್ರೈಡೆ ಅದ್ರೊಳಗೆ ಏನೋ ಮಾಡ್ಕೊಳ್ಳೋಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
My lord, few things I just would like to bring to your lordship's notice, my lord. Maybe by way of reply, my lord. The appellant claims that I did not act till 1994, my lord. It has specifically taken the contention in my plaint that till 94 they did not act adverse to me. Only somewhere during 94 when they started acting against me, I was constrained to file the original suit. Till that I was under the impression that the properties are in the joint possession, my lord. This indicates my stand that I am not aware of the sale agreement. Because if at all I was aware of the sale agreement, I would not have waited till then. I never knew that the so-called blank sheets have been converted into sale agreement. So throughout I was under the belief that we are in the joint ownership of the property, my lord. That is one thing.
Sir, I would have understood whatever you said. But the problem is you have put your date also.
Yes, my lord. No, I'm not dealing with execution.
Plaintiff number 1 has put the date of the agreement 15/1/1975 the date ಕೂಡ ಹಾಕಿದ್ದಾರೆ.
ಅದು ಸಿಗ್ನೇಚರ್ ಕೆಳಗಡೆ ಹಾಕಿನ ಸ್ವಾಮಿ, ನಾ ಅದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿಲ್ಲ. But at that point of time, we were not made aware for what purpose it is going to be used. Even for argument's sake, if we agree that if at all they intended to for the sale agreement, if at all it was a sale agreement, what prevented them till date to go for the specific performance? This itself clearly shows that they never intended to sell.
That is why I said they're only entitled for part performance, nothing else.
In addition to that, my lord, I have also sought for possession declaration, my lord. That being the case, I have not only sought for share of 1/3 each, my lord.
Possession cannot be recovered, Mr. In the light of 53A, you cannot recover possession is the law declared by the full bench of this court, even if they don't file a suit for specific performance in time.
That I do understand, my lord. No, my lord, that only limited purpose here, my lord, is that what I would like to canvass is, yes, they can take protection under 53A and I cannot recover the position. When, if it was delivered to them as part of...
Tentative. This is only tentative. I'm not saying that I'm going to hold it.
No, my lord. I'm not taking that. No, what I'm saying is that, my lord, 53A will come into the picture if I had considered that I had put them in part performance of the sale agreement. Throughout, I have denied, except the signature. Throughout, I have denied that it was not for the sale agreement. In addition to my signature, they have not laid any other evidence, because if at all it was to be a genuine sale agreement, at least there should have been some independent witness for this transaction, which is not there. So in the absence of all this, just taking advantage of my relation or trust with the appellants herein for having signed a blank paper, can they take advantage and to create a sale agreement out of the blank paper, my lord? That is what my case is. So under these circumstances,
Mr. Sharma, where have you stated about the requirements of 53A?
Return statement ಒಂದು ನಿಮಿಷ ಪಾರ ಎರಡು ಕಾರಣದಲ್ಲಿ ಹೇಳಿದ್ವಿ ನೋಡಿ. ನೋಡಿ ಲಾಸ್ಟ್ ಗೈಡ್ಲಿ ಸಿ ಈ ಪೇಜ್ 8 ಅಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ accordingly on your last got there is a reference regarding this return statement filed, page 8 of the paper book. Accordingly on 15/175 the plaintiffs have executed an agreement in favor of the defendant wherein they have specifically mentioned they are not in position sorry typing mistake to cultivate the plaintiff scheduled property due to their personal problem. They have further told that they have decided to agree to transfer the right in favor of the defendant for valuable consideration of 6,000. Accordingly, on 15/175, they have received consideration of ₹6,000 from the defendant over the value of their share over the plaintiff scheduled property. Accordingly, the plaintiffs put the defendant in possession of the plaintiff scheduled property in part performance of their contract. The lordship got it in the middle.
Yes, where's the requirement of 53A?
ಅದೇ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದೆ, ಅದೇ ಅಮೌಂಟ್ ಕೊಟ್ಟರು, ಫುಲ್ ಕೊಟ್ಟಿದೆ, ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. It has been ಅದಕ್ಕೆ once the full amount is paid, readiness and willingness ಆಮೇಲೆ ಬರೋಲ್ಲ, because the only obstruction was as my learned friend also says, some legal hurdle was there. So from my part, everything has been done. The 6,000.
Where is the willingness to get it? Where is the willingness to get a sale deed from the defendants?
ಅಲ್ಲ, ಅದಕ್ಕೆ next ನೋಡಿ. It has been specifically agreed that agreement that in view of the legal impediment, next sentence, the sale deed could not be registered. It is further agreed that plaintiffs that they will execute the registered sale deed in favor of the defendant, transferring their right over the plaintiff's property at any time on obtaining necessary permission from the concerned authorities. In fact, there was also legal hurdle in respect of all the properties held by Sri Kantarada Narasimharaja Wadeyar, originally pertaining to the abolition of privy purse. However, from the date of execution agreement, the defendant has been absolute possession of plaintiff's property in part performance of the contract. He has paid the entire sale consideration to the plaintiff.
Yes.
So
where is the willingness to conclude? Where is the willingness?
That is what I'm saying. Any time after the permission is obtained, it has to be done. That has not been done so far. And in the meantime, they filed the suit.
So where have you showed your willingness to conclude the transaction?
That is why I was submitting, my lord. Permission had to be obtained by them. They have not yet obtained permission.
What? Elli the permission, elli the torsi agreement.
Agreement permission bardilla, but why it has been diagram is.
Suit was filed in 94, my lord. It's not.
Please wait, Mr. Mohan. You have not answered the question.
I'm sorry.
Willingness elli the torsi.
ಇನ್ನೊಂದು then para 6 ಅಲ್ಲಿ page 11 ಅಲ್ಲಿ ನೋಡಿ. There is no cause of action for the suit. The claim of the plaintiffs are barred by time. Further, the plaintiffs are stopped from claiming any share over the plain scheduled property as they have received the entire consideration of rupees 6,000 from the defendant in respect of the value of the shares over the scheduled property from the defendant, and they have handed over the original documents to a title in respect of the plain scheduled property. In fact, defendant has made lot of improvements over the plain scheduled property, and he has dug the well and erected pump set. Pump set has been erected by the defendant alone, and electricity meter also stands in his name and alone, and has been paying the electricity charges. The said aspect amply proves the defendant has been in absolute possession of plain scheduled property. So that is all the way it is. Nothing else has to be done by me.
Please decide before Friday, whatever you want to decide.
No, I have because the suggestion came that day. I made them. I talked to my clients. The leader.
So now the clock has started ticking. Clock has started ticking. You have time up to Friday.
No, let him also speak about it. I am your Lordship kindly see. I will not go back from that and what they are.
I'm saying this to both of you.
45% I have spoken to them, my lord. They are agreeable. Whatever the existing position on that 45% I'm willing to take and give them the lion's share of 55%, my lord.
Yes.
It is not 45-55. I am the owner of 1/3 share already. Admittedly, the 2/3 have to be shared now by settlement. For that, the suggestion was half. That means 1/3 has to come to you and 2/3 has to come to me. That is a suggestion for which I made them agree. Though they said that Yalla Dudkotbitu now Tekondidini sir now yak Oppisidini. Let him convince his people that they have already taken entire thing. ಅದು ಮಾಡ್ಕೊಳ್ಳಿ ಒಪ್ಕೊಳ್ಳಿ ಅಂತ ನಾನು ಹೇಳಿದೆ. ಅದಕ್ಕೆ ಒಪ್ತಾ ಇಲ್ಲ ನಾನು ಏನು ಮಾಡಲಿ?
Or list on Friday for dictating judgment. In the meanwhile, if you want,
I am open. I am giving an offer to my friend even today now at the moment. ಯಾಕಂದ್ರೆ once ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ ಇಬ್ಬರಿಗೂ ಸುಖ. ಅದನ್ನ ನಾನು ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ ಅವ್ರು ಒಪ್ಪಿದ್ರೆ ರೆಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ನನ್ನ ಕೈಲಿ ಆಗಲ್ಲ. 45 ಮಾಡಕ್ಕೆ ನನ್ನ ಕೈಲಿ ಆಗಲ್ಲ. They will not agree. They will mistake me.
It is all left to both of you.
I will try once again. Yes, my lord. I will try once again, my lord. I will try to convince once again, my lord.
Yes, list on Friday.
Obliged, my lord.
For dictating judgment. Yes. Next.
Your worship will not require the judgment, my lord. The copy ಕಳಿಸಬೇಕು ಇದನ್ನ ILRದು.
ಬೇಕಾಗಿಲ್ಲ 3230 ತಾನೆ.
ಹೌದು. ಅದೊಂದು ಇನ್ನೊಂದು ಅಡ್ವರ್ಸ್ ಇನ್ಫರೆನ್ಸ್ಗೆ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 ಹ್ಯಾಸ್ ನಾಟ್ ಕಮ್ ಟು ಬಾಕ್ಸ್. ಅದಕ್ಕೆ ಜಜ್ಮೆಂಟ್ ಕಳಿಸ್ಬೇಕಾದ್ರೆ 99 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 2 ಇದೆ. ಅದು ಬೇಕಾಗಿಲ್ಲ. ಸರಿ, ಓಕೆ. ಅದನ್ನ ಓಕೆ ಮೈ ಲಾರ್ಡ್, I will keep this in mind and Friday I will appear.
What is this? ಏನು
and they are specifically made the marriage birth of second marriage to Raja. But they have admitted they have not produced the birth certificate. Admittedly they have not produced the birth certificate. As for the records, except for the lady.
ಆಯ್ತಪ್ಪ, but what about this? ಹೆಂಗೆ ಪ್ರೂವ್ ಮಾಡೋದು? What is the proof of marriage? How to marriage? ಹೆಂಗೆ ನೀವು ಹೇಳಿ? According to ಆಯ್ತಪ್ಪ, what about the evidence of PW 2, 3, 4, 5, 6? ಓದಿ ಎಲ್ಲಿ ಓದಿ. ಯಾರು PW? ಏನ್ ಹೇಳ್ತಾರ ಅವರು?
ಜವರೇಗೌಡನ ಮಗ ರಾಜೇಗೌಡ ಇದ್ದರೆ ಯಾವ ಹಿಂದೂ ಮನೆಗೆ ಗೊತ್ತಿಲ್ಲ. ಜವರೇಗೌಡನ ಮಗ ರಾಜೇಗೌಡ ಅಣ್ಣತಮ್ಮನಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಜವರೇಗೌಡನ ಮಗ ರಾಜೇಗೌಡನ ಯಾರು ಹಿಂದೂ ಮನೆಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದೇ ಜವರೇಗೌಡನ ಮಗ ರಾಜೇಗೌಡ ಮತ್ತು ಅದೇ ರಾಜೇಗೌಡನ ಕುಟುಂಬಕ್ಕೆ ಎಷ್ಟು ತೆಗೆದು ಮತ್ತು ಯಾವ ಸಂಬಂಧ ಬೆಂಗಳೂರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಗ್ರಾಮದ ಜವರೇಗೌಡ ಮಗ ರಾಜೇಗೌಡ
ಆಯ್ತು. PW3 ಏನ್ ಹೇಳ್ತಾರೆ?
ಒಂದನೇವಾಗಿ ಒಂದಮ್ಮ ಇವಳು ನನ್ನ ಅಣ್ಣನ ಮಗಳಾಗಿರುವುದು ನಾಲ್ಕರು ವಿಶ್ವಾಸ ಇದೆ. ಈ ಕೇಸಿನಲ್ಲಿ ಸಾಕ್ಷಿ ಕೊಡಲು ಒಂದನೇವಾಗಿ ನನ್ನನ್ನು ಕೇಳಿಕೊಂಡಿದ್ದರಿಂದ ಅವರ ಮದುವೆ ಆಗಿರಲಿಲ್ಲ. ಮೊದಲನೇ ಬಂದು ಶೆಟ್ಟಿ ಒಟ್ಟಿಗೆ ವಾಸವಾದ ಯಾವುದು ಯಾವ ವಿಷಯಗಳು ನನಗೆ ತಿಳಿದಿದ್ದರಿಂದ
ಮದುವೆ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ? ಅನ್ನೇಗೌಡ ಮದುವೆ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ? ಎಸ್ ಮಿಸ್ಟರ್ ಮದುವೆಗೆ ಬ್ರದರ್ ಬರೋದು ಇನ್ಯಾರು ಬರ್ತಾರೆ? ಏನ್ ಹೇಳ್ತಾರೆ ಅನ್ನೇಗೌಡ ಮದುವೆ ಬಗ್ಗೆ? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಅನ್ನೇಗೌಡರು ಹೇಳಿದ್ದಾರೆ. ರಾಜೇಗೌಡ ಏನ್ ಹೇಳ್ತಾರೆ? PW4. ಅಲ್ಲ ಅದ್ ಮದುವೆ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀವಿ?
ನಾನು ಮದುವೆ ಮಾಡಿದ ದಿನ ಸರಿ ಜಗಳಗಳ ರಾಜ್ಯ ಎಲ್ಲ ಅಡೆಗಳು ಮುಂದನವಾಗಿ ಒಮ್ಮಮ್ಮ ಅಡೆಗಳನ್ನ ತಮ್ಮ ರಾಜ್ಯಗಳನ್ನು ಮದುವೆ ಮುಂದನವಾಗಿ ಒಮ್ಮಮ್ಮ ಅಡೆಗಳನ್ನ ತಮ್ಮ ರಾಜ್ಯಗಳನ್ನು ಮದುವೆ ರಾಜ್ಯಗಳು ಮತ್ತು ತಿಳಿಸುವುದಿಲ್ಲ ಈ ದಾಳಿಯನ್ನು ಒಮ್ಮಮ್ಮ ಮತ್ತು ರಾಜ್ಯಗಳ ಹಿಂದಿನ ವಿಷಯವಾಗಿ ಹಾಕಿದ್ದಾರೆ ಒಂದನ ವಾದ್ಯ ಮಗಳ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ನಾನು ಪುನಃ ಒಂದನ ವಾದ್ಯ ಮಗಳ ಹೆಸರು ಸೌಮ್ಯ ಒಂದನ ವಾದ್ಯ ನೀವು ಹೆಂಡತಿ ಜೊತೆಯಾಗಿ ಅವರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸರಿ ಇಲ್ಲ
ಅವರು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಮದುವೆ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಬೊಮ್ಮೇಗೌಡ PW5. ಮತ್ತು ವಿಕ್ರಮ ಹಾಗೂ ಕುಂಬಾಳಮ್ಮ ಎನ್ನುವ ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ. ಸಾಮಾನ್ಯವಾಗಿ ಊರಿನ ಜನರು ನನ್ನನ್ನು ಕೇಳ್ತಾರೆ. ಈಗ ಈ 1973 ಕರೆಯುತ್ತಾರೆ. ಮದುವೆಗೆ ಬಂದಿದ್ದ ಪುರೋಹಿತ ಒಂದನೇ ಮುಖ್ಯವಾದ ಸಮಯಕ್ಕೆ 19 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು. ಊರಿನ ಅಂದ್ರೆ ರಂಗೇಗೌಡನ ಕುಟುಂಬಕ್ಕೆ ನಾನು ಕಾಯ್ದೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಖಾತೆಯನ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಒಂದನೇ ಮುಖ್ಯವಾಗಿ ಸಹ ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಮತದಾರರಾಗಿದ್ದು ಎಲ್ಲ ಚುನಾವಣೆಗೂ ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಮತ ಚಲಾಯಿಸುತ್ತಾರೆ. ನಮ್ಮ ಗ್ರಾಮದ ಮತದಾರರು ಅವರು ಮದುವೆ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಅವರು ಮದುವೆ ಬಗ್ಗೆ ಮಾತಾಡಿದ್ರು. ಹೌದು, ಇನ್ನೇನು ಅವರೇ
not even a birth certificate, not even a photo, nothing. You have to prove the marriage in accordance with the act. You have not proved. Moreover, the evidence says. Moreover,
section 50 ಓದಿ.
Moreover, they says.
ಓದಿ ಸರ್, 50 ಓದಿ ಸರ್.
Moreover, they says they don't know who is Devegowda.
ಆಯ್ತು, that is only PW1, PW2 ಮಾತ್ರ.
ದೇವೇಗೌಡನ ಮಗ ರಾಜೇಗೌಡ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ
4 ಜನ ಹೇಳಲ್ಲ, 3 ಜನ ಒಬ್ಬರೇ ಹೇಳೋದು. PW2
even though they are admitted witnesses, they says they don't know the ರಾಜೇಗೌಡ's father, ದೇವೇಗೌಡ. ಅವರೇ ಹೇಳ್ತಾರೆ, ಅವರೇ ಹೇಳ್ತಾರೆ. Therefore, I have specifically taken condition in my written statement that the marriage of Rajagowda was not solemn. He was suffering from illness. He was young. Therefore, it is burden on them to prove the marriage. I have specifically taken this context. They can't shift the burden on the defendant. Either they will not even produce the school records. PCR, admission register, birth certificate, ration card.
ಡಿಫೆಂಟ್ ವಿಟ್ನೆಸ್ ಯಾರು? PW1 ಯಾರು? ನಾವು ಅಂದ್ರೆ ರಾಜೇಗೌಡನ ಹೆಂಡತಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ರಾಜೇಗೌಡನ ಹೆಂಡತಿ ಕೊಂಬಮ್ಮ, ಸೌಮ್ಯ ಇನ್ನೊಬ್ಳು. ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಲ್ವಾ? ಪ್ಲೇಂಟಿಫ್. ರಾಜೇಗೌಡನ ಹೆಂಡತಿ ಎಷ್ಟೇ ನಂದಿದ್ರು. ರಾಜೇಗೌಡ died unmarried. He was a bachelor.
He was suffering from illness.
I agree.
In Canada, आपकी interstate में ಯಾವ ಕಾಲದಲ್ಲಿ ಇಂಜಿನಿಯರ್ ಆಗಿ ಒಂದನೇ ವಾದಿಯ ಎರಡನೇವಾಗಿ ಒಂದನೇ ವಾದಿ ಕೆಲವು ಅಂಶಗಳು ಸುಳ್ಳು
ಮಿಸ್ಟರ್ ನಿಂಗಜ್ಜಮ್ಮ
is wife of
ರಂಗೇಗೌಡನ ರಾಜೇಗೌಡನ ರಾಜೇಗೌಡ ಅಂತಿದೆ ಇಲ್ಲಿ. ನಿಂಗಾಜಮ್ಮ ಮಿಸ್ಟರ್ ಸೋಮಶೇಖರ್, ರಾಜೇಗೌಡರು ಮದುವೆ ಆಗಿಲ್ಲ ಅಂತ ನಿಮ್ಮ ಊರ್ನವ್ರನ್ನ ಯಾರಾದ್ರೂ ಸಾಕ್ಷಿ ಮಾಡಿದೀರಾ? ರಾಜೇಗೌಡರು ಮದುವೆ ಆಗ್ಲಿಲ್ಲ, ಕಾಯಿಲೆ ಇತ್ತು, ಹಂಗೆ ಸತ್ತೋದ್ರು ಅಂತ ನಿಮ್ಮೂರ್ನವ್ರ ಏನ ಸಾಕ್ಷಿ ಮಾಡಿದೀರಾ? ಮಿಸ್ಟರ್
some suicide of that village, senior person, a leader person, other than family members, they're not abusing any of us.
So they have to speak about, they have to speak.
As a example, they said, I don't know, Sunday, I don't know, the
ಅಷ್ಟೇ ಅಲ್ವಾ?
and stay on it. More right. Specific matter. There are 7 of the interstate. ಒಂದನೇ ಪ್ರತಿವಾದದಲ್ಲಿ ಯಾವುದು ಇರಲಿಲ್ಲ. ಹುಟ್ಟಿನಿಂದ ಕಾಯಿಲೆಯಿಂದ ಬಳಲುತ್ತಿದ್ದು ಗಟ್ಟಿಯಾಗಿದ್ದು ಒಂದನೇ ಪ್ರತಿವಾದದ ಹುಟ್ಟಿನಿಂದ ಆಗಾಗ್ಗೆ ಕೈಯಲ್ಲಿ ನೀರು ತೆಗೆದುಕೊಳ್ಳುವುದು, ದೇಹ ಒದ್ದಿಕೊಳ್ಳುವುದು ಮತ್ತು ದೇಹದಲ್ಲಿ ಆಗಾಗ ಬದಲಾವಣೆ ಒಂದನೇ ಪ್ರತಿವಾದ ವಿವಾಹವಾಗಿ ಪರಿವಾರವಾಗಿ ಉಳಿದಿರುತ್ತಾರೆ.
ಯಾರು ಹೇಳ್ಬೇಕು?
ನಮ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್
ಅದ ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡಿದ್ರು? ಮಾಡಿರಲ್ಲ. PW 2, 3, 4, 5
and moreover, in the super partition, admittedly there are key numbers you have to say right, but I may permit it to rely on the judgments with regard to the marriage. And in the reported case, the 2005 court cases of Kerala, into marriage act 1955, section 7, evidence of 1876.
ಇಲ್ಲ ಎಲ್ಲಿದ್ದಾರೆ? ಕಾಪಿ ಕೊಡ್ರಿ. ಕೊಡಿ.
The JR 1984 Supreme Court. 2025.
Yes.
The Hindu marriage act 25/16/17. Accompanying marriage. Proof. Custom not traded. Nature of ceremonies performed not brought out. Living together as husband and wife. That by itself could not confirm status of husband and wife.
ಅದು ಹೇಳಿದಿರ ನೀವು? Is it your case that ಎಮ್ಮೋ ಜೊತೆ ನಾವು ಇದ್ಲೋ?
ನಾವು ಮದುವೆನೇ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ
ಮತ್ತೆ ಈ ಜಜ್ಮೆಂಟ್ ನಿಮ್ಗೆ ಹೆಂಗ್ ಹೆಲ್ಪ್ ಆಗ್ತದೆ? ಗಂಡ ಹೆಂಡತಿ ತರ ವಾಸ ಇದ್ರು ಅನ್ನೋದು ಮಾತ್ರಕ್ಕೆ ಗಂಡ ಹೆಂಡತಿ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಆಯ್ತು ಏನಾಯ್ತು ಸಿಂಗಲ್ genealogy. Genealogy certificate issued to the complete authority. Not even the birth certificate of second degree. From the TC.
Yes.
TC and school records and help produce my.
Yes, study certificate ಇದೆಯಲ್ಲ.
Study certificate and TC produce ಮಾಡಬೇಕು. the official practice, what has to be look into the practice of the official person.
The court also has to look into the way. Complaint ಮಾಡಕ್ಬಿಡ್ರಿ ಹಳ್ಳಿ ಕಡೆ ಹೆಂಗ್ ನಡೆಯುತ್ತೆ ಅಂತ ಕೋರ್ಟ್ has to take into consideration. ಹಳ್ಳಿ ಕಡೆ ಹೆಂಗ್ ನಡೆಯುತ್ತೆ ಅದನ್ನು ಕೋರ್ಟ್ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಲ್ವ. ಸೋಷಿಯಲ್ ಮಿಲೇಯು ಆಲ್ಸೋ has to be looked into. ಮತ್ತೆ
they merely they have shifted the burden on the defendants. There is no doubt that only one person is had evidence, give everyone only examination. But here in the case, all the family members.
ಬರ್ಕೊಳ್ಳಿ ಸೋಮಶೇಖರ್ ಸಾಕು.
With regard to the chairman, but admittedly, when I should come to the architecture, the voice. Lingarajama and Ajay Gowda and another 6 people in Pitama, 3 persons, 2 sons and 1 daughter.
ಯಾರ್ಯಾರು? ರಾಜೇಗೌಡ,
Ajay Gowda and Pitama, 6 people. 2 children.
and ಗಿಡ್ಡಮ್ಮ.
Pitama. ಇವರು ಗಂಡು ಮಕ್ಕಳು Pitama ಏನು ಶೇರ್ ಇದು ಮಾಡಿ ಹಾಫ್ ಶೇರ್ ಅಂತ ಮಾಡಿ ಇವರು ಹಾಕು ಅವರು ಹಾಕು. So therefore, with regard to 19 degree of offset in all the properties is bad in it.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಈಗ declare that the plaintiff intended for offset needs and policy is property. Offset ಕೊಡ್ತಾರೆ ಮುಂದೆ ಕೊಡ್ತಾರೆ
ಹಿಂಗೆ
ಈಗ female member also 30% in property. Can family property.
Suit is filed in 2003.
2003 there is no partition affected between family members. Can family property. That is also equally 80% in the other property. ಮುಂದೆ ಕೊಡ್ತಾರೆ.
ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಯಾರು?
ಇಲ್ಲಿ ನಾವು ಅಪೀಲ್ ಅನ್ನು ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದೇವೆ. ಅದರಲ್ಲಿ ಇನ್ನು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಕ್ಕಡೆ ನಾವು ಟ್ರಾನ್ಸ್ಫರ್ ಹಾಕಿ ನಾವು ರಿವರ್ಸ್ ಡಿಪೆಂಡೆನ್ಸ್ ಇದ್ದೀವಿ ನಂಬರ್ 14 that is the response made of substantial to allow the property and the district of after the house and the same property as possible by allowing them how to then point and have a photo to the ಎಲ್ಲದನ್ನು ಆಕ್ಷೇಪ ಮಾಡಿದೆ. ಅಡ್ಮಿಟೆಡ್ಲಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್
ಆಯ್ತು ಶೇರ್ ಬಗ್ಗೆ ಹೇಳಿ. ಶೇರ್ ಬಗ್ಗೆ So what about the share to defend number 6 Kitama? Yes, Sandra? Claim ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಬಟ್ the appeal is filed by whom? ಗಿಡ್ಡಮ್ಮ ಹಾಕಿಲ್ವಲ್ರಿ? ಗಿಡ್ಡಮ್ಮನಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ನಿಮ್ದೇ ಗಿಡ್ಡಮ್ಮ ಬಂದಿಲ್ವಲ್ರಿ ಕೋರ್ಟ್ಗೆ? ತೋರಿಸಿ ಯಾವ್ದಾದ್ರು ಏನಾದ್ರು ಕಾನೂನು ತೋರಿಸಿರಿ.
Even when the Supreme Court recent judgment,
ಈ ಕೇಸಲ್ಲಿ ಗಿಡ್ಡಮ್ಮ is not filed an appeal before the first appellate court and also before this court.
judgment pass the airport itself is really action ಕೊಡಕ್ಕೆ ಬರಲ್ಲ. ಆಮೇಲೆ ಮತ್ತೆ ಒಂದು ಕಡೆ ಅಂತ ಈಗ ಒಂದು ಫುಲ್ ಕೆಳಗೆ ಬರಲ್ಲ but I think it is clear and whether she is entitled for action or not here and see university ಅಂತ ಮಾಡಬೇಕು.
ಹೆಂಗೆ ಅಂತ ಹೇಳಿ.
Two sons one daughter.
ಅದೇ ಹಂಗಾದ್ರೆ 1/3 ಈ ಕೇಸಲ್ಲಿ 2003 ನಲ್ಲಿ ಶೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು.
2003 ನಲ್ಲಿ ಮಾಡಿರೋದು. ಇವತ್ತು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ all the family partition is not affected. Between the family members all are equally entitled for share.
ಯಾವ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಲೇಟೆಸ್ಟ್ ಅದು ಯಾವ್ದು ಅಂತ ಹೇಳಿ.
Even Justice Ramandan confirmed that doctors are also equally entitled for share. That has been appointed in another judgment.
ಯಾವುದು ನಾಳೆ ಹೇಳಿ. Whether pending proceedings also will get affected by the Act of 2005 ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಮೂರು ಕ್ವಶನ್ ಹೇಳ್ಬೇಕು ನೀವು, 3 ಕ್ವಶನ್ ಉತ್ತರ ಕೊಡ್ಬೇಕು. ಸ್ವಲ್ಪ ಹೇಳೋದು ಕೇಳ್ರಿ. 3 ಕ್ವಶನ್ 2003 ನಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು. ಡಿಗ್ರಿ ಆಗಿದೆ ಯಾವಾಗ, ಎಷ್ಟನೇ ಇಶ್ಯೂ ಡಿಗ್ರಿ ಆಗಿದೆ? 2007. Whether the Act of 2005 impacts pending proceedings, ಅದಕ್ಕೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ. ಓಕೆ, ಸ್ವಲ್ಪ 3 ಕ್ವಶನ್ ಒಂದೇ ಹೇಳಿರೋದು. ಇನ್ನ 3 ಕ್ವಶನ್. ಎರಡನೇದು, ಇವ್ರು ಗಿಡ್ಡಮ್ಮ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. Whether the other defendants can argue for Giddamma, whether the other defendants can seek a share for Giddamma when Giddamma does not file an appeal. That is the second question that you will have to answer. Third question is, what will be the share? Whether section 6 ಅಲ್ಲಿ before it was amended should apply or after amendment it should apply. ಅದನ್ನ ಹೇಳ್ಬೇಕು. 3 questions you will have to answer. Tomorrow 3 ಕ್ವಶನ್ ಹೇಳಿದೀನಿ. ಜಜ್ಮೆಂಟ್ ಇವ್ರದ್ದು ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ. ಸ್ವಲ್ಪ yes. Yes.
Did not take the agreement application to the nevertheless they filed the suit.
ಯಾವ್ದು 753 ಅಲ್ಲ,
1150 ಮೂರು ಕೇಸ್ ಹಾಕಿದ್ರು. 13 ಗುಂಟಾದು 22 ಗುಂಟಾದು.
is there? How can you?
Like this. The post hold the right position.
Where is that?
By opens. Well, page 71, page 71. Well, page 10.
10 internal page. Para?
Well, page 10, in page 71. I'm reading 1153.
Yes, yes. 753 now. 753.
753, page 73. Identical judgment already.
What?
Plaintiff claiming that he became owner of the specific property by way of adverse this property. Even when a judgment plus even though the plaintiff is
Even if you claim, now the Supreme Court in Grewal judgment has said that you can claim. The question is, when did you enter possession? When did it become adverse?
My contention is that we entered possession in 1923. But the documents indicate that we are possessing property. We say that the government made a list of persons who are in unauthorized occupation. That's exhibit P13. P11, list of encroachers. And on exhibit P1, what the notice issue, meaning that you have encroached on government land.
What is the date of exhibit
That is in
P1?
2012.
1933 in the end, the
documents, exhibits, RTCs and the other documents are shown that I have produced one document 33 of the neighboring property which my grandfather owned, our document had. So all these properties, all four land neighbors.
So in 1933, your grandfather has got a land.
That was a small land, 114 only on 120 and the Pakal is not small lake
an application even not.
I see what they are trying to say. I wanted to approach the government and seek to grant the land. Last number of people have granted small bits of land. These two people.
See, we do not know. Please listen to me. Defendants are not contested the suit. Correct? We do not know whether you are in possession. We do not know somebody else is in possession. When we injunction put right, we will go there and discharge somebody else. We do not know.
Admits that I am in possession. Exhibit P1 P1 you are encroached upon government land and all of them. I don't what the Ashlar says is that this
the suit is filed in 2012. Tahsildar notice is in 2012. So what has happened to the proceedings before the Tahsildar? How is the suit maintainable? This is directed to list RSA 1150 of 2019. After vacation. This after. Seal number 40 and 41 at the request of the Council for Appearance list after vacation.
Nothing I do.
This is
the degree challenging the same day and preferred an appeal matter. And then he has succeeded. Challenging the same, I have preferred an appeal matter. This is the case where land was granted to the appeal matter by a particular architecture rights matter, land federal order matter. I claim I have exclusive right to this property because the land federal order gives me not
what the plaintiff and defense related.
That's the plaintiff's mother and the defendant's father assisted controller. The defendant that though it was occupancy rights was granted in the name of the plaintiff, it was actually granted to the family. Since the grandfather was cultivation of the land, so the land belongs to the entire family. And hence the direction for possession cannot be given because he is also a joint owner of that property.
Where is the form number 7? Where is the form number 7 that you have filed?
Has been marked as exhibit P4, P2, my lord.
Where is that? I have a copy of that. Issue notice.
I appear for the petitioner, appellant, my lord. Lord, suit for partition dismissed by both the courts below on the ground that, my lord, that it is the self-acquired property of the defendant number 1. Despite he admitting, my lord, that the form number 7 was filed on behalf of his grandmother Umakka Hengsu, which is admitted in his written statement. And he was in possession of the property, no doubt, my lord. That is why the trial court says that since he has been in possession of the property for 30 years, and the plaintiff being the brother, and defendant number 2 and 3 and 4 being their his nephews, did not object to it for 30 long years. That is the conclusion arrived at by the trial court, my lord. Exhibit P14 is the form number 7, my lord. Exhibit P14, where he clearly says,
what does it say?
Lord, may I read that, my lord? I have a copy of it. May I read that, my lord? Lord, Geni Hakku Umakka Hengasu Karkala Avara Maga Angara Shetty Umakka Hengsu Heseralidda 90 ವರ್ಷದ ಉಮ್ಮಕ್ಕ ಹೆಂಗಸನ ಹೆಸರಿನಲ್ಲಿದ್ದ ಜಾಗವನ್ನ ಅವರ ಮೊಮ್ಮಗ ಅಂಗಾರ ಶೆಟ್ಟಿ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ, ಅರ್ಜಿದಾರನು 31 ವರ್ಷದಿಂದ ಲಾಗಾಯ್ತು ನನ್ನ ಅಜ್ಜಿಯ ಅಧೀನದಲ್ಲಿ ಇರುವಂತ ಜಾಗ.
What is this release date?
My lord, thereafterwards, my lord, when the plaintiff and other defendants 2, 3 and 4 seek for a partition, defendant number 1 releases his right in the suit schedule properties in favor of these plaintiff and the defendants.
Appear for caveator in this matter, my lord.
Yes. Caveators are the subsequent purchasers, my lord.
Please, my lord.
They are the subsequent purchasers.
The release date was earlier to filing of this suit has been 1 month prior to filing of suit. They have got released, my lord, by forcing. ಅದರಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಎಲ್ಲ ಇದ್ವಿ ಅಂತ ತೋರಿಸ್ಕೊಳ್ಳೋದಕ್ಕೆ ಅದೊಂದು ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ. ಮೈ ಲಾರ್ಡ್ಸ್, ಫೈಲಿಂಗ್ ದೇರ್ ಇಸ್ ನೋ ಸೂಟ್ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಅವೈಲಬಲ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ದಿ ಸೂಟ್, ಮೈ ಲಾರ್ಡ್. ಅಲ್ಲಿಗೆ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟು ದೇರ್ ಇಸ್ ನೋ, ಅಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಪ್ರಾಪರ್ಟೀಸ್ ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ ಪ್ರಯರ್ ಟು ದಟ್.
ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ. ಯಾಕೆ ಪಾರ್ಟಿಷನ್ ಪ್ರಾಪರ್ಟಿ ಮಾಯ ಆಗೋಯ್ತಾ?
ಇಲ್ಲ, ಸೇಲ್ ಆಗೋಗಿತ್ತು. ಎಲ್ಲಾರ್ದು ಆಲ್ರೆಡಿ
ಸೇಲ್ ಆಗೋಗಿತ್ತು ಅಷ್ಟೇ ತಾನೆ.
ಸೇಲ್ ಆಗೋಗಿತ್ತು. ಒಂದ್ ಪ್ರಾಪರ್ಟಿ ಪ್ಲೀಸ್ ಮೇಲೆ ಪ್ಲೀಸ್.
ಸೇಲ್ ಆಗೋದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗುತ್ತೆ?
ಸಾರಿ, ಅಂದ್ರೆ ಸೇಲ್ ಆಗಿತ್ತು ಅಂತ, ಅಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಕೇಳೋದಕ್ಕೆ ಆಸ್ ಆನ್ ದಟ್ ಡೇ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಸೇಲ್ ಆಗೋಗಿತ್ತು ಎಕ್ಸೆಪ್ಟ್ ದ ರಿಲೀಸ್ ಡೇಟ್ ಮಾಡ್ಕೊಳಕ್ಕೆ. ಅದನ್ನು ಫೈಲಿಂಗ್ ಮುಂಚೆ 1 ತಿಂಗಳು ಮುಂಚೆನೆ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ.
ಪ್ಲೈಂಟಿಫ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡಿದಾರೆ ನಿಮ್ ಸೇಲ್ ಡೀಡ್ಸ್ಗೆ?
My lord, this is the not joint family property, my lord. ಅವ್ರದ್ದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಎಲ್ಲ ಇದ್ರಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಬರೀ ಡಿಫೆಂಡೆಂಟ್ ಒಂದೇ ಇವ್ರು ಪ್ಲೈಂಟಿಫ್ ಈಸ್ ದಿ ರಿಸೈಡಿಂಗ್ ಇನ್ ಮಹಾರಾಷ್ಟ್ರ.
ಅಡ್ಮಿಷನ್ ಹಾಕ್ತಾರೆ, ಯಾವ್ದು ರೀಚ್ ಆಗೋದಿಲ್ಲ. You represent Mr. N.S. Prasad, but Mr. Kulkarni said that there is no.
My lord, Mr. Prasad told me whether there is a possibility of settlement ಅಂತ. ನಮ್ಮ ಪಾರ್ಟಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ, ಅದಕ್ಕೆ I wanted to this to seek instruction.
ನಿಮ್ಮ ಕ್ಲೈಂಟಾ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋತೀರೇನ್ರಿ? ರಾಜಿ ಮಾಡ್ಕೋತೀರಾ? ಯಾವಾಗ ಹೇಳ್ತೀರಾ? 2 ವಾರ ಇಲ್ಲ ನೋಡ್ರಿ, ಇದು 2006ನೇ ಇಸ್ವಿ ಕೇಸು. 2006ನೇ ಇಸ್ವಿ ಕೇಸು. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟನೇ ಇಸ್ವಿ? ಸಿವಿಲ್ ಕೋರ್ಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಕೇಸ್ ಇದು? 99. 33 ವರ್ಷ ಆಯ್ತು, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. ಇವಾಗ ಮಾಡ್ಕೋತೀರಾ? ಎಷ್ಟು ದಿನ ಬೇಕು? 3 ವಾರ ಇಲ್ಲ. ಮಾಡಂಗಿದ್ರೆ ನೀವು 15ನೇ ತಾರೀಕು ಮಾಡ್ಕೊಳ್ಳಿ. 15ನೇ ತಾರೀಕು 18th madam. Just on 18th as a last chance to explore the possibility of a settlement. Dictation ಕೊಡ್ಬೇಕಲ್ಲ ಮೇಡಮ್? ಓಕೆ ಮಾಡಿದ್ರೆ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ 18 ತಾರೀಕು.
Malad 15th, Malad.
18th. As the last chance. Yes. ಶುರು ಆಗಿತ್ತಲ್ವ ಇದು? ಏನಾಯ್ತು? So what is this case? Yes.
Praise the Lord. Like I have said it prior to the agreement, after the agreement, 5,000 rupees. That is
5,000 rupees per square feet. Yes.
Price, my lord, is not price is not fact, my lord, same survey number. Survey number 63. In fact, he present the case before my lord. If it is calculated 6,066. And my agreement is subsequent to this. 1 year subsequent. That was the price prevailed. The price is not a. So as far as the other aspect, my lord, that the other parties have not signed the agreement. Only the mother and one of the sister has signed. My lord, 2 notices have been issued to all the parties. After second notice, the mother receives additional citation, admitted, and my lord, they are stopped from contending now because they were put on notice. I am in possession. They are aware of the agreement. And in the state, it is not that they have filed a separate written statement, but have adopted the written statement of the mother. So they are failing with the mother. Only that they want to wriggle out of the agreement. They are stopped from contending that they are not part of the agreement. By their conduct.
What does the mother say in the written statement?
The mother's say, my lord, is that it is a loan transaction. Mother's say, my lord, this is the paper book at page 5, my lord, is the written statement. He says she is a Pardhanaship lady. Paragraph 2, my lord. It denied that defendants agreed to say the plain schedule property off on price of 90,923 or obtained 55,000 as advance or put the plaintiff in possession. In fact, the defendant number 1, I being the widow and Pardhanaship lady had borrowed in all a sum of ₹60,000 from the plaintiff and permitted the plaintiff to harvest the crops. Non possessional agreement they are put to this contention have been taken with an intention to repay the said amount after taking into account of the reaped and harvested crops. In the said transaction, the plaintiff obtained signature of defendant number 1 and the same have been fabricated to suit the convenience in order to make a wrongful gain by causing the wrongful loss. This is her contention. My lord, in fact, my lord, also see paragraph 4, my lord. Paragraph 4. Last about 5 lines from the bottom, my lord. I, wherein defendant number 1 called upon the plaintiff to render accounts and to specify the exact amount payable for which plaintiff, instead of complying with the said demand, has come up with concocted plea of agreement to sell, to which defendant number 2 to 8 never intended or agreed to sell the scheduled land. The transaction is loan transaction. So she takes a stand for the other. And it is her case that she had taken a. So there is an agreement. The burden of the bonus of proofs is she has to prove that it is a loan transaction. In what circumstances is a loan transaction? There is no evidence on record. Paragraph 8, my lord, Mr. Lord, again she says she has sent notice according to that. That has not come from the court. It's a stereotype defense that Pardhanashyan lady, one, secondly, that it is a loan transaction. I have in fact produced documents to show my readiness and willingness. Kurigal market to two notices have been issued, Lord, one on 12/5/1992, 23/5/1992. After these two notices, she takes 3,000 rupees from me on 12/3/1993 and does not come forward to it.
That is after 12/5/92.
After the second notice.
Second notice is 23/5/94.
23/5/1992.
So ಇದು ಯಾವಾಗ
So after the first notice, Lord, she takes additional sum of exhibit P30. And later on she comes for, I have put her on notice that there is an agreement. She does not deny.
What is there to show this exhibit P14 was sent to them?
So they have not denied.
What is that? What
They have
is
not
that to
denied in
show?
the written statement. I have stated so in my plate. They have not denied the figure.
What have they said about the notice?
Lord, at paragraph 3 of my plate, the plaintiff has always been ready.
Statement ಏನು ಹೇಳಿದ್ದಾರೆ? Statement ಅಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ?
There is paragraph 4 and paragraph 8. Wherein I, defendant number 1, called upon the plaintiff to render account and specify the exact amount. Plaintiff, instead of complying with the settlement, has come up with a concrete agreement to sell, which defendant number 2 to 8 have never intended to. There is no denial of receipt of funds. Paragraph 8, my lords, may kindly see, she says she has sent me some notice that she doesn't even produce those notices. With regard to my lords, with regard to estimate, under section 150 of
How is estoppel applicable between suit for special performance?
there is a judgment of the where a father acts on behalf of the son as the owner of the property, and he enters into an agreement. And subsequent conduct of the son is seen. And court has read that he is established of maintaining that he was not a party.
Good.
Paragraph 20 and 21.
Exhibit P20. What is exhibit P20? Exhibit P, what is exhibit?
Agreement, subsequent agreement. There are two agreements. ವಾಗ್ದಾನ ಪತ್ರ ಅಂತ ಒಂದು ಮಾಡ್ತಾರೆ. ಪ್ರಯೋಜಕರಾರ ಪತ್ರ ಅಂತ.
ವಾಗ್ದಾನ ಪತ್ರ is exhibit P1, P13. What is the date? 91.
ವಾಗ್ದಾನ ಪತ್ರ is dated 28/5/1991.
ಇದು
The agreement is dated 19/11/1990.
ಇದು 19/11/1990 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ದುಡ್ಡು? How much money is paid under the exhibit P20? 15,890.
Under the agreement, a sum of rupees 15,893 is paid. 15,893. Subsequently, my lord, on 4/1/1991, 25,000 rupees. The balance remains 50,000 rupees. On 12/3/1993, my lord, 3,000 rupees. The balance is 47. And immediately, my lord, after the agreement, he has taken a call. After the notice also, she received. After that, she doesn't come forward or issue another notice and I beg.
This one disconnect. You please go to this exhibit P20. ನೋಡಿ ಅಂಶ ಪೇಜ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಕ್ರಯ ಸ್ವತ್ತಿನ ಶೆಡ್ಯೂಲ್ ತಪಶೀಲು. ಕರೆಕ್ಟ್. In page number 3, we describe the schedule. February 5 ಒಂದನೇ ಪಾರ್ಟಿಯು ಸ್ವತ್ತಿನ ಕ್ರಯಪತ್ರ ಬರೆಸಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿ ಕ್ರಯದ ಪೂರಾ ಹಣ 75,000 ರೂಪಾಯಿಗಳನ್ನು ಎರಡನೇ ಪಾರ್ಟಿಗೆ ಮಾಡತಕ್ಕದ್ದು. ಸದರಿ ವೇಳೆಗೆ ರಿಜಿಸ್ಟರ್ ಕಾರ್ಯ ನಡೆಸಲು ಸಾಧ್ಯವಾಗದಿದ್ದಲ್ಲಿ 9ನೇ ಫೆಬ್ರವರಿ 5 ಒಳಗೆ ಒಂದನೇ ಪಾರ್ಟಿ ಎರಡನೇ ಪಾರ್ಟಿಗೆ ತಪ್ಪದೆ ನಿರಾಕರಣೆ ಮಾಡದೆ 50,000 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ಮಾಡಿ ಎರಡನೇ ಪಾರ್ಟಿಯಿಂದ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನ ಪಡೆಯತಕ್ಕದ್ದು. ಮುಂದೆ ಕಾನೂನು ಅನುಕೂಲವಾದ ನಂತರ ಸಮರ್ಪಕವಾಗಿ ದಾಖಲಾತಿಗಳನ್ನು ಎರಡನೇ ಪಾರ್ಟಿ ಒಂದನೇ ಪಾರ್ಟಿಗೆ ಒದಗಿಸಿದ ನಂತರ ಒಂದನೇ ಪಾರ್ಟಿಯು ಕ್ರಯಪತ್ರ ಬರೆಸಿ ರಿಜಿಸ್ಟರ್ ವೇಳೆಯಲ್ಲಿ ಬಾಕಿ 25,000 ರೂಪಾಯಿಗಳನ್ನು ಎರಡನೇ ಪಾರ್ಟಿಗೆ ತಪ್ಪದೆ ನಿಧಾನ ನಿರಾಕರಣೆ ಮಾಡದೆ ಪಾವತಿ ಮಾಡತಕ್ಕದ್ದು ಹಾಗೂ ಕ್ರಯ ಪೂರ್ಣ ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು. ಇದಕ್ಕೇನ್ ಮಾಡಿದ್ರಿ? ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಸ್ವತ್ತನ್ನು ಕ್ರಯಕ್ಕೆ ಪಡೆಯುವ ಒಂದನೇ ಪಾರ್ಟಿಯವರಿಂದ ಸ್ವತ್ತನ್ನು ಮಾರಾಟ ಮಾಡುವವರಾದ ಎರಡನೇ ಪಾರ್ಟಿಯಾದ ನಾವು ಕ್ರಯದ ಬಾಕಿ ಮೊಬ್ಬಲಗನ್ನು ನಲ್ಲಿ ಇನ್ನು 25,000 ರೂಪಾಯಿಗಳನ್ನು ನಗದಾಗಿ ಸಾಕ್ಷಿದ ಸಮಕ್ಷ ಪಡೆದುಕೊಳ್ಳುತ್ತೇವೆ. ಕ್ರಯ ಸ್ವತ್ತನ್ನು ನಿರ್ವಹಣೆ ಮಾಡಲು ಇತರೆ ಪತ್ರಗಳ ಅವಕಾಶ ಕೊಡುತ್ತೇವೆ. ಕ್ರಯದ ಬಾಕಿ ಹಣವನ್ನು ಸ್ವತ್ತುಗಳ ಬಾಕಿ ಕ್ರಯಪತ್ರ ಬಳಸಿ ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಚಾನ್ಸಸ್ ಇದೆಯಾ? Any possibility of settlement? The client is here. Yes, Mr.
We are ready to offer.
Just to some more on this. Yes. What is the value of the property today? Huh? Just put the
I don't know if we get to the day. This is melodious. I went on whatever training has been made. From that trade, that much of time. For the balance, I will ask my friend, ask for today. Both the game, beಲೆ ಇತ್ತು
ನಾವು ಕಟ್ಟಿದೀವಿ. ಅವ್ರು ಎಷ್ಟು ದುಡ್ಡು ಹಣ ತಗೊಂಡಿದಾರ ಅವಾಗ ಬ್ಯಾಲೆನ್ಸ್ ಏನ್ ಜಮೀನು ಉಳಿಯುತ್ತೆ
ಮಾಡ್ಕೋತೀರಾ?
ರೈತಲ್ಲ.
How much you have paid? 75,000. ಅಲ್ಲ, ಎಷ್ಟು ಕೊಟ್ಟಿರೋದು ಟೋಟಲ್ ಅಮೌಂಟ್?
ಟೋಟಲ್ ಅಮೌಂಟ್ 50,000.
50,000. It is the same parties. They sold it to the same purchaser. So ಅದಿಷ್ಟು, ಅದು 15 ಎಕರೆ. ಅದು 15 ಎಕರೆ. ಪ್ರೈಸ್ ಏನಾಯ್ತು? ಏನಾಯ್ತದು? ಏನಾಯ್ತು ಏನ್ರಿ? Suit is dismissed. What happened? Is that a fact?
I am not aware of that. Here I have produced the sale of the price. It's a registered sale. And ನಾನು ಒಂದು ವರ್ಷ ಮತ್ತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು 1,000 ರೂಪಾಯಿ ಜಾಸ್ತಿಗೆ 1,600 ರೂಪಾಯಿ ಜಾಸ್ತಿ.
But look at the transaction, because it is from 1990, it has went on up to 1993. Same price.
There has been no lapse on my part.
Right.
Now time has passed for the litigation. I am ready to offer more. But
how much?
Nevertheless, as far as what defense has been taken.
You know, there's something which is staring in your face.
But there is sale deed was not available.
That sale deed is also not produced before the trial court.
It's not produced.
It's not produced before the trial court. There's not an evidence at all. It doesn't matter, no.
It is only for the sake of consideration whether the proper sale consideration was proper sale consideration. And here he is a person who has sold whatever he had to purchase the property. And they have dodged him all these years. Everything is same. And the problem is that both agreements were entered into. The agreement is not
Really, the judgment. But this is ಬೇರೆ ಇದ್ದಾರೆ ಇವರು. It was sold to somebody else.
In that case, the purchaser on Abdul Qadir. The client is that is the man of this customer. Yeah, same buyer. But actually, then is the customer. The one thing is about both books are there. On Abdul Qadir sir, the agreement dated would be given in his property recovery of 95,982. But there is then my lord, but everything is same, my lord, transport and amount paid, etc. And then my lord, the findings also say IEC my lord place 133. Page 132 itself my lord has 7. From the statements the other terms of process record whatever the notes going to near the executive 1911 on that 1911-1990 the present case is expected to do. There is a statement by the plaintiff leader that it will be 15,983. On the later capacity agreement is 1911-90. Thereafter it is 25,000. But subject to see that the raise so the amount will go to pay 55,083. Next item is the one that the question of now is what is the amount paid to the plaintiff whether it covers part of it. Over the assumption the plaintiff is to enter into the actually there was no dispute in the earlier agreement. Also what happened? Secondly, the agreement is the who doesn't fight the 1985. The record of the agreement
Tomorrow, come tomorrow, please come tomorrow. ನಾಳೆ ಬರ್ಲಿ ನಾವು
Very rarely.